Committee of Health, Hospital, and Human Services is hereby called to order. Pleasant good morning to the people of the Virgin Islands. I'm honored today to convene my first meeting as the chair of the Committee of Health, Hospitals, and Human Services. Today, we are here at the Fitz E. Lowitz Conference Room at the St. Croix Legislative Building, where we will hear the proposed Behavioral Health and Developmental Disability Act. I assumed leadership of this committee wanted to bring behavioral health to the forefront. Our mental health system has failed the people of the Virgin Islands for years. There have been times when the courts have been close to citing the government for contempt or have them take steps to force the government to actually do better. As a career law enforcement officer, I saw the intersection of mental health with law enforcement. We see it locally and we see it nationally, usually without the best outcomes. As a community, I know that we have work to do to remove the stigma from persons needing behavioral health care and support. And we also have to make services available and accessible to those who need it. This meeting is convened to discuss the proposed legislation that the governor has sent down to the legislature of the Virgin Islands, the Behavioral Health and Developmental Disability Act, and receive testimony from the people in the trenches, to include our nonprofit and community sector, represented today by the St. Croix chapter of the National Alliance of Mental Illness, NAMI, and the Department of Health. There are no easy answers when it comes to behavioral health. I look forward to a robust and honest discussion about where we are and the actions needed to deliver a system that meets our current and future needs. Colleagues and people of the community, this morning I woke up with Dr. Snyder heavy on my spirit. So I'd just like to take some time out to recognize Dr. Roy Lester Snyder. As we near the end of the Black History Month, I want to highlight Dr. Roy Lester Snyder, who served as the Commissioner of Health from 1977 to 1987 and was the 5th elected governor of the United States Virgin Islands. Dr. Snyder is a trailblazer in the territory's healthcare system. As Health Commissioner, he initiated the territory's first kidney transplant and performed the first radical 4/4 amputation for cancer of the humerus. He's a renowned cancer specialist. Dr. Snyder has lived a life of service. He served in the United States Army Medical Corps, where he served in Vietnam. As the Commissioner of Health, where he advocated for the completion of the new health facilities and for the establishment of a board of trustees for each hospital, and as the 5th elected governor of the Virgin Islands. Our territory is richer and better for Dr. Snyder's life and legacy of service. Thank you, Dr. Snyder, for all that you have done for the people of the Virgin Islands. At this time, I want to remind my colleagues and also those that's participating virtually to please turn your cell phones off or on vibrate to avoid any interruptions that it may cause. Also, a little bit of housekeeping. Those individuals that will be participating virtually, again, when you're not speaking, please have your device muted until you're called upon, at which time please remember to turn the voice on and speak accordingly. Madam Clerk, at this time, please call the roll.
Senator Marvin A. Blyden. Senator Blyden, present. Senator Samuel Carrion. Senator Carrion, present. Senator Kenneth L. Gittins. Here. Senator Gittins, present. Senator Alma Francis Heiliger.
Present.
Senator Francis Heiliger, present. Senator Janelle K. Soro. Senator Soro, present. Senator Kurt A. Vialet. Senator Vialet, absent. Senator Novell E. Francis Jr. Senator Francis Jr., present. Mr. Chairman, 6 members present, 1 absent.
Very well. Thank you everyone very much, Madam Clerk. Any correspondence to be read into the record?
Yes, Mr. Chairman.
Please proceed with reading those correspondence.
February 26, 2021, the Honorable Novell E. Francis Jr., Chairperson, Committee on Health, Hospitals, and Human Services, 34th Legislature of the Virgin Islands, 20 Estate Golden Rock, Christiansted, VI, 00820. Dear Senator Francis Jr., I regret to inform you that I will not be able to attend the Committee on Health, Hospitals, and Human Services meeting scheduled for today, Friday, February 26, 2021, due to a previously scheduled engagement. Please forward any pertinent information to my office. Thank you for your kind consideration in this matter, and I apologize for any inconvenience my absence may cause. Respectfully, Kurt Vialet, Senator, 34th Legislature of the Virgin Islands.
Thank you very much, Madam Clerk. Any other correspondence?
Yes, Mr. Chairman.
Please mark Senator VLA as excused and proceed with the reading of the other correspondence.
The Honorable Novell E. Francis Jr., Senator, 34th Legislature of the Virgin Islands, Committee on Health, Hospitals, and Human Services, Capitol Building, Charlotte Amalie, P.O. Box 1690, St. Thomas, Virgin Islands, 00804. Excused absence from committee meeting held on February 26, 2021. Dear Senator Francis, I will not be present at the upcoming meeting for the Committee on Health, Hospitals, and Human Services scheduled for February 26, 2021. I have another matter to attend. In my absence, I appoint Assistant Commissioner Mario Brooks to testify on my behalf and likewise provide representation of the department. If you have any questions, please feel free to contact me. I look forward to engaging in dialogue that creates the opportunity for progress in our department. Regards, Trevor A. Vellinor, Police Commissioner.
Thank you very much, Madam Clerk. Before we go to the reading of the agenda, I just wanted to take a minute to recognize the... Do you have other correspondence? Proceed.
Yes, Mr. Chairman.
Sorry, proceed.
Honorable Novell Francis Jr., Chairman, Committee on Health, Hospitals, and Human Services, 34th Legislature of the Virgin Islands, 3022 Estate Golden Rock, Christiansted, VI, 00820. Committee hearing scheduled for February 26, 2021 at 10 a.m. Dear Senator Francis, thank you for your correspondence of February 5th, 2021, inviting me to attend the hearing to be held by the 34th Legislature's Committee on Health, Hospitals, and Human Services on February 26, 2021 at 10 a.m. to discuss the proposed legislation to enact and establish the first Behavioral Health and Developmental Disability Act. Due to a scheduling conflict, however, I will be unable to attend. The District Court of the Virgin Islands has scheduled an evidentiary hearing in the federal consent decree case governing the St. Thomas Jail for the same date and time at which my staff and I must be present. We would be happy to offer testimony on the proposed legislation on a different date. Sincerely, Winnie Testemark, Director, Bureau of Corrections.
That's it, Madam Clerk?
Yes, Mr. Chairman.
Very well. Thank you very much. At this time, I'd like to recognize the newest employee to my office, 17-year-old UVI student, Ms. Kayla Prentice. If you just stand and be recognized. Welcome aboard. We look forward to your hard work and commitment and your future in politics. Very well. Madam Clerk, at this time, please go ahead and read the today's agenda into the record.
Agenda, Committee on Health, Hospitals, and Human Services hearing, Friday, February 26, 2021. The Committee on Health, Hospitals, and Human Services has scheduled a hearing for Friday, February 26, 2021 at 10 a.m. in the Fritz E. Lowetz Conference Room on St. Croix to receive testimony on the proposed legislation to enact and establish the first Behavioral Health and Developmental Disability Act. Invited testifiers, the Honorable Justa E. Encarnacion, Commissioner, VI Department of Health. The Honorable Kimberly Causey Gomez, Commissioner, VI Department of Human Services. The Honorable Denise N. George Esquire, Attorney General of the U.S. Virgin Islands. The Honorable Harold Willocks, Judge, Superior Court of the Virgin Islands. Mario Brooks, Assistant Commissioner, VI Police Department. Mr. Selvin G. Walwin, Deputy Commissioner, VI Police Department. Ms. Winnie Testemark, Director, VI Bureau of Corrections. Samuel Joseph Esquire, Chief Public Defender, Office of the Territorial Public Defender. Charlotte K. Perel Esquire, President, Virgin Islands Bar Association. Ms. Sherilyn Pogson, President, National Alliance on Mental Illness, NAMI, St. Croix.
Thank you, Madam Clerk. And this month is not only Black History Month, but it's also Heart Month, as well as Dental Month. So I think that having this committee hearing is very timely, as we will be hearing from the health professionals, as well as the human services professional and others in our community. I'm pretty excited about today's hearing because, of course, I believe that there are some positive outcomes to be gained from this particular hearing. It is a work in progress. The legislation is rather fluid, and it gives us an opportunity really to hear from these stakeholders and deliver a package that will be beneficial to all in this community. So I endeavor to really subdue the finger pointing, name calling, the failures of the past, and really work, toward actionable items leading to solution to this age-old situation that we've been having. So at this time, I'd like to go to the testifiers so that we could be able to mic test them as well as the video test, and we'll start off with the Honorable Commissioner Encarnacion.
Good morning, Senator Francis. This is E. Encarnacion, Commissioner of the Virgin Department of Health.
Good morning, Commissioner, and you have some staff that will be there with you as well today?
Yes. Okay. We'll start with Dr. Nicole Craig-Wilson, our Assistant Commissioner.
Okay.
Dr. Sims.
Good morning, everyone.
Deputy Commissioner Renan Steele.
Good morning, everyone.
Deputy Commissioner Janice Valmond.
Good morning, everyone.
Morning.
Assistant Director of Behavioral Health and Alcoholism and Drug Dependency Services, Curtis Callender.
Good morning, everyone.
Director of Maternal and Child Health, Charmaine Mears, Dr. Charmaine Mears. Dr. Mears, voice check.
Good morning, everyone.
Morning.
And of course, our attorney, Dwayne Henry. Attorney Henry, a voice check.
Good morning, everyone, senators and commissioners and everyone else. I'm here.
That's it for us, Senator.
Thank you very much. Before we go to the next testifier, I wanted to take a quick 1-minute recess. We're getting reports that we're not being heard on the live stream, so we'll just try to address that real quickly so that we could have full inclusion in this hearing today. The Committee of Health, Hospital, and Human Services stands in recess for 1 minute.
Question, would I be able to do the mic check?
The Committee of Health, Hospital, and Human Services is out of recess at this time. We're still having a little bit of issues with our live stream, but nonetheless, we'll go ahead and proceed in the essence of time. Honorable Commissioner Gomez, Kazi Gomez, you're recognized for your mic check.
Good morning, Chairman, Honorable Senator Nobel Francis. Mic check, you can hear me?
We can, loud and clear. Can you introduce your staff real quick as well, please?
I would be happy to do so. I have two Assistant Commissioners with me today. I have Assistant Commissioner Carla Benjamin. Mic check, Carla.
Good morning.
Morning, morning,
And Mikkel Reimer Brown.
Good morning.
morning. You're loud and clear. Thank you. Next, we'll go to the Honorable Attorney General, Attorney Denise George. You unmute, AG.
Good morning.
Morning.
Good morning to everyone. I'm Attorney General Denise George, and I'm here. I don't have any staff members with me today. There's one that may be able to come, but they are tied up in a court matter. But I will be here today presenting.
Very well. Good morning. You're loud and clear. Thank you.
Good.
Next, we'll go to the Honorable Harold Willox, Judge of the Supreme Court of the Virgin Islands.
Good morning.
Morning, Your Honor. You're loud and clear.
I apologize. I just recessed right quick, so if I'm loud and clear, I ask to be excused, and I'll return shortly.
Certainly, Your Honor. We're hearing you loud and clear. At this time, we'll go to the Assistant Commissioner of the Virgin Islands Police Department, Maria Brooks.
Yes, good morning, Mr. Senator, and all in the listening audience. This is a reader check. Along with me today is Dr. Selvin G. Warren, the Deputy Commissioner of Operations. Dr. Warren.
Good morning.
Good morning. Morning. You're both Lincoln Charles, loud and clear. Thank you very much. Next, we'll go to Samuel Joseph, Chief Public Defender.
Good morning, Senator. Good morning, all testifiers.
Morning, Chief. You're loud and clear. And next, we'll go to the President of the Virgin Islands Bar Association, Attorney Perrell.
Good morning, everyone. Charlotte Perrell, thank you for inviting us. We look forward to the session.
Very well. Thank you. And next, we'll go to the President of the National Alliance of Mental Illness, NAMI, Ms. Pogson.
Hello, good morning, everyone.
Good morning. Thank you for joining us. Very well. I think we're all set, and we'll go in that order in terms of the testimony. But before we do that, Senator Gittins, you're recognized for a motion.
Thank you, Mr. Chair. Mr. Chair, I motion requesting a 1 minute recess. 1 minute.
Very well. The Committee of Health, Hospital, and Human Services stand in recess for 1 minute. We're out of recess at this time. Senator Gittens, you're recognized for your motion.
Thank you, Mr. Chair. Good morning to all. Mr. Chair, I move that to add Bill number 34, that's 0017 to the end of the agenda, an act making appropriations from the balance of funds appropriated in Act number 7697, Section 2, Paragraph 1, and $400,000 from the Community Facilities Trust account to the Virgin Islands Government Hospitals and Health Facilities Corporation for the acquisition of plot number 7, Estate Diamond Ruby St. Croix, Virgin Islands, for reconstruction and expansion of the Governor Juan Francisco Louis Hospital and Medical Center. I so move.
Motion properly made by Senator Gittens, seconded by Senator Sorrell. Hearing no objection, so ordered.
Thank you.
At this time, we'll begin to take a testimony, and we'll go to Commissioner Encarnacion for her testimony at this time.
Thank you, Senator Francis. Good morning, Honorable Noel E. Francis, Jr., Chairman of the Committee on Health, Hospitals, and Human Services, Honorable Marvin A. Blyden, Vice Chair, committee members, all other members of the 34th Legislature of the Virgin Islands of the United States, and the listening and viewing audience. I am Justa E. Encarnacion, Commissioner of the Virgin Islands Department of Health. I have here with me today Dr. Nicole Cragwell-Sims, Assistant Commissioner, Renan Steele, Deputy Commissioner of Public Health Services with the oversight of behavioral health, alcoholism, and drug dependency services, Dr. Janice Valmont, Deputy Commissioner, Health Promotion and Disease Prevention, Curtis Callender, Assistant Director of Behavioral Health, Alcoholism, and Drug Dependency Services, and Dr. Charmaine Mayers, Director of Maternal Child Health. We also have with us today Attorney Henry, Chief Legal Counsel for the Virgin Islands Department of Health. We are here today to provide testimony on the establishment of the first Behavioral Health and Developmental Disability Act. The purpose of the Behavioral Health and Developmental Disability Act, proposed by the Honorable Governor Albert Bryan Jr., is to establish a coordinated and comprehensive system of care for persons with behavioral health conditions and developmental disabilities or neurodevelopmental disorders who reside in the United States Virgin Islands. The bill serves to expand behavioral health services, thereby eliminating gaps in the continuum of care by creating residential psychiatric services, community-based crisis services, and residential outpatients associated recovery support services, and serves to amend Title 19, Part 5, Chapter 45 of the Virgin Islands Code, Mental Health. The establishment of these services shall ensure that the clinical behavioral health needs of the population are able to be met within the territory. The topic of behavioral health and the corresponding community needs in respect to this arena has been a major topic of concern for several years. While there have been significant steps to assist in remedying the issue, example, interagency collaborations, including Department of Health, Department of Human Services, the Virgin Islands Police Department, Virgin Islands Fire Services, etc., which has resulted in the relocation and housing of homeless individuals with behavioral health diagnoses. There remains much work to be done. This bill provides a framework to continue the work that has already been initiated. The theme of the collaboration to address behavioral health and disability concerns is carried throughout the bill, as evidenced by the establishment of bodies as the Interdepartmental Coordinating Committee, Citizens Advisory Council, and the Community Services Network. This is paramount as there are several categories of needs that those who with chronic behavioral health and disability challenges typically possess, which span beyond the services capable of being provided by the Department of Health. Essential to the discussion surrounding the Behavioral Health and Developmental Disability Act is the inclusion of those affected by developmental disabilities or neurodevelopmental disorders. Of additional importance is the necessity of ensuring that the language of the bill appropriately reflects the current jargon of the field. As such, the Department of Health proposes a name change of division to the Division of Behavioral Health and Neurodevelopmental Disorders. There is also an additional need to change the term alcohol and drug dependency to substance use disorder throughout the bill to reflect the language changes that occurred as a result of the publication of the Diagnostic and Statistical Manual, 5th edition, DSM-V. It would be also appropriate to discontinue the usage of a terminology such as addict and abuser, as less stigma-inducing and biased terms should be utilized. Rather, more neuro terminology such as individuals, persons living with a substance use disorder, which implies no judgment or morality and keeps the focus on the symptoms. This should be the standard. The department further recommends the removal of section 1001, subsection A, number 15, and replace the term developmental disability and its definition with number 31, neurodevelopmental disorder. For the purpose of this chapter, neurodevelopmental disorder is a condition where the development of the central nervous system, namely the brain, is abnormal in some form or fashion. More specifically, this is taken to mean that such a disorder affects people as they develop neurological functions that influence emotional expression and understanding, memory, impulse control, and learning, among other characteristics. Signs and symptoms include those that revolve around sociability, such as inability to maintain eye contact during social interactions, a failure to respond to one's name, and a lack of facial expressions. Issues pertaining to emotions such as mood swings, an irritable temper, and an easily frustrated state of mind. Learning-based concerns like problems reading or spelling, dyslexia, difficulty speaking the repetition of words without really understanding how to use them, and the inability to properly plan, prioritize, manage time, and focus on tasks. Movement and impulse control related issues such as restlessness, issues coordinating movement, which can come off as clumsiness, and repetitive motions like rocking or hand flapping. Of course, some of the examples given above can be part or more of more than one category. For example, difficulty understanding questions, which would undoubtedly affect both learning and general socialization. The department agrees that the Commissioner of Health should be responsible for providing technical assistance for program development, promoting effective coordination with the Department of Health, Department of Education, Bureau of Corrections, Police Department, the Judiciary System, the Department of Human Services, and other relevant departments and agencies. The technical assistance provided by the Commissioner of Health would include ideas and resources to develop new resources, to improve the availability and accessibility of comprehensive community support services to persons who suffer from behavioral health challenges, mental health disorders, or those with disabilities. The Department of Health, however, does have some recommendations upon review of to strengthen the bill. These and other detailed comments appear in a red line copy of the bill attached to this testimony, as well as detailed comments in this testimony. In section 1002, addressing Commissioner's duties regarding community behavioral health services, the following changes are proposed. Section 1002, paragraph A and B, subsection B, paragraph 2, 4. We recommend recommendations for interdepartmental behavioral health assessment and transition team, for example, project led by Virginia's Department of Education, Division of Special Needs Education. A, develop school-based behavioral health assessment and transition team inclusive of Department of Health, Department of Education, and Department of Human Services representation, composed of school and community mental health professionals, conducting an assessment of needs and existing resources, clarifying roles and responsibilities and level of intervention. Adopt an evidence-based psychosocial screening tool designed to identify cognitive, socio, emotional, and behavioral challenges to identify needs. Identifying needs will determine which tier service students need. Tier 1, Department of Education design prevention delivered within the scope of educational programming. Tier 2, intervention developed by Department of Education with the assistance and assessment of both the Department of Health and Departments of Health and Human Services. Focus on students with mild or emerging mental health needs of a social, emotional, or behavioral nature. Tier 3, the assessment team, Health, Human Services, and Education will meet quarterly to determine needed intervention for students with more advanced mental health needs of a social, emotional, or behavioral nature. Regarding Section 10.7, Behavioral Health Training, after subsection B, law enforcement training, we recommend adding local law enforcement as part of a crisis intervention team is a crucial aspect to developing the territory's capacity to respond to behavioral health related emergencies. We recommend adding within the first year, the Virgin Islands Police Department in conjunction with the Division of Behavioral Health shall train, and we recommend adding all new hires and all law enforcement officers and insert biennially on how to address calls involving behavioral or mental health crisis. We recommend inserting by participating in nonviolent crisis intervention training or CPI-CIT. CIT training emphasizes a partnership between law enforcement, the behavioral health treatment system, behavioral health advocacy groups, and consumer behavioral health services and their families. Subsection C, recommend to add school monitors and add interdepartmental behavioral health assessment and transition team shall implement a comprehensive school-based behavioral health framework through a health literacy curriculum into health education, develop effective school-based emotional and social learning focused on behavioral health literacy intervention for adolescents relative to general education, reducing stigma and treatment options. The Department of Education will collect ongoing data regarding the prevalence of behavioral health challenges within the territory school system to help identify most pressing areas of focus. Regarding sections 1018 to 1040, we concur with the repeal of Chapter 31, Section 716, 717, 726, and 746. We insert that all other sections under this chapter remain in force and are not in conflict with the proposed legislation. Regarding Section 1037, records of persons who suffer from behavioral, mental, or developmental health disorders and alcoholism, intoxication, and drug dependency. The section does not address length of record storage. Thus, we suggest subsection C, records regarding persons who suffer from behavioral health disorders, substance use disorders, and neurodevelopment disorders shall be kept for a period of 7 years. Regarding Section 1041, establishment of a behavioral health, mental health, developmental disability, alcohol or substance abuse treatment facility. Paragraph A, we recommend, paragraph A, subsection A, we recommend adding, we clearly identify separation of population based on treatment needs. Following, the Governor of the Virgin Islands shall establish at least one behavioral health, mental health, developmental disability, alcohol, or substance abuse treatment facility in the Virgin Islands. The current proposal does not include a medical detox center. We feel that these services should also be included at the treatment facility. Paragraph subsection C says, the budget for the facility shall fall under that of the executive branch in a line item, but pursuant to Chapter 32 of the VI Code, Section 517, subsection C, the following portions of the Casino Revenue Fund will be designated and fund the establishment and services of the behavioral health, mental health, developmental disability, alcohol, or substance abuse treatment facility. 15% to hospitals and health, 1% for gambling, education, and education programs, 5% to the University of the Virgin Islands. This single source of funding will not be sufficient for the services to be rendered. Additional funding will need to be appropriated to facilitate the construction of such a facility. Regarding Section 1092, authority and responsibilities of the Commissioner of Health, institutional custody, aftercare, maximum period of civil commitment, credit towards sentence, an individual who is conditionally released from institutional custodial custody shall, while unreleased, remain in the legal custody of the Commissioner of Health and shall report for such supervised aftercare as defined or determined by Section subsection A1 of this section, as the Commissioner of Health directs. She shall be subject to home visits and to such physical examination and reasonable regulation of his conduct as the supervisory aftercare authority establishes, subject to approval of the Commissioner of Health. Paragraph 1, the Commissioner of Health at any time may order in writing conditionally release individual to return for institutional treatment. Subsection D, if it is determined that an individual has returned to the use of narcotic drugs or alcohol, the Commissioner of Health shall inform the court of the condition under which the return occurred and make a recommendation as to whether treatment shall be continued. In order to provide the supervised aftercare, a team of intensive case managers will be needed. This responsibility should be determined by a review committee and or treatment team inclusive of a treatment physician. Regarding Section 1094, delegation of functions by Commissioner of Health, use of federal, territorial, state, and private facilities. Subsection B, insert after the Commissioner of Health is authorized in accordance with the procurement policies of the government of the Virgin Islands as stipulated by the Department of Property and Procurement and the procurement laws and rules. Regarding subsection 1101, period of commitment to care and custody of the Commissioner of Health, patient subject to post-hospitalization program released from confinement. After subsection A, any patient committed to the care and custody of the Commissioner of Health pursuant to section 1100 of this subchapter shall be committed for a period of up to 6 months in the judgment of the court and shall be subject to such post-hospitalization program as may be established pursuant to section 1102 of this subchapter. Except that such patient may be released from confinement by the Commissioner of Health, we recommend adding guided by the attending physician and treatment team at any time prior to the expiration of such 6-month period if the Commissioner of Health, attending physician, and treatment team determines and certifies in writing that the patient is in recovery. Treatment team will review evaluations every 3 months. Regarding section 1102, released from confinement, notice and return to commitment court, placing patient under care and custody of Commissioner of Health for post-hospitalization treatment, recommendation of Commissioner of Health. Subsection B, the court, after considering the recommendation of the Commissioner of Health with respect to post-hospitalization treatment for any such patient so returned, may place such patient under the care and custody of the Commissioner of Health for up to 3-year period immediately following the patient's release from treatment and supervision under such post-hospitalization program as the Commissioner of Health may direct. Care for individuals should be individualized and subject to treatment team review recommendations. Evaluation should be conducted no later than every 6 months. Regarding section 1112 to section 1113, telehealth and licensing restrictions are also integral to adequate covering the behavioral health needs of our population, particularly given the current shortage of qualified mental health practitioners in the territory. By ensuring that we are able to increase access to practitioners and reduce barriers of compliance to treatment, the Department of Health is in support of ensuring that we are able to utilize appropriately licensed psychologists, psychiatrists, mental health or professional counselors, clinical social workers, marriage and family therapists, physician assistants, etc., to meet the medical and social economic needs of our populace. Regarding section 1122, subsection A, education of children with intellectual disabilities, the Department of Health recommends replacing current language to read, the establishment of a treatment team focused on educational implementation for children with disabilities led by the Department of Education, inclusive of the Department of Health and Human Services. Program development proposed by this team will maintain present and support future discretionary grant funding for applicable personnel development, technical assistance, technology, parent educator training, and information centers. Further, all systematic change benefiting children with disabilities will require the involvement of this team in collaboration with parents, other individuals with disabilities, and their families. teachers, and other service providers, along with any interested individuals and organizations to develop and implement comprehensive strategies that improve educational platform for children with disabilities. The reason for this recommended change is because it is a process cannot be the sole responsibility of one department of the Department of Health. The Individuals with Disability Education Act, IDA, guidelines, etc., should be also utilized as the framework for the development said educational program. Budget. In order to fully support the expansion of the behavioral health services within the inclusion of neurodevelopmental disorders, the development of the Crisis Intervention Team, or CIT, and wraparound services to support the needs of the population, an increase in funding is essential. This would increase the department's current supplemental budget request by $5,895,035. A line item supplemental budget is attached to the testimony. In conclusion, the review of the Behavioral Health and Developmental Disability Act proves the value on decision made and the magnitude of the impact on the population served. The Department of Health fully understands the critical role that quality behavioral health services play and strive to make changes to our system that positively influence the lives of our residents. The Department of Health will continue to collaborate with our sister agencies in refining strategies to meet the expectations of this bill. We ask for your indulgence as we proceed with the questions and answers of a bill that is currently in a fluid state and will take a few sessions to finalize. Thank you, Governor Albert Bryan Jr., Chief of Staff Carl Knight, Dr. Julia Sheen, the Governor's Policy Advisor on Health and Human Services, and of course, my Behavioral Health, Alcoholism, and Drug Dependency Services team and colleagues here today for all your hard work in writing, researching, and editing the Act. To our Department of Health family, thank you for your continued commitment to the people of the Virgin Islands. Senator Francis, the Department of Health will continue to uphold our mission. We are committed to reducing health risk, increasing access to quality health care, and enforcing health standards, and will continue to collaborate efforts with the members of the 34th Legislature. Senators, this concludes our testimony. Thank you for your support of our efforts as we strive to improve the Department of Health services to our community. I thank you for allowing us to provide this testimony on the first Behavioral Health and Developmental Disability Act, and we are here to respond to any questions that the committee may have. Thank you, sir.
Thank you very much, Commissioner Encarnacion. Next, we'll go to Commissioner Kazi Gomez, and you're recognized for your testimony.
Good morning, Honorable Senator and Committee on Health, Hospitals, and Human Services Chair Novell E. Francis Jr., Vice Chair Honorable Senator Marvin A. Blyden, members of the committee, and other members of the 34th Legislature present, and to the listening and viewing audiences. I'm Kimberly Kazi Gomez, Commissioner of the Virgin Islands Department of Human Services. Joining me today are Assistant Commissioners Carla Benjamin and Mikkel Reimer Brown. We are honored to appear before this committee to provide testimony on the proposed legislation to enact and establish the first Behavioral Health and Developmental Disability Act proposed by Honorable Governor Albert Bryan Jr., which seeks to restructure, reclassify, and address behavioral health services through an intentional coordination of departments and agencies throughout the territory. The main purpose will comprehensively improve the services and treatment of individuals who are diagnosed with behavioral health challenges, developmental disabilities, and substance use disorders. The Virgin Islands Department of Human Services intersects daily in key areas with government agencies like the Virgin Islands Departments of Health, Justice, Police, and Education, as well as a host of for-profit and nonprofit community-based agencies. The proposed Interdepartmental Coordinating Committee is a strength of the bill as it seeks to design and develop and implement a comprehensive system composed of governmental and private agencies to aid in the prevention and effective intervention approaches to meet the behavioral health needs of the territory. DHS embraces the opportunity to be a member of the committee. Title III, Section 431 of the Virgin Islands Code, entitled Powers and Duties of Department, paragraph A, states that DHS shall establish, administer, and coordinate and supervise all publicly financed services and programs for youth, children, handicapped, elderly, and low-income adults and families. And in paragraph C, the department, through the commissioner, shall identify, assess, coordinate, and eliminate conflict, duplication, and inconsistencies among programs affecting youth, children, handicapped, elderly, and low-income adults and families, shall promote efficiency among such programs, and shall seek to coordinate to maximize extent feasible such programs with other federal, local, or private programs affecting such persons. Title III, Section 432, entitled Department as State Agency, goes a step further and in paragraph A designates DHS as a state agency for all programs pertaining to youth, children, handicapped, elderly, and low-income adults and families whenever such designation is required by federal law for the purpose of participating in federal programs. In fulfillment of our legal mandates, DHS provides a facet of many of the services referenced in this legislation through its programming. The Office of Intake and Emergency Services, during intake and investigation of child abuse and neglect matters and service provision, provides crisis intervention services, as well as referral services to public and private providers of counseling and other psychological services as needed. The Division of Children and Family Services, through its protective and foster care units, arranges for services to address mental, behavioral, and emotional irregularities through private provider agreements with local professional behavioral health professionals. Our Office of Child Care and Regulatory Services and our Office of Head Start make possible environments where high-quality early childhood and education can take place. Programs such as Head Start, designating a percentage of their enrollment for children with special needs and disabilities. Through the Head Start program, children transition by choice from the Early Head Start program and from the Department of Health's Maternal Child Health 0 to 3 programs Part C services to the Head Start program, where they receive Part B services. These children have already been identified as needing special services and continue to receive those services, as well as other special educational supports. Our Division of Intervention and Prevention Services, formerly known as Juvenile Justice Services, intervenes with families in which children and youth are presenting outstanding behavioral problems that at times result in young and our youth being remanded to the Youth Rehabilitation Center by the Superior Court of the Virgin Islands. In most of these cases, DHS must arrange for services to address behavioral issues caused by trauma that the children and our youth have experienced, and at times due to physiological issues that result in outstanding behavioral challenges, mental health diagnosis, and at times psychiatric episodes. When the indicated behavioral issues surpass DHS's internal capacity as well as DHS's ability to engage private service providers, DHS assesses and services of residential facilities with which we contract for services to children and youth with behavioral and developmental challenges who present a range of behaviors and diagnoses from autism spectrum disorder to emotional disturbance to juvenile sexually deviant disorders, conduct disorders, individual developmental disabilities, etc. In addition to the facilities that provide services to the previous referenced children and youth with outstanding behavioral issues, a tri-agency agreement was enacted in 2005 that allows the Department of Education to refer youth who they determine cannot be educated due to a need for services not available in the territory to DHS to be placed outside of the territory in residential facilities that address their behavioral and educational needs. Our Office of Residential and Interstate Compact Affairs also manages contracts with residential facilities that house medically fragile and low-functioning adults and some elderly, not including our local homes for the aged. The only categories of our clients across the lifespan that DHS has no legal charge nor internal or external capacity to provide services for are individuals with acute mental and behavioral health presentations and criminal and/or forensic involved behavior issues. We do not contract with forensic facilities or facilities for the criminally insane. Individuals who primarily present a problem as a mental health issue are referred to the Department of Health, including our children. Another important program role which will assist in expanding and improving the behavioral health service delivery system across different populations is our Virgin Islands Department of Human Services Medicaid program. States and territories are moving aggressively to rebalance their Medicaid service delivery systems to move away from a heavy reliance on institutional care and more towards expanded home and community-based programs that are more cost efficient. They provide greater consumer satisfaction and have the ability to expand capacity to meet the growing need for behavioral health services, to include treatment, intensive case management, safe and affordable housing with support services, and other assistance needed for affected persons to help them effectively manage their behavioral health challenges. The Virgin Islands Medicaid and Children's Health Insurance Program, otherwise known as CHIP, currently covers the following behavioral health services under our VI state plan: inpatient acute care for all ages, hospital outpatient care, behavioral health clinics, community medical providers to include psychiatrists, psychologists, and advanced practice registered nurses, prescription drugs, psychiatric residential treatment facilities, or PRTFs, for beneficiaries under the age of 21, noting that each facility must be accredited by Joint Commission on Accreditation of Healthcare Organizations, comprehensive outpatient rehabilitation facilities, or other federally recognized accrediting bodies. It should also be noted, however, that under the Medicaid program, federal financial participation is not available for individuals between the ages of 22 and 65 who reside in an institution for the treatment of mental diseases. Federal regulations of 42 CFR Section 4351010 defined an institution for the treatment of mental disease as a facility established and maintained primarily for the care and treatment of individuals with mental diseases, whether or not it is licensed as such. This is an exception to the IMD rule where Medicaid covers residential behavioral health treatment if the facility has less than 16 beds. It is the exception which the Virgin Islands government, in collaboration with private for-profit and nonprofit agencies, can expand into group homes, meeting the under 16 bed rule for behavioral health residential treatment. As the Virgin Islands strategically moves forward in rebalancing our Medicaid service delivery system and away from the heavy reliance on institutional care, we also have begun taking the necessary steps to add community-based long-term support services. Our current Medicaid state plan covers home health services and will soon launch the personal care services as covered under Medicaid services in the territory. I take this opportunity to commend the bill for including the important federally mandated Developmental Disabilities Council in Section 1115 AI, the applicable department of the government of the Virgin Islands authorized to ensure the Developmental Disabilities Council is enacted and supported in the Virgin Islands Department of Human Services. The council is fully constituted and is operated with members appointed by the governor of the Virgin Islands in alignment with the Developmental Disabilities Assistance and Bill of Rights Act of 2000. It should be noted that the Virgin Islands Developmental Disabilities Council is administered by an executive committee, which is designated from the membership of the council. The federal funding to operate the Developmental Disabilities Council is awarded by the Administration on Intellectual and Developmental Disabilities to DHS as a designated state agency for the U.S. Virgin Islands. The federal funding is awarded under the DHS Social Services Block Grant and is dispersed to the Developmental Disabilities Council. As a DSA, DHS currently serves as a fiduciary of the funding for the AIDD. Another state council which is fully constituted is the Virgin Islands Statewide Independent Living Council, or SILC. In 2020, DHS coordinated with the Office of the Governor to reactivate the VI SILC after it was dormant for at least 3 years. The Honorable Governor Bryan Jr. appointed members to the council in accordance with the federal mandates of 29 U.S. Code Section 796. The 6 major responsibilities are to develop a state plan for independent living, monitor, review, and evaluate the implementation of the state plan, meet regularly and ensure that such meetings of the SILC are open to the public, submit all federal reports, and of course, coordinate activities with other entities in the territory that provide services like or complementary to independent living services. DHS receives a small federal grant annually to support the activities of the VI SILC. We especially welcome this chance to have an open and honest discussion with you, as many of the same clients who receive services by the Departments of Health, Education, and Human Services may directly be impacted by this legislation, as they receive direct long-term services from the Department of Human Services and are in many cases wards of DHS. It is a time for the territory to leverage its resources to promote the health, well-being, and stability while streamlining eligibility for services and expanding access to behavioral health services across each unique special population. This may be accompanied or accomplished by maximizing the cooperation between its service-providing agencies, so our vulnerable populations, such as those with mental illnesses and the homeless, are served in humane and effective ways. We're in full support of the concept of the proposed legislation. However, welcome further in-depth discussions what may strengthen it to ensure the existing gaps are being addressed. Some of the proposed language may create an unnecessary overreach for Department of Health in areas that are currently working and can stimulate the effectiveness of existing processes that address social and emotional issues of clients that do not rise to the level of acute presentation and does not require the Department of Health's intervention. We've reviewed the original bill and have made recommended specific changes to the lead agency, Department of Health, which is reflected in the revised submission of the legislation. We certainly agree with the concept of the governor's proposed bill to enact and establish the Behavioral Health and Disability Act and appreciate a comprehensive wraparound services strategy to care for individuals facing behavioral health and developmental disability challenges. The Department of Human Services is a strong partner in providing direct and essential services to our community, and we welcome further discussion to strengthen the legislation and develop a continuum of care to effectively address the behavioral health and developmental disability issues faced in our Virgin Islands community. A special thank you to the Honorable Governor Albert Bryan and Chief of Staff Carl Knight and his team for bringing this important legislation forward, and our DHS professionals who continue to provide frontline and direct services to our community each and every day. And of course, Department of Health for taking the lead in behavioral health. Thank you again, Chairman Francis, as we stand ready to answer questions at the appropriate time.
Thank you very much, Commissioner Kazi Gomez. Next, we'll go to the Attorney General of the Virgin Islands, Attorney Denise George. You're recognized for your testimony.
Thank you. Thank you. Good morning again, Chairman Francis, senators, legislative staff, and to those of you listening today. My name is Denise George, and I am the Attorney General of the U.S. Virgin Islands. I'm honored to present testimony on the proposed measure which has been advanced by the Governor of the Virgin Islands, Honorable Albert Bryan Jr. The purpose of today's measure is to provide the first ever territorial behavioral health and developmental disability act. Its intent is to solidify and consolidate existing law, create new law, and repeal outdated ones that relate to behavioral and mental health developmental disabilities, substance abuse issues, and the like. The Office of the Attorney General salutes Governor Bryan in this monumental and prodigious undertaking. Despite the fact that experts are with us today to discuss some of these matters, such as mental health and substance abuse, it doesn't take an expert to realize that many Virgin Islanders have and continue to suffer from mental health disorders, drug and alcohol dependency, and other related troubles. In speaking with the governor, his staff, and other executive branch stakeholders, it is clear that this bill has various areas that can be improved upon. Yet today's discussion can be the impetus to usher in a new system of real and lasting solutions and change for these problems. It can be the beginning of a better and brighter future for many of our residents that struggle with these issues. In his inaugural address, President John F. Kennedy quoted the age-old Chinese proverb that a journey of 1,000 miles must begin with a single step. Today, we are taking the first step of perhaps many for such needed and long overdue comprehensive mental, behavioral, and substance abuse reform. As other testifiers express their thoughts and suggestions, I too would like to offer a few recommendations to strengthen this proposed act. First, I would recommend that proposed section 1015 relating to the creation of a Citizens Advisory Council include language that would address how many members would constitute a quorum, as well as the issue of holdovers. In other words, once a member's 2-year term ends, may they continue to serve until a replacement has been found, or is the 2-year term firm? This may seem like an inconsequential request for such a bill that is so broad and expansive. However, this issue is one that has plagued the Office of the Attorney General in the past regarding legal issues that arise because of the uncertainty of these measures. I would also suggest looking at proposed sections 1020 and 1021 and compare them with 19 VIC sections 722 and 723. For all intents and purposes, they mirror each other. These sections, of course, relate to emergency commitments and involuntary commitments. One of the wonderful purposes behind today's measure is that it seeks to consolidate the laws. It would be counterproductive to enact sections 1020 and 1021 without repealing the current sections. Any differences between the proposed statutes and the existing statutes should be resolved and rolled into one. The next recommendation relates to proposed section 1039, which is entitled Criminal Laws Limitations. Subpart A states, the legislature of the Virgin Islands may not adopt or enforce local law, ordinance, resolution, or rules having the force of law that includes being mentally disturbed, drinking, being a common drunkard, being found in an intoxicated condition, or being found under the influence of drugs as a criminal offense. This should be reworded to accurately reflect the intent of the drafters. First, whatever this legislature adopts or does not adopt into law is not binding on their successors. Second, the language is somewhat confusing in that it is the executive branch's responsibility to enforce the law. If the intent is to prevent the police from arresting and taking to jail individuals due merely to a person's mental impairment due to either illness or substance abuse, then that should be so stated. Of course, it must be remembered that often when someone is suffering from one of these conditions, they're also committing other underlying criminal offenses. So it should be made clear that the police are not prohibited from arresting those individuals in those situations. In short, this proposed section should be reworded, and at the appropriate time, the Attorney General, the Office of the Attorney General, we can assist in that drafting. Further, proposed section 1025A is also unclear. It states if a law enforcement officer, which includes members of the Virgin Islands Police Department, Superior Court Marshals, or territorial peace officers, have probable cause to believe that a person may be suffering from a behavioral health challenge, mental health disorder, developmental disability, or alcohol and drug dependency, and that due to that condition, the person represents a threat of harm to that person or other persons or to property, the law enforcement officer shall immediately take the person into protective custody and deliver the person immediately for examination by a medical practitioner to a hospital or appropriate behavioral health treatment facility or examination. In essence, this is directing officers, peace officers, to take a person they believe may be suffering from some mental health or substance abuse issue to the hospital or other health facility. The problem is that this is based on probable cause that they believe exists. However, ultimately, it is the judge or magistrate that must determine whether probable cause exists. So at some point in the process, a judge or magistrate would have to become involved. The next recommendation rests in proposed section 1021E. It states, at the time of certifying the person suffering from behavioral, mental, or developmental health disorders, or a drug or alcohol dependency challenges in accordance with the provision of the subsections of this section, the judge shall establish by endorsement on the warrant the date and time for trial. The trial of any action under the provisions of this chapter shall be in the Superior Court without a jury unless counsel for the person suffering from behavioral, mental, or developmental health disorders and or drug or alcohol dependency request a jury. The Attorney General's office further says the Attorney General's office shall represent the people in these matters. Ultimately, the attorney, that is the attorney of the defendant, must abide by the client's wishes, even if it is not in their best interest. Thus, the recommendation would be to add that the individual also has the right to request a trial by jury through his or her counsel instead of the counsel requesting it alone. Further, we recommend changes to a number of proposed sections that inappropriately place the responsibility of the custody and care of mentally ill individuals upon the Attorney General. Those sections include 1076, which states, A, if after the hearing, the court finds by a preponderance of evidence that the person is presently suffering from a behavioral health challenge, mental disease, or defect, and is in need of custody for care or treatment in a suitable facility, the court shall commit the person to the custody of the Attorney General. B, the Attorney General shall hospitalize the person for treatment in a suitable facility until he or she is no longer in need of such custody for care or treatment, or until the expiration of the sentence of imprisonment, whichever occurs earlier. Proposed sections 1081 and 1087 are very similar in language and share the same theme as proposed in 1076, in that the individual in question is initially placed in the custody of the Attorney General's office. A portion of proposed section 1081 states, if after the hearing, the court finds by clear and convincing evidence that the person is presently suffering from a behavioral health challenge, mental disease, or defect, as a result of which his release would create a risk of bodily injury to another person or serious damage to the property of another, the court shall commit the person to the custody of the Attorney General. It further states that the Attorney General shall release the person to the Bureau of Corrections or to the appropriate official of the state in which the person is domiciled or which was tried, if such state will assume responsibility for his custody, care, and treatment. The Attorney General shall make all reasonable efforts to cause such a state to assume such responsibility. It would be improper and impractical and perhaps unlawful for any of these individuals to be placed in the Attorney General's custody, even temporarily. There are several reasons for this. First, the Office of the Attorney General is comprised of mainly of lawyers and legal support staff. Our expertise is the law, not drug or alcohol addiction, not incarceration and holding procedures, and certainly not mental health issues and disorders. Put another way, the staff of the Office of the Attorney General does not have the requisite expertise to care for or house these individuals or to determine where they should be housed. Second, since the Attorney General, through the Assistant Attorneys General, represents the people of the Virgin Islands in criminal matters, and the government of the Virgin Islands, including all of its agencies in all legal matters, it would be highly inappropriate for the Office of the Attorney General to handle house, or care for individual criminal defendants or other persons that may have legal adverse interests and rights that would have to be protected. This would expose our staff to possibly becoming witnesses in their own cases, as well as create a myriad of other unethical predicaments. Also, the Assistant Attorneys General are protected from professional liability in their legal representation of the government. However, being placed in the position of custodians of the mentally ill would unreasonably expose our attorneys and staff to professional and individual liability that would not or could not be protected. We do not even currently have positions in which this would be considered within an employee's scope of employment. Finally, the Office of the Attorney General does not have the infrastructure to house or care for these individuals, even temporarily. These individuals should be immediately placed in the custody of the Bureau of Corrections, the Department of Health, Department of Human Services, or some other entity that is better equipped than the Attorney General's office for such matters, and in which the department heads have the expertise in mental health care. The last area I would bring your attention today is proposed subchapter 9, which is entitled Civil Commitment of Persons Not Charged with Any Criminal Offense. The purpose of these sections is to provide a mechanism for an alcoholic or addict to receive treatment, or for someone else to petition that individual, or that the individual be required to undergo treatment. As a preliminary matter, some of these sections overlap with the content of 19 VIC section 721, entitled Treatment and Services for Mentally Disturbed, Intoxicated, or Drug-Dependent Persons. So the differences should be reconciled, and then section 721 should be repealed if that is done. However, the real crux of the problem appears in proposed section 1097. It states, except as otherwise provided in section 1106 of this subchapter, whenever any narcotic addict or individual who suffers from AUD or drug dependency desires to obtain treatment for their addiction, or whenever a related individual has reason to believe that any person is a narcotic addict, alcoholic, or drug dependent, such addict or related individual may file a petition with the Attorney General requesting that such addict or person be admitted to a hospital or public and private treatment facility for services or the treatment of their addiction. It also says the Attorney General is also authorized to permit treatment of such addicts under this subchapter to the behavioral health, mental health, developmental disability, alcohol, or substance abuse treatment facility, and to any commitment applicable to the patient based on their condition that is authorized under Chapter 45. First, if a person believes that they have an alcohol or drug problem, they should not have to petition the Attorney General for help. Second, as stated earlier, the Office of the Attorney General specializes in the law, not mental health or substance abuse. The same proposed statute continues by saying, the Attorney General shall consider and review petitions for confinement to determine whether there is reasonable cause to believe that the person named in such petition is a narcotic addict or an individual who suffers from alcoholism or drug dependency. If the Attorney General affirms that that person named in such a petition is a narcotic addict or individual who suffers from alcoholism or drug dependency, and appropriate facilities are not available to such persons, then the Attorney General shall file a petition with the United States District Court or Superior Court to commit such person to a hospital for service and treatment as provided in this subchapter, or treatment as provided and is applicable and approved pursuant to Chapter 45 of this title and Section 1020. Again, the staff of the Office of the Attorney General know and understand probable cause, reasonable suspicion, and various other legal standards. They have not been trained, or I should say, we have not been trained to recognize and to know reasonable cause to believe that, in quotes, a particular person may or may not be an addict or an alcoholic. This is as simple and blunt as I can be. The Office of the Attorney General has no business assessing petitions alleging drug or alcohol dependency. This is best left to the medical experts who specialize in such matters. The Attorney General is, however, always available to provide legal representation to public health agencies and officials who do have the expertise. Today, the spotlight should shine on the nurses, doctors, and other medical experts, as well as the Department of Health and Department of Human Services. The bulk of this litigation is aimed at curing problems that they were educated and trained in, that they have the unique understanding and perspective on these matters. However, very briefly, I would like to share some of my criminal attorney's perspective when it comes to mental competency for trial, as well as court-ordered commitments. Said one attorney, "There is no local facility to house mental ill criminal defendants. Judges and lawyers agree that BOC, the Bureau of Corrections, is not a suitable facility. Mental health defendants are often exploited while incarcerated. They may face danger from others, and they may be a danger to themselves. Because there is no holding facility or treatment facility for the mentally ill defendants, judges are forced to release them. Just in the past couple weeks alone, cases were dismissed against mentally ill defendants who committed offenses because the facilities were wholly inadequate. In other words, aside from having a competent staff to evaluate and treat individuals, the territory needs the necessary infrastructure. This takes money, which only this body can provide. The most comprehensive, well-researched, and thorough piece of legislation means nothing if the content of the measure cannot be carried out in reality. In short, I recommend that this measure be subject to further discussion and revisited again so that the proper amendments and changes can be made to perfect this very important and comprehensive measure. However, in the meantime, the Office of the Attorney General would encourage this body to soul search and prioritize so that when this measure comes back again, in whatever form it takes, and it is signed into law by the Honorable Governor, that all of the executive branch agencies present before you will be well funded so that its mandate may be properly carried out. This concludes my formal testimony, and I will remain available for any questions the members may have. Thank you.
Thank you very much. Madam Attorney General, and we look forward to your responses on the questioning at the appropriate time. At this time, we'll go to Assistant Commissioner Mario Brooks from the Virgin Islands Police Department for his testimony.
Yes, good morning again, Mr. Chairman, the Honorable Nobel E. Francis Jr., legislative body and staff, members of the VIPD, our executive team, and to the members of the listening and viewing audience. My name is Mario Brooks, Assistant Commissioner of Police for the United States Virgin Islands Police Department, testifying today on behalf of the Honorable Trevor A. Villeneuve. Thank you for the opportunity to present testimony regarding the proposed bill that seeks to enact and establish the first Behavioral Health and Developmental Disability Act in this territory. The Act seeks to amend Title 19 to update the law, services, and programs that are currently available to serve adults and children in the Virgin Islands community with behavioral health challenges, mental health disorders, intellectual or developmental disabilities, alcoholism, and drug dependency, and establishes the first facility dedicated to providing comprehensive services and resources to patients and their families alike. People with disabilities are more likely to encounter the criminal justice system, including contact with police officers, than members of the general population. Currently, the Virgin Islands Police Department is provided a list from the Department of Human Services that offers information on mentally ill persons. When our officers are confronted by situations involving these members of our community, they routinely transport them to our hospitals for observation, depending on the situation at hand, or to the custody of the Bureau of Corrections if there's a violation of law. In the police academy, the officers of the Virgin Islands Police Department are provided 24 hours of interpersonal communication, which includes sensitivity training. This training is readdressed accordingly to understand and recognize the features of disability. They are equipped with the skills to handle many challenges that may arise in the safe apprehension and transfer of persons during the arrest process. The department offers no specific policies to support the direct engagement of persons classified as behaviorally or mentally challenged. VIPD does not arrest persons because of their mental health. Individuals are arrested for committing crimes. VIPD continues to pursue effective ways to address individuals with mental challenges. The department will continue to train employees on best practices associated with encountering this group. Our team routinely partners with the Behavioral Health, Alcoholism, and Drug Dependency Services Council, or BADS. That includes members of the Department of Health, the Department of Human Services, the Frederiksted Healthcare System, Royal Snyder and Walnut Louis Hospitals, and other stakeholders to remain informed. We consult on best practices and assemble to discuss industry standards and methodological approaches to serve this group. Though the bill seeks to bring some relief to the community, the agencies that provide services to this group are overwhelmed. After our officers transport these individuals to the hospitals or place them in the custody of the Bureau of Corrections, they are subsequently released back into the community for various reasons. Though I'm not able to provide the data, it happens more frequently than not. Moreover, according to the Psychiatric Rehabilitation Journal of 2015, a solid correlation exists between this group's involvement in the criminal justice system with poverty, mental illness, addiction, and other unmet public health needs. Individuals with mental health illness and or addictions make up most of the incarcerated population, 65% meeting criteria for substance use abuse disorder and more than half diagnosed with psychiatric conditions. The recidivism rate amongst this group is high. Though we are unable to provide data on the local rate, the national data as provided by the Journal of American Academy of Psychiatry and Law of 2020 details a sample composed mainly of males at 83% with an average rate age at release of 35 years. And the most common reported racial ethnicity was Black at 56.5%. Most of the subjects were single, 83%, with a high school or equivalency degree of 64.1%. Although individuals had multiple run-ins with the law, this is the first prison sentence for almost 50% of the sample. The most common reason for conviction was drug offense, 25%. These individuals served an average of more than 2 years in prison. Moreover, 54% of prisoners had severe mental illness. 60% were not diagnosed prior to going to prison. 66% of arrestees for those with substance abuse problems. 68% for those with co-occurring mental illness and substance abuse. Likewise, locally, these individuals often cycle through a revolving door of arrest, rearrest, and release that is costly in terms of expenses to the criminal justice system. This measure provides the holistic approach to our territory so desperately needs that entails the joint community and governmental engagement aspect. Formal engagement opportunities between the Department of Human Services, the Department of Health, Law Enforcement Planning Commission, and other agencies are dictated in this measure to support the effort. All efforts will be made to provide the support to the Superior Court needs in the enforcement of the bill in compliance with Section 1016. As first responders, we have a major role in the first-line crisis encounters. Therefore, I cannot stress the importance of the behavioral health training for personnel as provided in Section 1007 of the measure. We must acknowledge that this issue will not resolve itself. Officers will be taught in accordance with Section 1008 to determine mental welfare. It is enlightening to participate in this important discussion. The Virgin Islands Police Department supports this measure. As leaders, we certainly encourage officers to lead up to become a part of the solution and not add to the issue at hand. Upon enactment, this department will do all in its power, provided the resources, to play its role. Together, through education, partnerships, and its body's support, we have a chance to provide a cure to this issue that plagues our community. In conclusion, the Virgin Islands Police Department is a flagship law enforcement agency in the territory, responsible for serving the public and protecting our citizens, albeit occasionally from themselves. This is a responsibility our officers take seriously. Mr. Chair, we gratefully thank you for inviting us to give testimony here today. Though the demands of our residents remain high, the department will continue to strive to protect and provide better services. I thank this body for the opportunity to testify and our Honorable Governor Bryan for introducing the measure. My team and I remain on standby for your questions.
Thank you very much, Assistant Commissioner Brooks. At this time, we'll go to the Honorable Judge Harold Willock for his testimony. Mic check. Judge, you available? You have to turn your camera on and also unmute your device. Committee will take a 1-minute recess while we work out the bugs. Committee stands recess for 1 minute. We're out of recess at this time. Again, we're in the Committee of Health, Hospital, and Human Services, and we've been taking testimony in regards to the bill that the governor sent down in regards to mental health and developmental disability. At this time, we'll go to Chief Public Defender Samuel Joseph. You're recognized for your testimony at this time.
Good morning. Good morning, Senator.
Morning.
Albert Lee
Morning, Chief.
Francis, members of the Committee on Health, Hospitals, and Human Services, members of the 34th Legislature in attendance, invited testifiers, and individuals in the listening and viewing audience. My name is Samuel L. Joseph, Esquire. I'm the Chief Public Defender for the Office of the Territorial Public Defender. As noted, the Office of the Territorial Public Defender has been invited here to comment on the bill proposed to establish the first Behavioral Health and Development Disability Act. I would like to start off by commending the sponsors and all who worked on this bill. This proposed bill is extensive and comprehensive, so I urge careful thought and consideration. Because we are in the preliminary stages, we still have time to involve the men and women who toil in the trenches on a daily basis. I believe their input is vital. As an attorney and a public defender, I have seen firsthand the issues of mental health and behavioral health, substance abuse and addiction in our criminal justice system, and how we as a community has failed to adequately address it. It is time we address these issues comprehensively and defer from kicking the proverbial can down the road. In the past, the normal and expected response to a bill of this nature would be, where is the funding going to come from? While this is a definite and realistic question, that cannot continue to be the excuse that is used. Doing so would only exacerbate the enormous human, health, and overall fiscal costs. The testimony I offer today is within the context of the criminal justice setting and the ramifications thereof. This legislation seeks to overhaul the statutory scheme that addresses mental health and addiction that is currently in place. Arguably, it is the biggest step taken in decades to address the issues identified. While I find comfort in many portions of the proposed act, there are areas that need to be addressed. And we should always strive to render the best product. I will start at the definition portion. Pursuant to Section 1001, subsection 9, behavioral health professional means licensed psychologist, psychiatrist, psychiatric nurse, behavioral health counselor, or psychiatric social worker, or in the absence of an emergency medical technician. There are other mental health professionals in the trenches who have dedicated countless hours to our community that counsel and address the issues that the Act proposes to address. They are licensed professional counselors, therapists, clinicians, and licensed social workers who have all toed the line for years and have continued to do so with vigor and tenacity. Next, an area of concern is the requisite training that is required in accordance with Section 1007. Pursuant to 1007A, law enforcement officers are most often the first responders in behavioral health emergencies. As such, it is essential that law enforcement officers recognize the signs and symptoms of behavioral health challenges or mental health disorders and respond more effectively and appropriately to individuals in crisis. Pursuant to Virgin Islands law, a large number of persons are considered peace officers. Title 5, Virgin Islands Code Section 3561 notes, peace officer is any inspector employed by the Taxicab Commission, Marshal, Deputy Marshal, Qualified Probation Officer of the Superior Court, Waste Management Authority, Enforcement Officers, Enforcement Officer of the Commission for DPNR, and Corrections Officers, Director of Fire, Fire Marshals, Fire Inspectors, Deputy Fire Inspectors, Investigators for the Department of Justice, for the licensing and consumer affairs, and a whole plethora of other persons. That being said, and as a practical matter, when would all of these officers receive the appropriate training as required? Additionally, factors that should be considered are what is the training schedule and who will be trained? What are the implications based on the consent decree for the Virgin Islands Police Department? Is there recertification or refresher courses required upon being trained? These questions must be answered in order to ensure the health and safety of not only the officers that are involved, but also the individuals they come into contact with. While it is good to have a general framework, practical implementation must be factored. Section 1008, protective custody, is also of grave concern to me. Even though portions of this section already exist in current Virgin Islands law, coupling this with untrained officers has some serious implications. Pursuant to Section 1008, if a law enforcement officer has probable cause to believe that a person is suffering from behavioral health challenges or mental health disorder, and due to that condition presents a threat of imminent and physical harm to that person or other persons or property, the law enforcement officer shall take the person into protective custody. Generally speaking, probable cause can only be found when it is shown or exists reasonable articulable suspicion that criminal activity is or was afoot. The question then becomes what activity constitutes probable cause if the situation being addressed is of a mental health nature, where no crime is committed. Additionally, while the officers may rely on outside information from third parties as well as other persons who saw the person to be taken into custody most recent behavior, this in conjunction with limited to no training can, in my opinion, be disastrous and can open a gateway for constitutional due process abuses. I can think of a number of scenarios where this can easily occur. The same holds true for Section 1025 or 1025. There's no definition laid out in the proposed bill. It leaves open to subjective interpretation and application by a plethora of individuals who have been given peace officer status. Probable cause is vague and thus unconstitutional. The ability to take into protective custody individuals despite the fact they may lack proper or requisite training is problematic, no matter how you look at it. With no intent to cast aspersions, I say this. An untrained peace officer taking persons into custody, protective custody that is, for what they believe to be probable cause or where its probable cause is found, to do so would not only be unconstitutional, but tantamount to illegal kidnapping and a false imprisonment. In any courtroom forum, probable cause always requires a judge to make a final determination. As such, the judiciary would have to be involved at some point in time. And the burden should not be laid solely on the police officers who interact with these individuals. The next area of concern I will discuss is placing the financial burden of transportation and maintenance on patients. Section 1027 requires patients that are considered non-indigent at the time of the admission to a mental health hospital to bear the cost, and it must be paid by them monthly in advance. Based on the cost of healthcare, would that not render most, if not all, persons with mental health issues to be considered indigent? Further, the statute fails to identify what the threshold for determining indigency is. To further exacerbate the problem as it relates to the costs, Section 1028 penalizes persons with mental health issues by requesting individuals who agree to undertake a person's care and restraint to pay a bond set by the judge. This is tantamount to bail, and the purpose of bail is generally to ensure the defendant's appearance at trial. If the purpose is to ensure the person with mental health issues is looked after, then why would money be a requisite for their release? Section 1028C further goes on to note the bond may be waived if reasonable cause exists. If this is the case, what is reasonable cause within this context? Another area of concern is Section 1032, subsection B, which speaks to the interception and turning over of patients' mail to the Department of Justice. If there is reasonable cause to believe there is contraband information regarding an unlawful event or activity that otherwise warrants interception. Notwithstanding the fact this should only be applicable to contraband, this portion of the statute is vague and overbroad and would fail against a constitutional challenge. For example, what constitutes otherwise warrants interception? And how would one know that a letter contained information regarding an event under normal circumstances without actually opening and reading the letter? This is not an institution that is considered a prison or a jail. These individuals are being held mostly and in part because of the mental health issues or crisis that they are going through. The security issues are much different. The issues identified stand out the most. There are, however, several others, many of which can be rectified through policy. But that policy should be tied to timeframes under the proposed act. This is a large undertaking. I see areas that are ripe for abuse. As noted earlier, practical implementation is key. As such, prior to implementation, there should be a basis or model framework for the necessary committee under the act to be formed, a mandatory clause in all service contracts requiring jurisdictional submission to the Virgin Islands for all outside service providers, smaller timeframes for those individuals who voluntarily commit themselves to remain committed, and the implementation of time requirements for offices to be formed, policies and programs that expand services for juveniles, and most importantly, a realistic focus on building a facility pursuant to Section 1041. Currently, the Office of the Territorial Public Defender has over 20 clients who are housed off island in various facilities. This amounts to an exorbitant amount of cost to the government of the Virgin Islands, and it presents difficulties when it comes to consultation with our clients. The diversion of individuals with the substance abuse and mental health issues away from jail and juvenile detention centers towards a more appropriate and culturally competent community-based mental health care system is critical and is key, and it is now time to turn the tide. For decades, our community has dealt with mental health facilities issues and a lack of mental health services. We can no longer kick the can down the road. Further, with respect to the proposed statute, there are many portions that make reference to the representation of these individuals within the court. That needs further clarification. Obviously, there'll be overlap for cases in which the Office of the Territorial Public Defender would be involved. Those are the criminal cases. But what about the cases for involuntary commitment or voluntary commitment on its own? What court does that go to? Will it be the family court, or will it be the courtroom in which the criminal charge is pending because of the overlap? We believe also, because of due process implications, at some point we may run afoul as a community of due process. Many of our clients are being held off island, and we have very limited ways of accessing them. Even this past year has presented a large amount of problems in terms of being in contact with our clients. The institutions where the clients are being held off island have limited interaction and in-person contact. This bill is one that has issues and needs some clarity. However, it is a step in the right direction. I think we can all agree that it's time that we put our shoulders to the wheel and do what is necessary in order to bring our people home and house them in institutions that can help them get the treatment that is needed. While the Public Defender's Office cannot speak in favor of the bill per se as it relates to conflict of interest, we are happy to see this bill being moved forward and will stand by and be part of any discussions needed in order to move this bill to the place where it needs to be. Thank you for your time and consideration. I remain available for any questions.
Thank you very much, Chief Public Defender Joseph, and my office will be in contact with you to get a copy of that testimony shortly. At this time, we'll go to Judge Willock. Judge Willock, you recognize your testimony? Very well, we'll proceed to the next testifier and then come back to the judge. At this time, Bureau of Correction. She's just coming in. Let's go to the NAMI. President Parkson, you recognize for your testimony at this time.
Good day, honorable senators, fellow testifiers, and the listening audience. My name is Sherilyn Pogson, president of the National Alliance on Mental Illness St. Croix affiliate, also known as NAMI St. Croix. I am here today to share with you our comments on the proposed Virgin Islands Behavioral Health and Developmental Disability Act on behalf of NAMI St. Croix. NAMI is the nation's leading grassroots advocacy organization solely dedicated to improving the lives of persons with severe mental illnesses. Currently, 1 in 5 adults in the United States experience a mental illness. That could be an estimated 20,000 plus Virgin Islanders that may need behavioral health care services based on the population data from the 2010 census for the US Virgin Islands. According to the On Pins and Needles survey conducted by the National Alliance for Caregiving, it is estimated that at least 8.4 million Americans provide care to an adult with an emotional or mental health issue. Prior research has shown that these caregivers are especially vulnerable as they face complex, high-burden care situations, resulting in higher caregiver stress and strain. In the Virgin Islands, that could be approximately 2,700 plus caregivers that are vulnerable to face emotional stress, physical strain, and burnout. As an independent, nonprofit NAMI affiliate solely made up of volunteers, NAMI St. Croix's passion is to dedicate our time and resources to facilitate support groups, teach NAMI signature programs, advocate for behavioral health systems, change, and foster peer relationships that strengthen and empower individuals. This work is rewarding and fulfilling, but is quite often a challenge without the necessary resources and programs in the territory to support persons living with mental illnesses and their families. Therefore, we applaud the intent of the proposed bill to establish a coordinated, comprehensive behavioral health and developmental health service system in the territory. However, we have several concerns with the proposed bill in its current form, in addition to critical needs that we feel need to be addressed while work is being done to develop a coordinated, comprehensive behavioral health and developmental health service system in the territory. Our areas of concern in the proposed bill are the use of diminishing terminology, the lack of defined sources, the lack of defined funding sources, the lack of defined emergency commitment procedures, the creation of mandatory committees and councils, the lack of protections of persons with developmental disabilities, personal liability to guardians, the exclusion of defined housing programs, and the exclusion of an early identification and intervention program for children and adolescents. The entire document refers to individuals who suffer from disabilities over 70 times. This is contrary to current person-first language and should be eliminated from the document in its entirety and be replaced with a person who has terminology. There is a pervasive stigma surrounding mental illness, and it is inherent that we encourage the use of person-first language amongst ourselves, in our community, and stated in our policies to begin to eliminate said stigma. Section 1 of the proposed bill references the reappropriation of funding from the Casino Revenue Fund from other government entities, specifically hospitals and health, gambling addiction and education programs, and the University of the Virgin Islands. Reappropriation of funding from these other entities can result in the reduction of existing services for the community, particularly for individuals diagnosed with a mental illness from hospitals and health. If this revenue stream fluctuates, what guarantees do we have there will not be inconsistencies in the healthcare provided? It is our opinion that a clearly defined funding source to support the systems needs to be appropriated to ensure successful implementation of the system. The lack of defined emergency commitment procedures in subsection 1020, currently known as a 722, is a concern. In section 1020C, the response time and required process steps from the written application to the evaluation by a doctor or behavioral health professional is not defined. In section 1020CI, the response time from the evaluation to the transportation request by an administrator/director or behavioral health professional to an approved public treatment facility or hospital is not defined. In section 1020F, the administrator/director of the approved treatment facility or hospital can refuse an application and certificate if they fail to sustain grounds for commitment, which effectively negates the professional assessment already done. It is our opinion that this language and action should be removed. The lack of a defined emergency commitment protocol brings frustration and possibly physical harm to the family members, caregivers, and persons with a mental illness experiencing a crisis. It is our opinion that this area needs to bring clarity and safety as soon as possible for everyone involved. The creation of mandatory committees and councils is another area of concern. In section 1014, it creates an interdepartmental coordinating committee made up of all the commissioners of health, human services, education, police, vocational rehabilitation, and any other departments at the discretion of the governor. In section 1015, it creates a 7-member Citizens Advisory Council on behavioral health, alcoholism, drug dependency, and developmental disabilities with members appointed by the Commissioner of Health and approved by the governor with an extensive list of duties to perform. An advisory board, the Virgin Islands Behavioral Health, Alcoholism, and Drug Dependency Planning Council and Advisory Board, currently exists under Act number 8152. In section 1116A3, it refers to a mandatory establishment of a protection and advocacy P&A system for protection of the legal rights of persons with disabilities. There is already an existing P&A network in the Virgin Islands operating under federal grants, the Disability Rights Center of the Virgin Islands, which already has established offices in St. Croix and St. Thomas, St. John districts. While continuum of care is a positive measure, these different entities call for establishing administrative bodies with a new set of mandatory rules to follow. It is a struggle to obtain sufficient members for the councils that are currently established. Our concern is that these new mandates will create more bureaucracy. It is our opinion that supplementing the necessary amount of support staff to provide these services under existing programs and administrations with a comprehensive case management system will bring more value to the processes and the system. The lack of protection of persons, children, and adults with developmental disabilities is another area of concern. The proposed bill makes no distinction throughout between individuals with a mental health challenge, mental health disorder, or drug addiction, and individuals with a developmental disability. There is a significant distinction between these two populations of those with mental illness and those with developmental disability. Combining persons with developmental disabilities and persons with a mental illness together has the potential to harm those persons who may not have the cognitive ability to understand certain situations and be taken advantage of. It is our opinion that this should be reevaluated. The potential for personal liability for guardians is a concern. In Section 1034A1, it states that a guardian may be held responsible for payment of the debts of the ward by the court at a hearing. This would have a dampening effect on any party applying to be a guardian due to potential liability for the debts of the ward. It is our opinion that this section should be reevaluated. The exclusion of defined affordable supportive housing programs is a concern. Clearly defining dedicated housing initiatives for persons with a mental illness, such as transitional housing, personal care homes, or independent/supported living facilities to provide supervision and assistance with personal care tasks will help to support their independence and improve their quality of life. The exclusion of a defined early identification and intervention program for children and adolescents is a concern. According to research conducted by ArchGen Psychiatry, 50% of all lifetime mental illnesses develop by age 14 and 75% develop by age 24. It is our opinion that clearly defining an identification and intervention program is critical to a comprehensive behavioral health care system. While addressing these concerns are important, it is critical our policymakers prioritize certain challenges now as work on this proposed bill continues. We strongly urge our policymakers to prioritize the development and training of community-based crisis intervention teams for the VI Department of Health and the VI Police Department, the establishment of the behavioral health facility on St. Croix, and the mobilization of the mobile wellness vans for the St. Croix and St. Thomas St. John districts appropriated in Act 8152 in January of 2019. The development of transitional housing and personal care home programs, the development of an early identification and intervention program for children and adolescents, and clearly define emergency commitment procedures. These priorities are critical now to improve behavioral health care services and improve the quality of life for persons with a mental illness and their loved ones. NAMI St. Croix realizes that the challenges of mental illness do not only affect an individual's family members, but also friends, teachers, neighbors, co-workers, and others in the community. Therefore, we encourage other opportunities for discussion and feedback from other members in our community. Any comprehensive behavioral healthcare system implemented in the territory will require resources and support from all of us. In closing, I would like to say NAMI St. Croix stands ready to support and advocate for these priorities and the Virgin Islands' future with a comprehensive behavioral healthcare system. Thank you again to Senator Novelle Francis and the members of the Committee on Health, Hospitals, and Human Services for the opportunity to allow NAMI St. Croix to provide testimony on the proposal. I'll make myself available for any questions you may have.
Thank you very much, President Pogson, for your testimony. Next, we'll go to the President of the Bar Association, Ms. Purcell, and then we'll follow her with the Director of the Bureau of Corrections, Ms. Winnie Testamark.
Good morning, everyone. Thank you particularly to Senator Francis, the Chair of the Health and the Hospitals and Human Services Committee, your committee, and for all the senators and everyone else here testifying today. We welcome the opportunity as the Bar Association to review the Behavioral Health Act and Developmental Disability Act. We've not had an opportunity to meet before, and so I wanted to introduce myself. My name is Charlotte Perrell. I am an attorney practicing here in the Virgin Islands at Dudley, Newman & Fusig, and I am the current president of the Virgin Islands Bar Association. It's in that role that I'm here today to provide the comments of the association. The Bar Association is comprised of 1,200 lawyers, 865 of which are actively practicing in the territory. The Bar Association has a standing legislation and legal reform committee who undertake to review proposed legislation. And so when we received this request, I contacted that committee and had them review this in detail for their comments and so forth. The committee reviewed it and prepared the comments in the letter and testimony that I provided earlier this week. In addition, the committee has also provided me a detailed letter with very specific line-by-line proposed changes and concerns that they have, and I'm happy to elaborate on those as needed and to provide specific examples. In addition, I reviewed the legislation personally and have met with the chair of the committee to try to answer any further questions that I might have had and to further discuss these issues. In addition to the committee's experience, I also come before you as an attorney who has practiced for 27 years and who has, over the course of that time, had certain instances where I have had involvement with many of the issues that are being addressed in this legislation. In particular, I've represented the family of a young man who was designated as a risk of harm to himself and others, was being transported from an emergency room to a mental health facility, and literally jumped out of the back of the ambulance while it was moving 50 miles an hour down the road. He clearly was hearing voices and was having a psychotic break. As some of the others who have testified earlier, it is very common for individuals' mental health illnesses to start to manifest themselves in the later teen years and early 20s. My experience in various matters that I've involved and represented individuals, that is in fact the case. While here in St. Thomas, I've represented and been appointed pro bono in a number of cases relating to young teens who are being housed at the Seaview facility here on St. Thomas, one who had escaped and so forth. Another young man who was clearly involved with a psychotic break and was oftentimes turning to drug and alcohol to self-medicate. I have no place to go here on the island. There's issues associated with those hospitals being paid for their services because of a lack of funding. And so I understand exactly how important this is, and I hope to bring that experience and that of our committee to bear on our testimony here today. The position of the Virgin Islands Bar Association believes that this proposed legislation is a much needed and a great start to address the challenges that do face this community. We review this legislation without an agenda, and we seek to provide you a neutral counsel as to the ability of this legislation to function as it is intended to do so. Therefore, we offer our comments not to criticize, but instead to assist in the effort to further develop and refine this legislation. The goal for the legislation is to always work and to accomplish the goals. It is not beneficial simply to pass a legislation that sounds good, that may look comprehensive and certainly means well, but that actually doesn't. Further, we're cognizant of our limited role, and we simply note certain areas that we would like to point out that may create contradictions or concerns, not to be so presumptuous, however, to determine what the solutions may be. We're trying to stay in our lane, so to speak, and simply be neutral advisors as to the legal functioning and the ramifications of this proposed legislation. Certainly, if the committee would like for further input from the Bar Association, we are happy to dig in and to do that, and I'm sure we can supplement as we need to. With regard to the areas, there are really 5 areas of concern, and as I've had the opportunity to listen to various individuals who spoke earlier, many of those have been raised before, and I hate to again, retread the ground that many have already made, but I would like to emphasize that it appears that there are some consensus as to some of the areas that do need to be addressed. One of the areas, of course, is the issue relating to the definitions. The Virgin Islands Bar notes that the legislature attempts to refer to the DSM, which is the 5th volume, the one that they refer to of the Diagnostic and Statistical Manual of Mental Disorders. That is, in essence, the reference book for that, those issues. And while that is an important place to refer, the problem we see with the legislation as it's currently drafted is that while there is a referral to that manual, at the same time, the legislation attempts to draft very strict and concrete definitions and make defined what those particular pseudo-medical terms are in the legislation. That can oftentimes create a conflict. And I believe, as the Public Defender's Office noted, and I believe even the Attorney General's Office noted, sometimes that's going to create a problem. So if as an attorney, I'm appointed to represent an individual who may be committed and so forth, and if the doctor has done a certain diagnosis, if it doesn't fit with the language that is set forth in legislation, we are going to have a problem where we've got a question as to whether or not the diagnosis, in fact, is what was being contemplated by the legislation and so forth. I believe that that one's actually a relatively easy fix, and that it could easily be remedied by simply designate the DSM as the definitional requirements for these various components throughout the legislation. Others have mentioned, and I would echo this issue relating to adequate funding. The Act creates a much needed public mental health treatment facility and requires specific timeframes for mental health treatment and services and so forth. It also requires that beds be made available for acute mental treatments, requires access to psychological and psychiatric care, and in some instances even requires access to second opinions, create certain learning centers and so forth. However, the concern, of course, is that the funding sources that are currently in place in the legislation may not be adequate. It proposes portions of the casino revenue fund, which is currently allocated to health and hospitals for gambling addictions and also to the Virgin Islands. And although the proposed bill was drafted before the COVID pandemic hit, this past year has taught all of us that revenues oftentimes cannot necessarily be relied on, and certainly a tourist component or in a scenario where we're talking casino revenues where folks are not able to attend those venues. And once we start to establish a facility, the costs are long-term costs. These are costs to house individuals, sometimes for many years on end. We need to have the ability to have psychiatrists, psychologists, and various individuals available. So the revenue source, and I understand that there's limitations as to where the revenue is going to come from, but having a consistent revenue source that is going to be available long term, I think is going to be key in order to making sure that this legislation actually functions in the way that it is proposed. The other issue related to the role of law enforcement, I would echo some of our other presenters earlier. Certainly the Attorney General and the Public Defender's Office and some others have echoed this issue. There is significant concern about putting the onus of making diagnoses or mental health illness diagnoses on the police officers without at the same time giving them significant and adequate training to really make those diagnoses. In the past, I've actually had some experience with a particular mental health task force in a state in the United States. And in that particular task force was an arm of their particular police department. Those individuals were at the investigator level and had typically significant either undergraduate degrees or significant training in psychiatry, psychology, and ability to recognize mental illness signs. Oftentimes, homeless individuals or individuals who may be involved in a crime who are suffering from mental illness have telltale signs. Oftentimes they may, for example, spew obscenities. They may act in a way that would be goading or provocative under otherwise normal circumstances. That puts a police officer in a scenario of having to determine whether this individual is actually being aggressive and should be taken in or otherwise restrained, or whether in fact the individual is simply manifesting different behaviors that are actually indicative of mental illness. So putting the officers in that front line, which they often are, but we've got to make sure that they've got adequate training in order to do so. We would also note that it appears that across the country, there has been a move to take officers away from that primary role and put that onus on other types of individuals that have specialized training in that regard. Some of the more recent stories that we've all heard relating to an officer's misinterpretation of someone who had either a mental illness or a mental disability and has had very catastrophic effects comes to mind. So we want to be careful that whatever role we put those police officers in, that we fully support them to be able to do that. And that either means not having them be always only on the front line, or making sure that the training that they receive is secure, is adequate, and is something that's going to be able to put them in a good place going forward. One of the issues that we also noted was sections 1060 through 1067. These sections relate to a not guilty by reason of insanity component and create procedures related to that defense in criminal trials. We would note that there's a couple of challenges there. For example, Section 1060 requires that a judge instruct the jury to determine whether, quote, the defendant is of unsound mind. But however, the Virgin Islands Supreme Court has held that the prosecution must prove a defendant's mental condition at the time of the crime, as opposed to at the time of trial, in order for there to be a conviction. So we would recognize that there's potentially an inherent controversy and contradiction there, and that the determinations made by the Virgin Islands Supreme Court will prevail over an inconsistency in this regard. So we want to make sure that before this legislation goes forward, that those things have been reviewed and are fixed in order to make sure that we don't walk into lots of inconsistencies going in. With regard to education of children with intellectual disabilities, sections 1120 through 1123 of the Act, it addresses the behavioral health of children and young adults. One of the ways it attempts to do so is taking the Department of Health, tasking the Department of Health with, quote, establishing an educational program for children with intellectual disabilities. The approach potentially is problematic because it directly conflicts with existing provisions of the Virgin Islands Code directing the Department of Education as responsible for, quote, all regular and special education and related services required by children with disabilities. An additional concern, of course, is possibly creating incongruencies between the various entities and over-regulating what is going to be required of an individual and the child. We certainly understand the need to coordinate, but there's coordination to the point where it might really actually be detrimental in that it ultimately does not function, and there might be conflicting regulatory requirements. At the end, we definitely believe that this is a wonderful measure. We think that it is something that is desperately needed. We hope that we can be involved in further review of it. We have additional details that we can provide to this committee and to any of the other stakeholders who would like our input. We suggest potentially, I believe echoing on some of the other testifiers, that perhaps shoring up a few of the laws and some of the procedures that we have in place now and getting those shored up, and perhaps coordinating for a phased-in approach as a facility starts to be either put into place and so forth, would probably be a good way to resolve it in the short term while we all continue to work on the efforts in the long term. But we thank this body, and we thank everyone for allowing us to testify and to review this important legislation. We are happy to answer any questions and to be of any further service that you need us for. Thank you.
Thank you very much, President Purcell from the Virgin Islands Bar Association. Next, we go to Director Winnie Testamark from the Virgin Islands Bureau of Corrections for her testimony.
Good morning, Chairman Francis, distinguished members of the Committee on Health, Hospitals, and Human Services, and other distinguished members of the 34th Legislature of the Virgin Islands, and our listening and viewing audience. I am Winnie Testamark, Director of Virgin Islands Bureau of Corrections. On behalf of the men and women who make up the BOC, thank you for the opportunity to offer our perspective regarding this landmark bill proposal. Bill number BR 210244, the first Behavioral Health and Developmental Disability Act, makes major and needed revisions to the Virgin Islands mental and public health law. With me today are Mr. Riel Faulkner, Assistant Director for Administration and Compliance, and Dr. Celia Victor, our Health Service Administrator, who works closely with our mental health team and who brings considerably experience in mental health issues to her role, and Ms. Ruth Warren, our Mental Health Coordinator at the Alexander Farrelly Complex under St. Thomas Facility, CJC, who has worked for almost 10 years with the mentally ill persons in jail. We are prepared to discuss how this bill, if enacted, would impact Bureau of Corrections operations. But first, let me paint a picture of the mental health landscape in the Virgin Islands as it relates to corrections. The Virgin Islands has been under a mental health state of emergency since September 2016. The destruction caused by Hurricane Irma and Maria in 2017 only made an already critical situation worse. Within the first 100 days of taking office, Governor Bryan extended this state of emergency by executive order so that the Department of Health could have access to federal resources and broaden its search for qualified mental health professionals. This mental health state of emergency has had and will continue to have a substantial impact on the Bureau's operations. Because of the mental health crisis nationwide, prisons and jails are now the largest institutions housing adults with serious mental health disorders. In fact, the largest mental health hospital in the country is a jail. The mental health state of emergency in the Virgin Islands means that the Bureau of Corrections is now one of the largest providers of mental health services in the territory. Today, roughly 40% of all our inmates at Bureau facilities receive some form of mental health treatment. The National Alliance on Mental Health Illness, NAMI, estimates that between 25% and 40% of all mentally ill Americans will be jailed or incarcerated at some point in their lives. To meet this need, the Bureau presently retains the services of a part-time psychiatrist and recently contracted with a local psychiatrist provider with its own complement of psychiatrists and other mental health professionals to provide mental health services for inmates on both islands. We also have 2 full-time mental health counselors on staff, as well as a qualified mental health professional. In the Virgin Islands, those who suffer from some type of mental illness and who may have been charged with some minor infraction or petty offense are brought to the Bureau facilities by default, since there is no long-term treatment facility for the mentally ill in the territory. The harsh reality is that those who need mental health treatment the most, especially those who are homeless, don't get the treatment until they commit some offense that lands them in jail. Without a forensic health facility in the territory, however, the Bureau's options are necessarily limited. Those inmates suffering from severe mental illnesses who need the highest level of care must be sent off island to a treatment facility at great cost. Providing adequate treatment and facilities for the acutely mentally ill is a territory-wide problem, which manifests itself in Bureau facilities. Perhaps the most serious challenge facing incarcerated persons suffering from a mental illness in the Virgin Islands is one over which the Bureau has no control. The time it takes for the criminal justice system to process their cases. Mentally ill inmates who may have committed very minor offenses sometimes spend months or even years in jail waiting for a decision on their case, sometimes much longer than the punishment for the offense which they are charged. This is a major point of contention in the federal consent decree case covering the Alexander A. Farrelly Criminal Justice Complex on St. Thomas, and the John Bell Adult Correctional Facility and Detention Center on St. Croix. We need to do a much better job as a territory processing cases through the criminal justice system so that the incarcerated mentally ill don't deteriorate in our jails while awaiting a decision on their case. So, as you consider this important legislation, I urge you to consider placing time limits and time constraints to expedite the criminal justice process for the mentally ill. We also need to consider non-penal alternatives to mental health treatment. Not every offense allegedly committed by a mentally ill person warrants incarceration, especially for nonviolent property crimes. Some minor misdemeanor offenses may be handled by a non-criminal referral to treatment. I also urge this committee to consider establishing a mental health court, staffed with judges and advocates specializing in mental health who may be able to handle much of the current mental health caseload on the court docket. Mental health courts not only expedite cases involving the mentally ill, but also acts as diversion interventions designed to engage defendants with mental illnesses in treatment instead of incarceration. These courts link offenders who would ordinarily be prison-bound to long-term community-based treatment. Mental health courts also emphasize family, work, and responsibility. It allows family members to have regular visits at the treatment facility. And importantly, a person committed to a mental health court is not saddled with a criminal record. Although establishing these specialized courts comes at a cost, doing so may be cheaper in the long run than simply incarcerating the mentally ill. We welcome the opportunity as required by State Statute 1002B of the proposed bill to coordinate with the courts, the Department of Health, the Attorney General's Office, the Virgin Islands Police Department, and community agencies to devise innovative ways to get the mentally ill in the territory the care and treatment they deserve. Turning to the specific provisions of the bill affecting the Bureau of Corrections, we have identified the following areas of concern. Section 1054A or B on page 67 should include a time limit for when a competency hearing must be held. This will ensure that a decision on a defendant's mental competency to stand trial is expedited and prioritized. Without a time limit, a person suspected of mentally ill may languish in jail for months or even years for waiting for a competency hearing. As I stated earlier, this has been one of the foremost problems facing the territory's mentally ill in jail and is a major issue in the federal consent decree. In State Statute 1057B, paragraph I, on page 68, we are concerned about limiting the psychiatrist to 4 months to evaluate a defendant to whether he or she can attain the capacity to stand trial. We do not believe that it is advisable to put a specific timetable on a psychiatrist's treatment or evaluation. In State Statute 1060E on page 70, which requires testimony of 2 or more qualified physicians when deciding whether a person is not guilty by reason of insanity, we have 3 concerns. First is that testimony should be limited to licensed psychiatrists, not physicians in general. And second, there are only a handful of licensed psychiatrists in the Virgin Islands, and it may prove difficult or impractical to find 2 who are available to testify at trial, thereby delaying the proceedings. We suggest expanding the pool of psychiatrists to include 1 license in the Virgin Islands and 1 license in another jurisdiction of the United States who can participate via telepsychiatry. Third, it should be made clear that one of the psychiatrists giving testimony should not be the defendant's treating psychiatrist, which would present a conflict. Subparagraph 2 of State Statute 1060E should substitute the word treatment for restraint. Restraint is more coercive than treatment. Section 1061A on page 71 should also have a time limit for how soon a person found not guilty by reason of insanity must be committed to the Commissioner of Health for placement in a suitable facility. Section 1065A on page 72 incorrectly commits a person who has been found not guilty by reason of insanity back into the custody of the Bureau of Corrections if, after a court hearing to determine whether they should be released from a suitable mental health facility, they are still considered a threat to themselves or to others. They should be committed to the Commissioner of Health or the Division of Behavioral Health because legally, a person found not guilty by reason of insanity is acquitted of the charges against him, and the Bureau has no just jurisdiction to take custody over a person who has been tried and found not guilty of a crime. Similarly, we believe State Statute 1071A should be amended to substitute the Commissioner of Health or the Division of Behavioral Health in the place of the Bureau of Corrections. This should be done for consistency and because the section speaks of commitment to a suitable facility in lieu of being sentenced to imprisonment. Since there would be no sentence of imprisonment, the person should be committed to the care of the Department of Health with BOC assisting with transport to the mental health facility as currently is the case. In State Statute 1090A, we also suggest that the term person suffering from an abuse disorder should be substituted for the term addict in keeping with contemporary mental and behavioral health practices. Conclusion. Thank you for the opportunity to give testimony on this important legislation. The Bureau is prepared to work with the legislature and partner agencies to provide those suffering with mental illnesses in our community the care and treatment that they need. My staff and I will be happy to respond to your questions or concerns. Thank you.
Thank you very much, Director Testermark, for your testimony, and to the public and colleagues. We are almost to the end of testimony. And again, this is a very comprehensive bill. It's almost a complete reform of our behavioral health, one of its first of its kind. Also, the bill itself right now contains 110 pages of makeup, but we do have the Honorable Judge Willock and live and direct. He's available, and I'd like to get some testimony from him. Individual that I've encountered, this situation. I've been at the forefront in really moving similar legislation and also addressing the mental health issue for quite some time. Judge Willock, good afternoon. You are recognized for your testimony at this time.
Good afternoon, Honorable Senator Francis. Listening audience, fellow testifiers, senators. I do apologize. I sort of busy trying to handle a calendar. First, let me thank a lot of the unsung heroes. The issue of mental health goes back for many, many, many years, over perhaps 20 odd years. I want to thank the 50, 60, or 100 people who throughout the years have who have been in the trenches and have really tried to improve the conditions for the mentally ill. In particular, I'd like to single out Assistant Attorney General Joseph Pontine and Dr. Hendricks. They have been in the trenches, they're older than I am, and they've been in the trenches doing that far longer than I have. I'm not really going to speak long, I never do, try to avoid that. What we have to look at is this bill is a floor plan. It gives us, no bill is perfect. However, it gives us a guide as to how we should proceed in doing or handling the mentally ill. We have to understand that one of the biggest problems here is coordination. The bill attempts to do that. There's a lot of concerns about, for example, competency. The court cannot, and I'm choosing words very carefully, if the skeleton, if the system is not there, we cannot have a competency hearing unless we are provided with certain information. We cannot have a trial determining whether or not that person is not guilty by reason of insanity, unless the support services is there. So we have to understand that this is not just a singular, if you will. This has to be a coordinated effort. The basic functions of each department is crucial here. Human services, health, mental health. That is the core of the of providing services. I don't think there's a need for any mental health court. We don't have the numbers for that. There is a significant need, if you will, to have the basic services provided so that the courts, as well as everyone, or defendant's rights can be respected. If the court requests for example, a psychiatric report to be provided in 5, 10, 15 days, and it's not there, the court has 3 options: put the person in jail, hold them in contempt, and just simply say, okay, when can you provide it? Been there, done all 3. So we can't look at necessarily anything in a vacuum and simply say, this is the best way to do it. We have to provide the most basic of services. That is the root of the problem. Once that is done, then all the other services become automatic. I don't really adhere to we don't have those services. No, we are obligated to provide those services. We're obligated to have psychiatrists here. We're obligated to provide the most basic and essential treatment for the mentally ill. And that is what is required, that needs to be done. I look at this bill, I think it's an excellent, I guess it's a blueprint. I think some of the concern has been that when the bill was initially written and so forth, the law changes. The law changed in several areas, such as with the Supreme Court. Well, I would think that may have been done because the law has since changed on that. Those are simple amendments. But I don't think we should get lost because of the technicalities. I think we should focus on the actual structure, which is providing the services, using this as a blueprint. We can provide basic services now, but for whatever reason, it has not been done. I have been in many meetings and so forth where we can provide it, but for whatever reason, we have seen MOUs. There have been plans to use Anna's Hope, Golden Grove, all kind of different buildings and areas. And then within the next 2-3 months, it's 10 steps backwards. So that is concerning to the court. And I think that we need to really utilize this bill as a framework. The minor amendments can be done. But while we're doing this, people suffering from mentally ill are being abused, the women are being raped. I mean, this is a real problem. And we need to understand that we're basically in the belly of the beast. And we don't really have time to continue proceeding on the path that we're doing. Like I said before, Honorable Senator Francis, I really don't speak. I think I can better assist you in answering any questions. Thank you.
Thank you very much, Judge Bullocks, for your testimony, colleagues, and to the general public. We have heard from 9 testifiers this morning in regards to this particular measure, and as I have indicated before, it's a bill proposal that has 110 pages, and it's no perfect bill. There's a tremendous amount of work still to be done with the bill, and it's no easy undertaking. And I'd like to open up the floor for some questions at this time. However, I want to continue to say to those individuals, the mothers and family members, husband, wives, brothers and sisters, those individuals that continue to be under siege every single day because of dealing with this issue of behavioral health. I know that you're confronted a lot of times of what to do
what not to do. You know, you can't come out your house. You know, there's things that's happening. You have to lock up your homes. You call the police. There's a certain expectation. This body have done some of the work that's required. We have provided some funding. We have changed laws in the 722 and 723. Involuntary committals. You know, we have really worked with some of the medical institution to make sure that there is the funding available for you know, the infrastructural designs and preparation that they need to be made. I know that the Virgin Islands Police Department have also worked in terms of entering into MOUs that when they respond to the hospital, that in fact that they are given priorities. You know, the issues that's confronted here have not gone unnoticed, and I would be the first to admit that perhaps we have not gone forward enough to address it. We have heard of the declaration of state of emergencies in respect to mental health for quite some time, and it's something that we will continue to, you know, to address. But I believe that we do have a very good blueprint here. Yes, there is some much amendments that needs to be done to address this particular issue, and I believe that here we're at this juncture. Certainly, the executive branch, the governor, and the agency heads certainly have been given their priority marching orders in regards to do everything possible to really address this particular issue. I assume this responsibility as the chair of Health and Hospital to really you know, bring this to a full, like I've indicated in my opening statement, under my role as a law enforcement officer. I see the direct interconnect a lot of times with what's happening here. So before we go to a quick break, I wanted to ask the Commissioner of Health for her to give us an update of the Anna's Hope site, and also for the mobile substation, mobile vans to go out into the community. If she could just really just go over that real quickly, and then we'll take a break, and then I'll come back and open up the floor to my colleagues for questioning.
Okay, before I do that, I just wanted to say that Judge Willack spoke about the Trailblazers, and ever since I've come into the Department of Health, he has actually been someone who has been a trailblazer for behavioral health throughout the territory. So I wanted to recognize him in and of itself. And in reference to Anna's Hope, I'm actually going to turn that over to DC Steele, because he went on a visit at Anna's Hope 2 days ago. We do have some thought processes on that, and he has a really good update on the vans. DC Steele?
All right, good morning. Yes, pertaining to the Anna's Hope, as Commissioner mentioned, I had the pleasure to go and do a site visit with the Department of Property and Public Works, The Anna's Hope facility, unfortunately, will not meet the needs currently for what we envisioned. It is, of course, formerly a detention center, and it does not meet the updated standards of care for behavioral health patients. It is not a therapeutic setting. It is isolative. The wings are separated by 4 quad units of 3 beds. The rooms are not situated to provide a therapeutic environment. It actually would possibly re-traumatize some individuals that's placed in that facility. There's no adequate way to monitor all 12 beds with the nursing staff and psychiatric staff that will be needed. And the facility just would not meet those needs and meet current codes within the industry. So we have reached out and actually in the process of meeting with some community partners who have existing structures that's readily available and ready to go. So we're going to open up that discussion to see if that would be an option, and then we will come back to this by the request, possibly the reallocation, so that we can move that funding to have beds that's actually immediately available, as opposed to the long-term project for the Anna's Hope. Pertaining to the vans, for the mobile crisis vans that we will discuss sometime, they're actually, as of Monday, they're on their way down to the port of Everglades in Florida. We were assured by the vendor if they make the vessel by next week, Thursday, they'll be in the territory the first week of March. Then those the vendor who will build those units will come down and conduct a full training on those vehicles so that the behavioral staff will be able to properly utilize them.
And if you could just explain the vehicles or the vans. Those are three vehicles that are available for each of the island. Can you just talk a little bit about the van?
Yes, correct. There's 3 vehicles that was ordered for outreach and behavioral mobile units, one for each island, including St. John. The St. John vehicle is just a 31-foot setup. The 2 other islands have the 37 footers. Each one of those units are decked out with space for de-escalation, for crisis prevention. There's a space for the psychiatrist to see patients in the unit. There's a nursing table set up for physical evaluations if need be, so they'll have a comprehensive assessment. It's fully set up for communications and could actually provide telehealth services right from those modular units as well. And so we take everything into consideration when we design those units to make sure it's truly a self-integrated mobile unit for behavioral health.
Very well, thank you. I just want to say that in regards to your comments on the Anna's Hope site, that in fact we know that there was sufficient land there to be able to do a additional build out, and we were hoping that that was going to be the temporary facility because it was in fact designed under its current structure, of course, for detention center back then. However, there was some tremendous amount of work that had gone into it to really look towards bringing home some of the individuals that we had in institution abroad, you know. So there's a lot of work that had gone into the preparation of that. I am not going to stand in the way of it. However, I need to make sure that we have some definitive timeline by which you'll be coming back to this body, because we're the one that moved the legislation, provided the funding for the Anna's Hope site, and if we're moving away from that, then we need to know what the plans are, and be comfortable in ensuring that we will meet the needs that was established by this legislation to move that forward. So I'll be very interested in seeing what is it that's being proposed at this time, but we can't continue to delay this. We can't continue to kick this can down the road. You heard from all of the testimonies today the urgency in this particular matter. This is a priority issue, and whatever we do, we need to make sure that we're moving post haste to address that. So thank you for your update on that. While I'm not totally pleased, I think that is something, a workable proposal, and I'm interested to see what is it that you're providing, because at the end of the day, we want to make sure that we're providing an institution for the behavioral health population that they could use in the immediate future. So I look forward to that discussion. At this time, we'll take a 10 minutes refresh break after those long testimonies, and when we come back, we'll be opening up the floor for a round of questioning by my colleagues and I. The Committee of Health, Hospital, and Human Services stands in recess for 10 minutes. since you're third. We're out of recess. Again, we're in the Committee of Health, Hospital and Human Services, and today the committee is vetting the proposed legislation to enact and establish the first Behavioral Health and Developmental Act, a proposal sent down by the Honorable Governor Albert Bryan Jr. We'll be going to a 7-minute round, and we have heard from 9 testimonies thus far and the various stakeholders. And the order today, we'll start off with Senator Francis Heiliger, Senator Blyden, Senator Sorrell, Senator Gittins, Senator Carrion, Senator Fred Gregory, Senator James. Senator Francis Heiliger, you are recognized for your 7 minutes at this time.
Good afternoon, everyone. How are you?
Good afternoon.
Couple of things. I was very excited to come to this meeting today because I was looking forward to learning a little bit more about this piece of legislation, potential legislation that was sent down by the governor, over 100 pages. But as I sat here and listened to all of the testimony, and I heard many of the governor's cabinet members the governor who sent this down to this institution, as I listened to many of his cabinet members speak about all the things that they saw potentially wrong or could have been altered or could have been changed or should be changed, the question I want to ask the testifiers first, did many of you have any conversation with the governor in regards to the creation of this bill? And if the answer is yes, why weren't all of these changes and suggestions and potential amendments not mentioned to him so that we could have had a much more conducive document to work with?
Senator, is that question being posed to anyone in particular? Or?
Well, I said to any of the cabinet members because as a senator, I am sitting here trying to do my very best. And as these testimonies pop in one by one and my staff run upstairs to hand them to me, and I'm trying to keep up and understand what all these changes and amendments are. If the governor sent this to this body, all of these suggestions and changes that were made, I'm trying to understand if the very cabinet members that are here, did they have conversations with him in the creation so that all of these changes and all of these amendments and all these things they're saying is wrong with the document could have been altered before it was given to us? That's what I'm trying to understand.
Senator, this is Commissioner Encarnacion from the Department of Health. I'll
Yes.
begin by saying that indeed you do hear a lot of recommendations coming forward towards the bill. In my testimony in particular, I did ask for the indulgence of the senators, as it is definitely a fluid, fast, evolving bill. It's something that we've been waiting for a long time. So yes, discussions have been had, but I think that along with the research, with the experts that you have on the panel today, along with community members, it is actually something that it provides us an opportunity to share our ideas even further and to better build upon the bill. And even the governor and his office recognizes that it's going to take a few turnarounds before we actually come to a conclusion of the bill, but that it is a critical bill to help us to get to where we need to be in terms of managing the behavioral crisis of the VI. So thank you for that question.
Thank you. Anyone else?
This is Commissioner Kazi Gomez. Good afternoon.
Thank you.
I kind of want to Good afternoon. This is Commissioner Kazi Gomez. I think that this is a really great start, and I do. It's an enormous bill, but it gives us a good platform, a good starting place. And so I think that presenting it to this body, even though it's not in its perfection or perfect form, is still a good place to start with the discussion. So for me and for Human Services, I'm happy to at least have the honest conversation with you, Senator.
Thank you. Well, I want to say something before I jump into my questions quickly. You know, I do agree that it's a pretty extensive bill, and I think it's an excellent start. But I also think as an elected official, I too should have had the opportunity to really indulge in all the testimony that's here and recognize and really had an opportunity to go back and research and look at some of these ideas that you guys have shared today. One of the things that concerns me as a senator in this institution, this is my first term here, is I am consistently inundated with testimony and information during the time that I'm sitting here. And I don't know if it's a responsibility or a fault of us as the first branch of government to make sure that some of this information is provided to us, whether even 24 hours or 72 hours beforehand. But in order for me to do the very best on behalf of the people of this territory, all of this information that was popping up today while I was sitting here, I'm just requesting, even through the chair of many of these committees, that we do be provided this information in advance. And I know as testifiers, you come before this body, and I have heard prior that it's a lot of work, but some of you had 3 weeks to prepare and give us this information. And it's a disadvantage to me and to the people of this territory to be getting this information literally sitting here on the floor. One of the things I want to ask quickly when it comes to Commissioner Brooks, are you there? I think it's the Assistant Commissioner. Is he still here?
Yes, good
Hi,
morning,
how are you?
Senator. Good afternoon. My apologies. I'm still here.
Your testimony, page 2, number 1. I want to ask a question. Why does the VIPD doesn't have policies in place as it relates to that? How do you deal with the procedures in recognizing individuals that have disabilities or developmental issues when you're dealing with them?
Well, as mentioned in my testimony, VIPD, we do not arrest persons for mental capacity issues. We simply escort them, take them to the hospital as outlined for treatment. Once they're identified, we receive a listing from the Department of Human Services of those bodies.
And
so, Echo.
Mr. Chair, I can't hear him. He's cutting off.
Please hold the senator's time. Assistant Commissioner, if you get a little bit closer to your mic, and if you could minimize moving your head so much and just speak directly into the mic. Every time you shift, it kind of cuts off.
Okay, can you hear me better now?
We can. You may proceed with responding.
Okay, yes. Yes, as mentioned, Senator, in my testimony, the VIPD, we do not arrest persons for mental disabilities. So there is no specific policy standing out. Again, we're open to suggestions. That was the purpose. We assume that we know that is the purpose of this hearing, so we can dialogue and identify ways that we can perfect addressing this issue. This has been new for all of us. Again, so this is an opportunity for us to dialogue at this level and identify ways and gaps that we have that we can address and best, as you said, support those in the community. So we always welcome your advice and support accordingly in this healthy discussion.
Well, thank you so much for that. I kind of ran out of time, but I will pick up on the other rounds. Thank you.
Senator, do you have a follow-up question that you'd like to ask at this time?
Well, I wanted to understand a little bit more in regards to when we took a tour of some of these facilities, the correctional facility, for example, over in St. Croix with the director Testamark, one of the things I had noticed that there were individuals, even with mental disabilities, moving around and intermingling freely. Have they found any issues in regards to keeping a balance or keeping them separated from the population? Or is that something that they normally do? And the reason why I know this is because one of the individuals that was there, I was a victim of a crime by this individual. So as I spoke to him and I said, hey, you know, do you remember me? And he did say, aren't you the young lady who I broke into her property? And I'm literally feet away from him. And he said, but you were always nice to me. And the reason I was nice to him is because I recognized that even though he committed a crime, he was dealing with a mental disability. And as much as I tried to help him through his mother and call the different agencies, I see him in prison now. So I was wondering what type of help people such as himself is getting when it comes to mental disabilities and being inside of prison at the same time.
Very well, I'll have the Director of Testamark respond to that.
You there?
Director, you seem like you might be on mute.
Yeah, we can't hear her.
I'm sorry. Hello, can you hear me?
Yeah, we can. Go ahead and respond.
We can.
Sorry
Go
about
ahead.
that. Yes, those individuals in which the senator is speaking of, they're in a segregated unit and they're locked down for their own protection, so that others don't prey on them. However, the individuals that's on the mental health caseload that's in the jail, yes, they do get the care that they need. We have psychiatrists not on staff but on contract, and we also have mental health counselor and professionals that's there to assist them.
Okay, the question I was asking is because the individual that was in the prison, if you have ever, I'm not going to call his name, but he does have a mental issue and he was moving around the prison freely. He was not under lockdown and he has a very long, extensive rap sheet, and he is a perfect example of individuals that go into prison and the prison released him because they cannot really house him. So I'm trying to understand what was the difference now with him being incarcerated as opposed to let go about 15 times before because of his mental issue, and is he getting the type of help? How do we deal with them? Because he clearly was not under lockdown.
Right. And it's funny that you said that because the goal is not to keep them locked down. The goal is to give them the help that they need, medicate them. When you think through, the individual apparently is medicated and he's manageable. So once they're manageable, there's no need for us to keep them locked down. They're allowed to come out, they're allowed to watch TV and intermingle with others.
Well, I'm glad you added that because initially when you said they were under lockdown, I was a little confused. But thank you so much for the clarity.
You're welcome. You'll have another opportunity, Senator, that you could drill down further in the next round. Thank you. Senator Blyden, you're recognized for your 7 minutes.
Thank you. Thank you so much, Mr. Chair. Good afternoon, colleagues. Good afternoon to the listening and viewing audience, staff, central staff. Good afternoon, testifiers, and thank you so much for your comprehensive testimonies. I must say, after 3 hours of listening to testimonies, that's a lot of information, but good information. And I want to start by basically commending the administration on the intent of this piece of proposed legislation as it seeks to address the long-standing need for comprehensive action regarding behavioral health in this community, and the lack of service and facilities for persons who have behavioral health issues is a serious blight in our community. And as it has been said many times before, the strength of a community can only be judged by how you address those that are in need of your assistance, especially the most vulnerable, which means in this regard, in my opinion, that we are failing when it comes to mental health, miserably. And as such, any effort like what we are trying to accomplish right now to address these issues is a positive way forward in supporting our community. Even though I support the intent of this bill as proposed, I have some concerns, like all of the testifiers put on the record today, especially when it comes to the language and if we can accomplish the task at hand, especially when it comes to the proposed funding source, which I think is an unfunded mandate, because we know the casino revenues since 2014 on an annual basis, we have never collected more than $263,000 on an annual basis. So at the same time, though, I'm happy, based on the testimonies on all of the different amendments and recommendations that have been shared with us this morning, I am happy to state that I am sure that we can all come together and come up with the funding source, and the amendments that were offered and recommendations are on point. And I want to thank the testifiers truly, because they are on point. But the only problem is communication, collaboration, and basically coming together, because with the administration and all of the different division departments, they're on point with their recommendations. But those recommendations and amendments should have been brought forward as one, in conjunction with the non-for-profit like NAMI and others, because I must say on the record, NAMI is on point. NAMI's inquiry is on point. Their testimony really hits in terms of hitting a nail with a hammer. Dead square down the center. I must say, though, that all of the departments made good recommendation. When it comes to the Department of Health and the training aspect, especially for police officers and correctional officers, I do agree with that wholeheartedly. And also, it was spoken in the testimonies, whereas we start in terms of recognizing the issues from a young age. That is critical also, because it is said that in NAMI's testimony that up until the age of, it is said in, I believe, the Department of Health testimony with the CHIP program, those funds are there to assist individuals in mental health, but if we don't catch them at a younger age, from the time they hit age 21, you can no longer assist those individuals. So it all intertwined with each other, and it all makes sense. So let me ask a few questions moving forward, because it's comprehensive, it's a lot, it's so much information, but nonetheless, we must cipher it out and basically move forward. Commissioner Encarnacion, good afternoon.
Good afternoon, sir.
Let me ask you quickly in terms of your department, and when it comes to individual with mental health and other ailments, in terms of record keeping and basically assuring that those records are kept confidential. And for instance, if someone comes forward and has a situation with your department, right, and they are seeking help, and they need those documents in order to get the assistance they need, is there any way those documents can be lost without having a backup, etc.? What's the procedure and what's the process with your department?
To be open and honest about that, you know, we had a hurricane 3.5 years ago, well, 3 years ago, basically, and a little bit more than that. And we did have some records that were destroyed. And so actually just received a call yesterday morning, actually, and spoke with someone who indicated that they were looking for records for, I think, one of their parents. And so we're tracking to see exactly where and looking at the records that were destroyed because of the hurricane, and ensuring that we can actually provide some information to the ones that are looking for records. Going from here, we have been working on fully operationalizing our IT system and the Division of Behavioral Health and Alcoholism and Drug Dependency, so that everything can now be electronic. So we do not, and actually basically in the cloud, so we don't have to depend on paper charting in the future. So that's really where we're going now. So we will be speaking to individuals, we will be tracking, and Assistant Director Callender, Deputy Commissioner Steele has assured me that tracking of those records will be brought to my attention in short time. Thank you for that question, sir.
Thank you so much, Commissioner. Good afternoon, Ms. Paxson. I must again commend NAMI of St. Croix, which is a grassroots organization here in the territory. You mentioned in your testimony that there can be an estimated 20,000 plus Virgin Islanders that may need behavioral health care services here in the territory. Would you say we have a mental health crisis here in the territory at this time?
Good afternoon, Senator. This is Sherlyn Pogson, NAMI St. Croix. Yes, absolutely, we are in the middle of a crisis. We are not even sure, because obviously we're using national numbers. That's just simply an estimate. And if we don't know, especially what's been happening with the pandemic, who knows what we will uncover in the next month, year, when it comes to persons that are really trying to manage their mental illness.
So, since the hurricanes, have those numbers increased? Have you seen an increase in cases from your organization?
Not specifically increased. What is happening is there are individuals that are certainly being, I think they're being more open because of what happened with the hurricane, and then now what's doubled with the pandemic. People are being more, they're disclosing their concerns more. So we are seeing that, but there were individuals that they had made mention of in the past of their condition. So I think people are certainly within our group, they are seeking more support, but it's usually it ebbs and flows.
Okay, well, I want to thank you for that. I know my time has been called, Mr. Chair. I just have one follow-up question. In terms of protections for persons with developmental disabilities, what type of services does your organization provide for those type of individuals?
For NAMI St. Croix, we do not support individuals with developmental disabilities. That is not our area. We work specifically for persons diagnosed with a mental illness and their family and caregivers, friends.
Well, I want to thank you for what you do. And again, I hope that you are at the table at the end of the day when it comes to this proposed legislation moving forward, and all other individuals who testified today, because all of your input is very important. I want to thank you so much, Mr. Chair, for the time.
Thank you very much, Senator Blyden. Before we move on, I'm not sure, I know that Senator James have been here for some time now, and we went right into the questioning period, but I just wanted to recognize Senator Javon James, non-committee member, for being here this morning. Also, Senator Whitaker, welcome. Thank you for being here as well. Next, we'll go to Senator Sorrell. You're recognized for your 7 minutes.
Thank you, Mr. Chair, and good afternoon to all. Assistant Commissioner Brooks, let's go right into it because I have like a million questions. So right now with the bill places the onus, a lot of the onus on law enforcement officers throughout this 117 pages. So the question would be, in the absence of officers being trained and the time that we want to roll this bill out, does this place the police department in a position to violate the consent decree?
Thank you for that question, Senator. Now, as it stands right now, we've been in a consent decree for somewhat of 10 years. And at this junction, we have not had that issue come up. The officers do have a level of training at the police academy. They do 24 hours. And I'll have Deputy Commissioner Warren extend on that, if you may.
So you're prepared now, if this bill is passed in the near future, to act accordingly, because a lot of onus is placed on the VIPD, and we don't want the consent decree to extend any further. So you're saying that you're prepared to take this responsibility?
I'm saying that we will welcome any additional training that will come to better prepare our officers. So should the bill be passed tomorrow, again, we will consult with the subject matter experts here in this forum, i.e. the Department of Health, Department of Human Services, to get add some additional extensive training relative to handling these persons. in the best possible way.
Okay, good. So that's a concern for me. Let's go to funding source. I know we don't have OMB here, but Commissioner Encarnacion, the funding source is, much of it is the casino revenue fund. Does that, that reallocation of the casino revenue fund, does it impact any other, would that, what do I want to say? How do I word this? Would the reallocation of the fund, would it impact any existing programs, mental health programs that we currently have?
No, the funding source, I think that the bill actually encompasses everything. So that funding source, along with the supplemental that we requested, we would be able to provide the wraparound services that the bill is actually asking for.
Okay. Now, let's go to in subsection 1015, you create a 7-member board, and that's something, I'm happy that NAMI touched on it because that's one of the things I noticed in the legislation. So you create a 7-member Citizens Advisory Council on Behavioral Health, Alcoholism, Drug Dependency, and Development Disabilities. But Act 8152 already established an advisory board. Is the intent to duplicate, to work in conjunction, or to repeal Act 8152?
As I stated in my testimony, the reference is to repeal, and I think the Attorney General indicated the same thing. So it's not to duplicate efforts in and every way. We actually do have an interagency board that works on a monthly basis to address issues like this. So it really would be rolling over what we have right now.
So the intent is not to, duplicate, but to, okay. Let's go to subsection 1020, where the administrator of the approved treatment facility can refuse an application and certificate if they fail to sustain grounds for commitment. Is that the intent of that section?
DC Steele, can you take that and for me, please? Give me one. Deputy Commissioner Steele will answer your question, ma'am.
Subsection 1020F specifically. And
1020F.
while you look for that response, let's move to Commissioner Encarnacion. Let's go back to you for a second. So,
Time just
so
Can
NAMI,
I get a few minutes, Senator, please?
okay, you have time, so Commissioner Encarnacion, I think you'll have to respond to this question, but NAMI, in NAMI's testimony, let me not say NAMI, Miss Parks.
Senator, in the section here, and it's probably not clearly defined in the definitions, but the administrator and director of that public treatment facility, as identified further up, is being regarded as a physician or individual who could make clinical determination. So while it's worded as administrator director, that person actually would have clinical capacity, but it would be in conjunction with the assessment team or the psychiatrist on staff.
So I understand.
There's definitely a change in the wording there.
So I understand the correlation, but is your intent to have the administrator director have the authority to refuse an application if they fail to sustain grounds for commitment? Is that the intent?
No, that's not the intent. That's where the correction would need to be made.
Okay, so 1020F, okay. So Ms. Paxson, in her testimony, said the exclusion of a defined early identification and intervention program for children and adolescents is a concern. Now, in the Women, Children, and Families Act that was passed in the 33rd legislature, Section 1 says, behavioral health screening of children, pediatric practitioners in private practice, those employed by not-for-profit corporations, and it goes on to talk about them may at least biannually perform a behavioral health screening as part of general pediatric wellness examination of children between the ages of 3 and 18. And it also concludes by saying that the screening will include a test of the child's development, cognitive ability, and general emotional and social well-being. And the screening may be conducted through behavior rating scales, standardized. So basically, there's a behavioral health examination, and if that pediatric practitioner notices some changes, then they'll refer them to the trained professional. How have you incorporated Section 1 of the Women, Children, and Families Act to address the concern of Ms. Paxson and her organization? or have you even linked it? Commissioner Encarnacion? Ms.
Yes,
Parks,
Senator, one of the things that we've done is that we've actually begun a program in the Women and Children's Division, and Dr. Charmaine Mayers is here today. Can you address that, Dr. Mayers, so that the Senator can see how we're actually working with children with behavioral health capacities?
Yes, hi, good afternoon, everyone. Charmaine Myers. The Maternal Child Health Program has the VI Project Launch Program that is under that division. And that program focuses, it actually has a dual focus on infrastructure development and delivery of services and supports that promote young children wellness and healthy social and emotional development. Of course, it is our plan to infuse mental health informed practices into primary care, early care and education, home visited and family settings. Yes?
Ms. Mayers, please put on your camera.
So the question would be,
go ahead.
The question would be, do you intend, with your indulgence, Mr. Chair, do you intend to, so I hear the unit, but the concern from Ms. Parkson for NAMI is that it excludes a defined early identification and intervention program for children. So is the intent of the bill to have a standalone component for mental health or behavioral programs? Is it to be separated, or does the department intend to include that in the legislation? I understand what you do. I just wanted to know how.
Yes, it will be included, but the program is already the Project Launch program is an intervention program, and it is the intent to include it in that legislation.
And lastly,
also, Senator, we in the legislation, it speaks to an interagency council that addresses it, and we focused on the fact that even though health may be one of the leads of it, we have to have Department of Education as well as a team of individuals who are actually making that decision. So it's not one entity, and that team should be meeting at least on a quarterly basis. So we did edit the bill to be inclusive, to include that concern.
thank you, Mr. Chair. I don't want to abuse the time. You gave me enough already, so I'll follow up in the second round. Thank you, Mr. Chair.
Thank you very much. I know it's a lot to manage today, but we will have a second round on this matter. But before we go on to the next, well, let me just go ahead to Senator Fred Gregory. You recognize for your 7 minutes.
Thank you, Mr. Chair, and good afternoon, colleagues, and good afternoon to the testifiers. I just have to say that I am, while this is a good start, there is so much work to do around this legislation. We need a robust bill that mandates cross-collaboration. And too many times we have good intentions and we move legislation forward, but at the end of the day, it really does not, suffice for what really needs to occur. And let me just take this opportunity to as well, thank the Attorney General George, Commissioner Encarnacion, Commissioner Gomez, and Assistant Commissioner Brooks for their candor. But what is a bit disappointing, just from my experiences in working in government, is, we have, 4 departments under the executive branch that came before the legislature today, and a major piece of legislation that, has far-reaching, actually, legislation, and, all of you came with your own perspective. And I think we need to remind ourselves that if you are in the executive branch, then there must be some collaborative effort as it relates to, major legislation like this, or any legislation that comes before the legislature. Commissioner Encarnacion, is there a decision around this bill that there would be some review committee so we could get something that we could really work on together as the executive branch as well as the legislative branch? So I'm going to start there.
Excellent point. We actually started that late, but we did start that. So we actually pulled a few people together on Department of Human Services, actually the Office of Disabilities and VIPD. And we have begun that discussion. We'll pull more individuals in. The AG and I have had discussion. Department of Education, Commissioner Barry Benjamin and I have had discussion. And so you're on point. And so we have begun, but we have to be a little bit more robust. And yes, I agree, that has to take place and then brought back to you.
Thank you. One of the other things that's disappointing in all of the conversations that I heard today is the fact that there was no mention of the Virgin Islands Virtual Information System. And I continue to talk about it, and I believe one of my colleagues, the good Millennium Senator from the St. Thomas St. John District, she moved that legislation, I believe, in the 33rd, and it was vetoed. Did we override it? It was vetoed. And that legislation was a piece of legislation that requires data to be provided. For instance, my good colleague, the millennial colleague, spoke specifically earlier about the legislation that she moved in the 33rd. And if we are not collecting data, I'm not certain how in the world a legislation of this magnitude will even be effective. You know, we heard Assistant Commissioner Brooks talk about, you know, all of the percentages from the data on the US level. But he was not able to share any information as far as the data in the territory. So let me ask, Commissioner, do we have data in the US Virgin Islands around our...
Behavioral health?
Yes.
So we actually started to collect some data, and it actually occurred after the hurricane on the CASPER report, Community Assessment of Public Health Emergency Response data collection that was done through the help of our epidemiology department, but more so, we are actually pleased to have a part of our team now, Dr. Janice Valman and the team at the University of the Virgin Islands. So we have that data, and we can actually send you a copy of that so that you can see in terms of percentage. Dr. Valman, if you have recall of that data and the percentages.
No, I don't need it right now, Commissioner. I don't need it right now.
Okay,
I'm trying to drive home a point. So I want to go back to VIVIS. I want to go back to VIVIS, the Virgin Islands Virtual Information System. A $2 million grant was awarded to this territory sometime, I want to say, in 2010, 2009.
2050.
No.
2050.
No, that was the additional funding, because I recall when I served as commissioner, we did a lot of work on that. And there was a VIVIS committee that was comprised of the Department of Education, the Department of Health, the Department of Labor, the University of the Virgin Islands, VIPD, Department of Human Services, etc. All of the agencies that would impact what we will call cradle to grave here in the territory. And one of the things that was supposed to happen that we continue to get pushed back on was the entering of the data of every single child that was born in the territory into that system, and all of the other data with human services, et cetera. So when a student gets into the classroom and a teacher identifies that there are issues with that child, he or she could go back, look at the data, and you will see that X student has Y cognitive issues as to the reason why they are behaving the way they are or whatever the issues are. Let me ask you, and I'm going to ask yourself, I'm going to ask the Commissioner and Department of Justice, is that system being used? $2 million, and I believe that the Department of Education, not I believe, I know, that they are still utilizing the system. So I'm trying to understand whether the systems are talking to each other and we are in fact inputting information into it, because all of this that we talked about today briefs well. But if we are not following our children, then we are never going to be able to figure out exactly what our challenge is here in the territory. So are we using the system, Commissioner Encarnacion? And it's just a yes or no.
No, but I need to just if the time can be or some, we need to explain. eCivis was actually linked to a company called Genesis, And we recently, the contract with Genesis expired in 2015. That's the date I was looking for. And so we're now trying to get back into a contract with the company since that contract was expired. And so we're working towards that, but interfacing is one of the things we're trying to do with it.
So you're not using a system. Commissioner of Human Services, are we using the system? Are you entering data into that system when you have challenges, when youngsters, young people come to Human Services for services?
No, ma'am.
Yeah.
We're not.
VIPD, are we using Vivis?
Not to my knowledge, ma'am, no.
Attorney General George, are we using Vivis?
Not that I'm aware of, and I can certainly get back information to you with respect to that, but I am not aware of that.
See, this is what happens when we put all of these funds into all of these different systems, and then we don't use them, and then we have these robust bills that talk about all the things that we can and cannot do. But from my perspective, and I'm certain from the perspective of my colleagues, we need to identify root cause, intervention, and then figure out how to resolve the issues that we have. And that's treatment. And let me just ask, I have some notes here. Let me just ask Commissioner of Human, my time is called? Oh, I'm sorry.
You have a follow-up question, you may.
Yes, let me just ask this quick follow-up question. Do you find in the particular bill, just in reading the whole bill, because I have so many questions, but of course we can't do all of this in one fell sweep, right? Do you find that in this particular legislation that we are conflating mental health, behavioral health issues with developmental disability?
Is that a Human Services question, Senator?
It's for Department of Health. It's for Commissioner Encarnacion and yourself. Both of you could respond.
I think it's a large bill, and I think that there could be cause for confusion if you include both.
Yes.
So if it is included, we have to be, the definitions, going back to what Attorney General George said, was that the definitions have to be very clear in order for us to understand.
Commissioner Encarnacion?
That's why we actually put in the definition of neurodevelopmental disorders versus disabilities, so that we can focus on what's going on from a mental perspective and socio perspective versus a physical perspective.
Thank you, and Mr. Chair, thank you for the time. And I'm going to leave by saying, because I'm not certain that I will be here for the second round, but I will leave by saying that this is a very, very important piece of legislation, and I will be very happy to have a seat at the table so we could flesh this out. Thank you for the time, Mr. Chair.
Thank you very much, Madam President, and thank you for your comments in regards to having a seat at the table. I think all 15 of us are really instrumental in moving this legislation forward. It impacts every segment of this community, and it's critical that everybody have a seat at the table. So thank you for that. Before we move on to the next Senator, I wanted to ask Commissioner Encarnacion, we have many new groups, boards, networks requiring administrative, bureaucratic red tape, quorum forming in this particular bill, right? How do we remove those issues and the bureaucracy to allow for the issues confronting mental health and behavioral health to move forward outside of those bureaucracies and red tape? Because again, we want to make sure that we're getting into the trenches and meeting the need of our community.
Well, I think that one of the things that we've been missing in all these years past is the fact that, and I'm a big believer, and if you don't have one person or one entity focusing on the issue, and you say that everyone is focusing on the issue, then nobody really isn't. And so I think that's one of the strengths of this bill, is actually bringing everyone together and figuring out really where we need to go. So I agree, it's a big bill, it's a lot to do, but we actually need to be able to sit down to the table and figure out who's responsible for what. Let's get it onto the table and then make those decisions, and then we go there. Right now, there are overlapping responsibilities, which I think will remain, but where does regulatory come in? Where does operational come in? Where does clinical functions come in? I think that will be something that's presented at the table and the decisions made there with the right people at the table.
Very well. Thank you for your response there. We'll certainly do a further deep dive at the appropriate time in that matter. Senator Gittins, you recognized for your 7 minutes at this time.
Thank you, Mr. Chair, and good afternoon to all. I truly welcome this conversation here today, as it is indeed a crisis here in the territory. Just like everyone else, I was a bit baffled earlier listening to the testimony, wondering where is the collaboration between the agency and the administration in getting this measure down here. That's neither here or there now. We are already here, but I thought I would mention it. But I want to also say that we can't continue to kick this can down the road. This is a major, major problem, as we lack even the facilities to put these individuals. I heard mention earlier of the Anna's Hope Detention Center. And every time we have this discussion, I'm wondering, what's the status of the Anna's Hope property? From the 30th legislature, we've been pushing to utilize that property that just sits there now overgrown. I didn't hear the response earlier with regards to Anna's Hope, but could one of the agency heads tell me what's the status of the Anna's Hope property, please?
Deputy Commissioner Steele would respond to that again.
And that's of which agency?
Hi, good afternoon, Senator. Yeah, as earlier discussed, we had the opportunity to do the walkthrough of the Anna's Hope property most recently in the last 2 days. This was my first direct contact with looking at the facility, and the facility is not adequately equipped on that same existing footprint to provide the therapeutic services. It's not set up as such. It's very much set up as an isolative setting because it appears it was a detention or a prison system. It doesn't provide the layout for accurate monitoring of psychiatric patients in a subacute setting, so that would become a hazard as well. And the understanding is if it was to be rehabbed an existing footprint in that current location, that would not be an appropriate setting for our behavioral health patients.
So, Deputy Commissioner, I'm not blaming you or any individual. You know, today ain't the time for the blame game. However, you know, it's a little frustrating when we've done so many walkthroughs of that place. The place was overgrown. I'm surprised that you were able to do a walkthrough the other day. That means you probably just cut the grass. But what sickens me with this government is that we could spend money on all kind of things except what we need to spend money on. Now, the retrofit that we're talking about, we retrofit in people private business where we renting money, and we can't retrofit our own property. Something ain't wrong with that, colleagues. Something ain't wrong with that. We have access to not millions, but billions of dollars now in this territory through what? The CDBG grant funding, through FEMA funding, through COVID funding, all kind of funding coming from all over the place. And we prefer to retrofit somebody private property what we need, and paying a whole year rent what we ain't even occupy yet. Something is grossly wrong. That is my frustration, administration. We got to get moving. It's time to stop kicking the can down the road if we're really serious about this. We've had incidents where these individuals are hurting innocent people, standing in restaurants, sitting down outside in parking lots. What are we waiting for? For one of us to become the next victim? These individuals need help. The first responders, the police officers who we put in on the front line, they too need the assistance. That was a one frightening task when I was a police officer. Because when we go to address these individuals, our mandates was to disarm ourselves before engaging any of these individuals. One time in the Walter M. Hodge pavilion, known as Safarelli, one of these young men actually took a door off the hinge and threw it down the stairs at us. We got to get serious. We have these monies in the territory. Let's put it to good use. Let's do the proper planning. Again, the 5 Ps, proper planning prevents poor performance. I don't know how much time I'm going to have to sit here and say the same thing, but the legislature surely can't sit here and legislate and execute at the same time. So we need the executors to engage and put the vehicle in motion. Please, not another term, not another year should go by where we're just talking about Anna's Hope Detention Center. That place have been abandoned for many, many years. So let's get it fixed. It belongs to us. We don't have to rent it. Which brings me to ask the Bureau of Corrections, how many inmates with mental illness do we have incarcerated at this time, whether here in the territory or outside the territory? Bureau of Corrections,
That
not
question-
there?
Please hold the senator's time while we get the Bureau of Corrections up. Director Testamart. Unmute your device.
Director Testamart, can you hear us?
Yes, I can hear you. Could you repeat your question?
How many inmates with mental illness or detainees do we have currently in the institution, in the territory and outside the territory?
Currently, in our population that we have here on the island, in the territory, 40% of our population is on a mental health caseload. Outside of the territory, in the mental health institutions, we have a total of 15 individuals.
Okay, you're telling me 40% in the territory and 15 actual inmates, and I beg your indulgence, Mr. Chair, and 50 inmates outside the territory. What is the 40%? What is the number?
40%, 1 second. Let me give you the actual number. That is 75.
We have 75 inmates right now in our local jails that have mental illness?
Yes, sir. That's on the mental health caseload.
What's the cost to hold those 15 inmates outside the territory?
They currently it's $475 a day to take care of 14 of those individuals, and we have one that's a special need. The cost is $576 a day, and it does not include any additional medical.
The $475,000 a day is for one inmate, or
No, $475 a day per individual.
I'm sorry, repeat that?
$475 a day the territory pays to take care of a mentally ill inmate for the 14. However, we have one that's a special case. He requires a little bit more care, and his case $575 a day.
Okay, I guess I'm trying to, okay, I heard you now $475 a day.
Per person.
Not thousand.
Yes.
But
No.
is that per prisoner or the 15?
That's per individual.
Wow. Thank you, Mr. Chair. We could see how much money is we spending outside the territory, and I'm saying that we need to watch our dollars and cents and make the dollars and cents make sense to us. Thank you, Mr. Chair.
Absolutely. I don't know if Judge Willocks want to weigh in on that particular. That's what I was just about to ask if you want to weigh in on that particular issue, because I know that we have had many conversations in respect to that. You would like to weigh in on that?
Are you speaking to me, Senator Francis?
Yes, Judge.
Yeah, good afternoon. Maybe I should bring some clarity to this. The Anatole facility was one that was conceived between myself, the late Attorney General Swan, Dr. Hendricks, Dr. Kennedy, a forensic psychiatrist out of University of Chicago. I always thought that the purpose of that, like what Senator Gittens was getting at, was the first phase where we're going to use that at the forensic facility. We're going to bring back those who are in the States to that facility, or those who were violent or perceived to be violent inmates. They would go to the out-of-the-soul facility. Preferably, we would bring those in the States back to that facility. The savings then would go to construct another facility, which would then house what I think Mr. Steele is referring to. And I think that maybe there's some, I don't know if there was a change or whatever, but I think that was the perception that we were all that I was going on with for all these years. So the actual first phase of the fourth phase was to actually bring that out. We were a month away before the Honorable Swan died. We were a month away from opening to just bring back those who are in the States. So I don't know if there may be a miscommunication and Mr. Steele was looking at it for some other reason or some different reason. But I think I've had conversation with Director Testamont and others to try to get assistance, getting them from underneath the federal by using that facility as more of a placing them in that type of facility. So I would just ask for clarification if that's what Mr. Steele was looking at, or you were looking at it for some other facility, what type of facility?
I think Commissioner Encarnacion, you want to address that matter, because that was my understanding as well when we moved the legislation and my colleagues supported. I moved the legislation and my colleagues supported to actually do the build out of the Anna's Hope site while contemplating, and $3 million were provided for that additional build out. So I'm hearing 2 days ago there was a decision made to move in a different direction. So I wanted to know from Commissioner Encarnacion, you wanted to address that?
Clarification. What you heard from Mr. C was his recommendation based on what he saw there. It really and truly no decision has been made. That's just a recommendation based on a review that he did along with, we're actually looking at A&E firm to be with the help of property and procurement and our project management office in Department of Health. They all review the area, and that is actually the recommendation coming out of there. No decision is being made. And so any recommendation coming forth will actually be submitted to you in a formal fashion. But like we said, today is a day where we put things on the table and we come to what we need to decide on what's best for the community. So that's kind of like where we are. We actually have a need, not just for forensic care, but really and truly acute step down long-term care. We've all said that the facilities really and truly need to be there and the services need to be provided. When we finish, I'd like to give an update, though, on where we are in terms of building facilities within a territory, Senator.
Well, I'll give you an opportunity to do that. I'll give you an opportunity to do that. So, let me recognize Senator Gittens real quick for a point of inquiry. Senator Gittens, you recognize?
Point of information.
Point of information.
Thank you. So, over $7,000 per day for inmates, over 2.6 million per year for housing them out of this territory. And what I wanted to say was, again earlier, was thank you to Judge Willocks, because just the other day I was looking at C-SPAN and saw where there's this same problem in, I think it was Ohio. And they have a program there called the Cahoots program. And that program is between social workers and police. But here in the territory, we have a unique situation now where we even have a judge assisting us. So I wanted to say thank you. And as we work innovatively on this, please let's work with the chairman on this legislation, because I know for sure when he came in here, we pushed that Anna's Hope property. So again, thank you all.
Thank you very much, Senator Gittins. Commissioner, I'll go ahead and put what you wanted to put on the record at this time.
Yeah, I appreciate that, Senator. The governor and the Office of the Chief of Staff actually is working on an initiative. It's the Healthy Housing Initiative. And in that, we actually have been conducting assessments of all of the homes that we have where we actually house individuals, Elder Shelterbrand, Human Services, Department of Health. And so we're looking at its entirety in the community, who we have off island, who we need to bring in. So that assessment should actually be reaching to us within the end of March, beginning of April. And that would allow us to know, to see, we live here, we know exactly what's going on, but it gives us, we always speak about data collection, it gives us something in writing scientifically, it leads us into a direction. So we haven't forgotten CBDGR funds are on the table as well. We've actually submitted a request. I know Department of Human Services, Commissioner Kazi Gomez could speak to what she's doing in terms of housing the elderly. So it's not forgotten, it's a conversation that's being had. Mental health, behavioral health issues are also being considered. Just wanted to put that on the table.
Very well. Thank you for that. But we can't continue to throw the baby with the bathwater. I think every time there's a new administration, we just start all over again, and we just find ourselves at a disadvantage. I think it's critical that, yes, everyone want to put their stamp as being the first, and I'm fine with that. But at least let's put in place something, because every single day we have a new fallout in this community. And we're talking about our teachers, our nurses, our government employees, all of us are only an episode away from those fallout situations, especially in this pandemic. We have our teenagers that's under tremendous stress. We got to put something in place, at least as a stopgap, until such time as we could go towards that grandiose, the bigger scheme of creating an institution. At this time, I'd like to recognize the presence of Senator Potter. Thank you, Senator, for joining us. And Senator Carrion, you're recognized for your 7 minutes.
Good morning, Mr. Chair. Good morning to my colleagues. Good morning to the testifiers. It's afternoon already, yeah, that's right. It's afternoon, and good afternoon to the viewing and listening audience this afternoon. Clearly, we have a lot to talk about today and this afternoon, but before I begin with my questions, I'd like to make a brief statement about something that I find a growing concern regarding those in our community that have behavioral health issues. And really what I want to do is make a plea to the members of our community. I have noted on several occasions now that that people are photographing and filming individuals in our community that pretty clear have some mental health issues. I want to plead, please, let's stop sharing these images on social media, on WhatsApp. I know that at times such things, some people can find them interesting and shocking, and others might find them entertaining, but the truth is that it's cruel. Not only cruel, but it's also exploiting people with disability in a way that we shouldn't do. These individuals are parents, these individuals are sisters, our brothers, our cousins, our sons, children's, they are neighbors, and we as Virgin Islanders were taught better than this. So I want to make this plea. It saddens me every time I see an image of someone that has a mental health issue and how we continue to share and make fun of it. So, anyone could have an episode of some kind, and having it shared to the world really won't help that person in its process of recovery. And we need to provide the support that they need, and by doing such, we're not providing that support. So this is my plea to members of our community: please stop sharing those images. Now, moving right along with my line of questioning, there is a mental health and substance use disorder crisis nationally, and territorially it's no different. And we definitely need to address this in a comprehensive way. And in order to do so, we need all hands on deck. And it has been clearly evident this morning by the testimonies that, unfortunately, there's not a good communication between different departments and agencies. We heard here this morning in the testimonies different amendments and suggestions that I think should have been addressed before presenting this proposal to this body. Nevertheless, we're here to work in collaboration with the administration and ensuring that our community, and especially the sector in our community that are facing or are with mental or behavioral issues, are attended and their needs are met. Commissioner Encarnacion, first I want to thank you, and I agree with you on updating the terminology used to describe those with behavioral health issues. I myself am learning the process, so I ask your indulgence, because I might use a term here today that might not be appropriate. But in your testimony, you also noted the need to have a medical detox center at a treatment facility. What would that medical detox center need to consist of? If you can share with us, please.
Actually, I have a couple experts on the panel list, so I'm going to actually ask DC Steele or assistant, who would be more? AD Calendar? AD Calendar, that is your area of expertise, can you please address that issue?
Of course. Good afternoon, everyone. As far as a medical detox center, what we're referring to is somewhere that someone can go to receive treatment when they are actively under the influence of substances, and a substance that would cause them to have withdrawal when it comes to their reduction of use. And so the purpose of having a detox facility is so that detoxification can happen in a controlled setting under the supervision of medical professionals, because there are times when people go through a detox process, and because it's not medically supervised and the severity of the symptoms that come along with the detoxification process, they can have major medical complications and at times even death. And so the purpose of that facility would be to ensure that there's medical professionals there to monitor that person and react to any negative effects that they may be having as an effect of going through the detox process.
Thank you for sharing that information. You would like to add anything else, Commissioner? I thought like you had said something.
No, I was thanking him. Excellent response. Thank you, sir.
That leads me now to the BOC director. Do we currently have inmates then that are being treated for substance abuse? And what's that number or percentage? Is the director on? Mr. Chair, can you hold my time, please?
Yes, it's being held. We have a wonderful timekeeper that engages every time, so we're good.
Is the director on with us?
Yeah, we just need to pin her. We have quite a few amount of individuals on this particular call, so it takes some time just to get her. Director Testamart?
Well, let me move on then to another question. Commissioner Encarnacion, back with you. There seems to be quite a bit of overlap, and I think we've been discussing a little bit here between the Department of Health and the Department of Human Services. Do either of the commissioners believe that we are duplicating efforts? And let me ask you this. Is any restructuring necessary in terms of delineating exactly what the duties are? And would it be beneficial for the territory to consider at some point combining both agencies just as they are combined at the federal level? So I would like to hear your thoughts from both of you, Commissioner Gomez and you, Commissioner Encarnacion.
Good day, Senator. That's a loaded question, so I appreciate that. So first and foremost, is there a duplicate effort? I believe was the first question. I think there's some overlap, but I'm not sure if there's duplication necessarily. There was a tri-agency agreement that was established in 2005 between the Departments of Education, Health, and Human Services, specifically for children and youth that couldn't be educated within the Virgin Islands and needed some facility aspects. And so that's in our budget. That responsibility comes to the Department of Human Services. And so that's a variety of reasons why children and youth are replaced off island, but I said that a little bit in my testimony of the reasons why. Second question, I don't know, and Commissioner Encarnacion, did you want to answer any of that part as far as the duplication?
Well, I think that there's some activities within Human Services as well as in health in terms of infants and toddlers and MCH that we work together on. And so wouldn't say that it's an overlap, or I think it's just our programs actually call for specific responsibilities. One of the responsibilities that health has is a regulatory aspect, and I think that wouldn't be an overlap. It would be more of a compliance in reference to what's being done outside of health. But health has specific requirements under Title III, as well as we have WIC and infants and toddlers. So I don't think it's a duplication of efforts, sir, but overlap.
I think the only assistance, well, not the only, but part of the assistance is the acute part of it when we have mental health issues that are acute and that are coming up like really strong, especially for our children and youth. And, you know, those are sometimes, and I've been in Judge Willock's courtroom many a times for some of our adults too, in our adult protective services aspect of things when they cross over several types of programs. So the acute, whenever they're coming to crisis, what do we do and how do we respond? So I think that's that process.
And that's where the collaboration comes in. In reference to the other question, of course, that is a of course an executive question in reference to merging health and human services. There are several jurisdictions that have merged or have kept health and human services together, but there are also jurisdictions that haven't. And so that is obviously a conversation for the governor at his level. However, I think that collaboration allows us to work so well together that merge right now is not necessary. But that, like I said, that is a question for the governor.
Commissioner Gomez?
Commissioner Encarnacion handled that question beautifully.
Well, I was more interested. Of course, I know it's a question for the governor and even for this body, but as a body, we wanted to hear what are your opinions with regards to that. Do you see that it's beneficial, that it will be beneficial? So I just wanted to hear from both of you, what are your opinions on the matter?
I believe that would be an assessment that would have to be done. So just to answer it off the cuff right now would actually not allow for an educated guess, honestly. I think that there's been assessments over the past years about merging, and I don't believe that there was a cost savings on it. So I think that the delineation of the duties and what we do in the BI code and the federal mandates it allows us to do our job and do it and try to do our best of our ability. So to answer the question specifically, I wouldn't be able to have an answer. I'd rather have an assessment completed before I could answer that.
Good, thank you for that. I guess that's your position also, Commissioner Encarnacion.
Well, yeah, you see, one of the things, and I speak about this openly in terms of the social determinants of health and the Medicaid funding and how we can actually work together to ensure that our community are being able to be afforded preventative care based on the local social determinants of health, which may be different from other jurisdictions. So we've been at the table. I've invited the director of Medicaid at our table as well, so that we can actually have input on the Medicaid state plan, which is critical for how health in general is managed through Medicaid. So even though it's under Human Services, there's a large health component to the administration of Medicaid monies. So we work closely together with that. So there's some conversations, like Commissioner Gomez says, is initial conversations as to what the future would look like. But right now, I think that this is just an understanding of where we are and going forward, working collaboratively. Honestly, that's how I feel.
Well, thank you.
I just had one, Chair, if I may. Human Services is a large agency. We have 86 different types of programs that do cradle to grave type of work, and so really making sure that when we're doing it, we're doing quality work and making sure that we adhere to the individual and family needs is the most important thing that I feel that we should continue to do.
Thank you. Well, I want to thank you both for your candid response to my question. Thank you, Chair, for your indulgence.
Thank you. Thank you very much, Senator Carrion, for your line of question. Attorney General George, are you still on the line? I know that you have to jump off. Attorney General George, you still on the line? Okay.
I believe she may have texted you, Chairman, to say she had another meeting.
Yeah, she did. She did. I just was checking to make sure because I had a comment for her or a question, a real quick question before she jumped off. Nonetheless, we'll have a second opportunity. Senator James, you're recognized for your 7 minutes at this time.
Good afternoon to the people of the U.S. Virgin Islands, and thank you, testifiers, for all that you do and your service to the people of the U.S. Virgin Islands. As we know, the month of May is Mental Health Awareness Month, and that's about 2 months away from now. And I see that on the VI Department of Health website, there are some vacancies, and it says that the deadline for individuals to submit their resume is February 28, 2021. So my question to Commissioner Husta Encarnacion, I see that you have vacancies for behavioral health counselors, project manager, and health outreach worker. Have we been able to get individuals to come forward to fill these vacancies that are needed in order for you to carry out the mandate of this proposed legislation by the governor?
First of all, it would take more than what we actually have right now in our coffer. I can't tell you how many people have actually applied. We have a couple more days for Department of Personnel to close out on that one. And so I don't have my DC over Human Resources and Labor Relations with me. So I do apologize, but I could get that information to you at a later time. But we're pushing for that, for those positions to be closed in a really early manner. I don't know if you heard, but I did indicate in the testimony that in order for us to actually run the services provided or requested in this bill, it would at least be $5.7 million in addition to what we are budgeted for. So we would need more people in reference to outreach workers and case managers, as well as counselors, to be productive under this bill.
So can you just give us a quick 10-second ad on how individuals can go about filling out or sign up for these positions, please?
Well, you can go to the VI Department of Personnel, the Department of the Department of Personnel website, and actually apply on that. I don't have the details of the website available right now. I can get all of that for you, and I'll do a little advertisement when I have everything written down. So before the end of this session, I will have that for you, sir.
Thank you so much. And Governor Albert Bryan signed an executive order on February 19, 2019, declaring a state of emergency on mental health in the USVI. And the governor said declaring this emergency will give the Department of Health access to federal resources. Can you speak to what federal resources did we receive since February 19 regarding mental health?
Well, one of the things the bill gave is access to allow psychiatrists to even after retirement, to apply for positions as well as clinical staff. And so we've tapped into as many staff as we can, as available within a territory. It also allows us to expedite, with the help of Department of Personnel and OMB, to overturn these requests in a more expeditious manner. We also are working with our federal partners, CDC, SAMHSA, and opened up some of, we've gotten some new grants, and we've opened up some positions, and the positions that you actually are seeing now that's being advertised are also federal positions, as well as those positions in our general fund. DC Steele can probably add a little bit more to that if you have time and you'd like to hear from him.
I would try to get back on the second round. And is this declaration still in effect by the governor?
Yes, that has not been pulled away. So, yeah, and I have to tell you that behavioral health continues to be top priority for, and not because we're on the session, it's just a fact, continues to be top priority for the Department of Health.
Thank you so much. And currently, who is your director of the Division of Mental Health, Alcoholism, and Drug Dependency Services?
We actually, right now, Curtis Callender, I just signed for him. He is the acting director of behavioral health and alcoholism and drug dependency. So he's right here with us today, and you've heard his level of expertise as we have spoken.
Thank you so much. I think earlier we were told that VIPD is here. VIPD? But before I get to VIPD, Department of Health, because page 19 of 110 of this act that was brought down to us in the raw form speaks to law enforcement training for officers addressing calls to behavioral or mental health crisis, right? But what I want to know is who came up with a minimum of 40 hours for specialized training for law enforcement officers? Where did we get that number from as the minimum?
2 minutes.
I'll have DC Steele, who has more knowledge in the CIT process. DC Steele, could you please respond to that?
And if you can just keep it brief, please.
Keep it short.
Yes, that is based off of the national model. It's actually sometimes referred to as the Memphis model, the Crisis Prevention Institute, who designed that specific model that's been utilized nationally. So that's their standard. And it's the initial training and then every 2 years.
Awesome.
Refresher.
And to VIPD, can this mandate of 40 hours of training be incorporated in the training of our new trainees while at the police academy? Is that any way we can incorporate it? Because when we do 40 hours divided by an 8-hour work day, that is 5 days of training. Is there any way we can incorporate that into the police academy training for individuals handling mental health and behavioral health citizens of this territory?
Senator, this is Dr. Walwin, Deputy Commissioner of Police. Yes, it can be incorporated. We're already doing the 24 hours of training, but the NAMI class is 40 hours minimum. We can extend that into post-academy or in service, but during the academy, we do give some basic training on how to deal with persons with behavioral issues. I heard a question asked this morning, and I don't think you got the answer.
No, I never asked you a question for the day. Thank you, Dr. Warren. Thank you. The reason why I've asked about the 40-hour training is that I really want to make sure that we're looking out for our law enforcement officers. They have a lot going through right now. And I can only imagine how it is to be a law enforcement officer in the territory. And once we implement this and it becomes law, I really want to make sure that we have like refresher courses.
Time.
This is not something that you just do one time and then boom, you become an expert with dealing with mental health and behavioral citizens of this territory. So can you give us this commitment between Department of Health and VIPD that there will be refresher courses and continuous training for law enforcement officers?
From VIPD, yes, we can.
Department of Health?
Yes, we can. Yes.
And Mr. Chair, if I can just ask one more question. Page 17 of the proposed legislation that came down from Government House speaks to collection of data and the qualified personnel to execute such a task. So my question regarding data, I know recently we have the former senator who is the director of Bureau of Economic Research, and hopefully we can get individuals all across government who's responsible for data collection and research to really sit down and put a plan in place where we can be able to do things from a place of logics instead of a place of emotions. Because we tend to jump day by day on the thing that is hot. If the radio station say right now, this is a hot topic, we jump on it. But we have to make sure that we're dealing with it when it comes to data. So Department of Health, can you speak to me as far as the manpower that you have in your department or across the executive branch where we have a focus group when it comes to data collection, when it comes to mental health and behavioral issues in the territory?
Well, I'll speak to it in terms of general. We have specific key performance indicator that we pull on a monthly basis. And so that is actually something that is, the report goes to the Office of OMB, to the governor, of course. It goes to the legislature as well. We definitely do report that, especially on our annual report from a financial standpoint to the legislature, and we'll continue to do so. I did speak, and I don't know if you heard about the CASPER work. The CASPER work that's been done, that was actually done after the hurricanes, is a community assessment of public health emergency response, or the CASPER epidemic technique. It is designed to provide public health leaders and emergency managers with community data. And so that was actually posted. So we have that information, and we will be sharing it with Senator Francis, and he in turn will share it with the team. We do need more data collectors, but I have to say that process improvement is one of our key goals for the Department of Health, and we are collecting data on a monthly basis.
Thank you so much. I would just end by saying thank you for all that you do. There are a lot of things I want to say on the floor, but because this is a sensitive issue, I'm not going to bring personal incidents and situations to the floor. But I really look forward to this body being able to meet with those focus groups that you made mention of. So when we come back to this floor, we are not complaining, and we're actually coming with a document that is ready to go and ready to be voted on. Thank you, Mr. Chair, for the time.
Thank you very much, Senator James, for your line of question. Before we go to the next senator, Commissioner Encarnacion, in the Attorney General's testimony, she gave somewhat of a scathing rebuke. I'm not sure if of the legislation. I really wanted to ask her that, but I wanted to ask you whether or not the Attorney General or some representative from the Attorney General's office have been a part of your group discussion in respect to this legislation.
She and I actually spoke a little bit more, turn that down. Spoke a little bit more about the 721, 722, 723 process linked with the current 2021 process in this bill. And so that's really the line that we're getting. She actually gave some information in terms of where her thought process is with this bill and how she'd like to see some changes made. However, that is the only conversations we've had. Like I indicated before going through, it's been late, but we have started interagency collaboration more so on the outcome of this bill. And I think, like someone indicated, we do have a behavioral health and alcohol and drug dependency committee. And NAMI is also part of that, as well as other behavioral health agencies. And we will bring this bill to them because we already have a table for this bill to be vetted. And of course, individuals like Judge Willax, community entities, and focus groups will be presented again to them before coming back to you.
Very well, no problem. I just wanted to really respond, or at least, again, she's not here, but I'll have a discussion with her because I think it's critical. In it, she also talked about the funding that's required, and it's this body's responsibility to identify funding. And I just wanted to let her know that between the 32nd and the 33rd legislature, we have appropriated close to $8 million for behavioral and mental health. So, we have put our money where our mouth is. We continue to make ourselves available to certainly fund it, but we need actions as well. At this time, we'll go to Senator Whitaker. You recognize for your 7 minutes.
I'm sorry, excuse me, Senator Francis?
Yes, Judge?
if there's no more questions for me, I'll respectfully ask that I can get permission to leave. I have a 3 o'clock.
Okay, any questions for the judge? No, Judge. Thank you very much for being on the call. Thank you very much for everything that you have done over the years to assist with the heavy lifting that's required for this mental health legislation and other legislation as it pertains to behavioral health. And we certainly appreciate and will continue to engage you in terms of being able to come up with a comprehensive reform and address some of the issues that I know that have plagued the court system for quite some time now. So thank you for being on the call today.
Well, thank you.
Senator Whitaker, you recognize for your 7 minutes.
Thank you very much, Chairman, and good afternoon to all the listening and viewing audience. Good afternoon to all my colleagues and everyone engaged in this process. Good afternoon to all the testifiers. I want to lay out some important foundation, and as I personally believes in, as we prepare for hearings, that foundational work has to be done. Again, for the public, as a reminder, this is a bill sent down by Governor Bryan, sent to us. And all the testifiers, majority of them are members of the governor's cabinet. So I think what is going to really also be critical as we move forward, that we have a series of extensive working sessions, not just meetings, but meetings where we're going to really drill things down and analyze and come up with our revisions. I want to go to each individual, especially our government departments. Let's first off, I want to find, I'll start off with you, Director Tessamark. The Bureau of Corrections does have a legal counsel, correct? Legal counsel, either assigned by the Attorney General or assigned directly to your office, to your department?
That is correct. That is correct.
And through this, and the legal counsel did in fact, through this, in preparation for the testimony, did in fact review the legislation. Am I correct?
That is correct. A team of individuals, yes, with him.
Okay, and as it pertains to all the laws pertaining to the issues of prisoners with disabilities, do you have any, has this attorney produced any documentation to help guide you as a director of Bureau of Corrections? Would you be able to quickly reference documentation that would help aid you in this process?
Yes, I will let Mr. Faulkner respond to that. Mr. Faulkner?
Yes. Good afternoon, Senator.
Good afternoon.
Yeah, the question is whether we produced any documentation.
No, very specific. I'm speaking, we're here today to address a critical crisis in our community.
Absolutely.
And so have you produced any reports, documentation to help guide and help your director as it pertains specifically to respecting the rights of prisoners with disability and carrying out what the law currently speaks to?
Okay, well, we work with our mental health team to come up with our perspective to this particular piece of legislation. And as you know, Senator, we're also under a consent decree that governs how we can treat the mentally ill within our care. So we have quite a bit of documentation arising out of the monitor's report, the consent decrees, and also the cases that have been decided recently by the Virgin Islands Supreme Court and the Superior Court.
And what I just would advise,
all
correct. And so I understand that it's a compilation legal research, but what I'm getting at is, as we work together on really addressing this issue, for us to get the ear much more narrow and get more concrete as to the exact provisions we're amending. Thank you so much for your answer. Deputy Walwyn, you have answered I've actually, Assistant Commissioner Walwyn, Deputy Commissioner Walwyn, you've actually answered my question before, and I want to emphasize again, what is needed is professional development. Is the Virgin Islands Police Department on course for an actual professional development system that incorporates the review process, 360s, a learning management system? Are any elements of professional development, a system in place for the Virgin Islands Police Department? Even the name of that system will be helpful as well.
Good afternoon, Senator. Those systems are being looked at right now. For the management of our men, we are looking at a new system called ADOR, which will follow our men from the academy till retirement. That is something that we are working on right now.
Okay. And I would just express that it's really important that we select the system, but that we look, and as is specific to this issue, that we really be much more aggressive in development. I know Division of Personnel to really take the lead in many ways when it comes to professional development of all of our agencies, but as your individual agency to at least adopt a core portion of professional development. I want to bring to everyone's attention Title 19, Section 729. Title 19, Section 729, sorry, 710 to 729. Correct myself. And specifically Section 715. So that's Title 19, Section 715. It's called the Interdepartmental Committee. An interdepartmental coordinating committee is established, composed of the Commissioner of Health, Education, Human Service, Police Commissioner, Director of Vocational Rehabilitation, other appropriate agencies, and the Director. The committee shall meet at least twice annually at the call of the Commissioner of Health, who shall be its chairman. Commissioner Encarnacion, are you aware that there is, in fact, an interdepartmental coordinating committee as it pertains to behavioral health, alcoholism, and drug dependency? Are you aware of such a committee?
Of course, ma'am. We actually met last year under the, along with SAMHSA and the director of SAMHSA, regional director of SAMHSA. So we did meet, and along with that, we actually have a behavioral health and alcoholism and drug dependency cooperative committee that meets on more of a regular basis. And so, yes, I am truly aware of both.
Okay, and this committee has produced information and documentation that, of course, is sensitive information being taken out that is readily available, that you'll be able to provide to this body? Would you be able to provide reports of these meetings?
What I've been asked, and Dr. Sims is working on this right now, so we're pulling all of our data sites together, and we'll be able to, and I'll probably present it in closing and also submit it to the chair, through the chair, but we have specific areas that we have been collecting data, and so I just want to pull everything together, and then we'll be able to present that to you in a more formalized fashion.
And just a note with that law as it pertains to when we talk about mental health, behavioral health, persons afflicted with various sicknesses, or persons who have been deemed in different challenges. All the departments, so each department is actually responsible for not just for the mental health of its employees. So to Commissioner Encarnacion, have you provided, I know, for example, Department of Education, you work critically on the reopening of schools as it pertains to the guidelines. Have you assisted various departments and then government? Chair, you can proceed. Yeah, so I'm just, have you put out, especially when it comes to COVID, any informational guidelines to assist different departments, not just in the testing of coronavirus, but also persons' mental health as it pertains to COVID and even on any other afflictions?
Yes, we have. From the onset of COVID, we have been doing that. We actually have a breathing session technique session that occurs on a monthly basis coming out of the Department of Health. I actually met with the Board of Education last Saturday, who actually also requested some support for our teachers. And so even though we've met with the teachers, we do some education with them. I think more specifically talking about how we can manage the crisis that we are in right now going forward. So yes, we have in the past, and we will continue to do so.
Chair, just have one last question.
You may conclude. Yes.
Thank you. And my final to really wrap up really concerns the legislation itself. To Attorney Perel, for the president of the Virgins Bar Association, how, in terms of specifically the Legislation and Law Reform Committee, how best will you proceed following this hearing to assist, if you will, with the continued efforts to address this legislation?
Thank you. I appreciate the question. We are at the ready and available to go forward. Obviously, a lot of the comments that we had were echoed by some of the other attorneys that were also testifying today at the Public Defender's Office and obviously the Attorney General. So we have a number of very specific issues. We're happy to redline and provide that to the appropriate group. Again, we were trying to make sure and stay in our lane, but as far as providing suggestions, we have a number of them, and we're happy to produce it anytime anyone would like them, and we're happy to do it as soon as possible.
Okay, thank you. Thank you, Chairman.
Thank you very much, Senator Whitaker, for your line of questions. Before we go to Senator Potter, I wanted to ask you, Commissioner Encarnacion, is there any other government agency that's under, part of the central government that's under any kind of compliance requirements? In respect to behavioral health, mental health, that is, yes.
Well, Department of Health, I think, and I would ask Attorney Henry to more speak to this in terms of our linkage with BOC and the order that they're under. So Attorney Henry, can you speak to this, please?
Yes, I apologize. I was trying to get my camera to work, but I don't know what's going on. Yes, I actually have been keeping close coordination with all these legal issues with the Department of Justice. Recently, regarding the COVID-related mental stuff, Attorney Pontine has been really big on that and has been working with us on a plan for I don't want to use the term incarceration, but placement in treatment facilities promptly.
Attorney Henry?
Yes,
would you like Senator Francis to repeat the question?
Yes, please. I thought I heard it properly, but...
Yeah, I was asking Attorney Henry whether or not are you aware of any other central government agencies that's under any type of compliance in respect to mental health, behavioral health requirements at this time?
No, I don't. I know the Bureau of Correction, it may have a mental health component, and other than that, just the Department. The Department of Health is under any decree, but we have statutory responsibilities.
Very well. Thank you. Senator Potter, you're recognized for your 7 minutes.
Thank you very much, Mr. Chair. Good afternoon, everyone. I wanted to start really by commending Commissioner Encarnacion, sorry about that, Commissioner, and her team for, I think, putting together a very far-reaching piece of legislation that admittedly needs some work, but I think it was a very good start. I wanted to ask the Commissioner whether she had an opportunity to confer with Dr. Masove. I know that he is the head of the behavioral unit at the East End, St. Thomas East End Medical Center. I know he is, I believe, the only psychiatrist here on St. Thomas on a full-time basis, and he has vast experience, I think, in child psychiatry, a board-certified individual in child and adolescent and adult psychiatry, and he has a vast array of experience in this area. Would you be willing, or have you had any collaborations with Dr. Masove in putting this significant piece of legislation together?
No, we haven't, but I don't know if you know, I'm a pediatric person by heart. And so any input that we can get from a pediatric-minded individual, I will definitely confer with. So thanks for the recommendation. I know of him. I met him once, but we definitely will be reaching out to him as well as anyone. It's not just children, but children and education, and those, of course, with disabilities.
Excellent. Thank you very much for that. I wanted to start with my first question, really, and it is concerning collaborations with the various agencies. With or without this bill, or while this bill is being fine-tuned, how can we better work together to connect the various agencies that provide behavioral health services in the territory, so that individuals who are in need of behavioral health services, as well as the various agencies know of each other, and individuals who need the services are aware that the services exist. Do you think there's room for us to do a better job in that regard?
If I may, I think that there's always room for improvement, and I'm sorry that that Judge Willax had to leave, but I have to tell you that my first meeting with Judge Willax in his court, he wanted to put me in jail because I didn't have the Behavioral Health and Alcohol Dependency Committee working. And so a month after that, we began, and we have actually continued. I know COVID slowed us down a little bit, but that entity, as well as there's a meeting that we had on a every Tuesday basis, where everyone came together and shared ideas. And so that is the quorum, the venue for sharing ideas. Everyone knows what everyone else does. And we actually did it in several different ways. But I have to tell you that, yes, COVID has slowed us down, and there's definitely room for improvement. And we will be researching that. And DC Steele can probably let us know exactly where we are with that committee.
Excellent. Thank you, Commissioner. Can you share your efforts to recruit? And I think this question can be asked to both Commissioner Encarnacion and Director Testermark. Can you share with us your efforts to acquire a full-time psychiatrist at the Department of Mental Health, at the Division of Mental Health, as well as the Bureau of Correction? Is there a need for a full-time psychiatrist there? I know they are difficult to come by. I recall Senator VLA last year passing an initiative through the 33rd legislature to provide a scholarship program, working it through the Board of Education for psychiatrists, to provide a scholarship for local homegrown psychiatrists. But can you share with me your efforts at recruiting a full-time psychiatrist to the Division of Mental Health as well as the Bureau of Corrections?
I'll start by saying is that salaries are not as competitive as we would like them to be here within a territory. But we've actually gone as far as hiring someone to conduct telemedicine services because it's so difficult to recruit here to the territory. DC Steele, can you speak a little bit more about our efforts in recruiting a psychiatrist?
2 minutes.
Yes, as Commissioner mentioned, we're taking this opportunity, being that we don't have a lot of interest or competitive rates here. We are building up the telesite. We have set up the infrastructure to do so, and we are actively seeking physicians and psychiatrists who are willing to provide us service through a telehealth platform.
Okay, and the telehealth
yes,
the
and we
telehealth
also
platform.
are setting up through one of our grants that we have funding right now to try to get professional contract out so that we can also put other practitioners in place. And we currently had, in the interim, we had applied for a grant through FEMA to provide a community crisis project. While it does not put psychiatrists per se on there, it was allowed us to partner with 2 local providers to have counselors and provide community support for any resident in the territory. That's been an ongoing project since September. And we recently applied and was able to get awarded for that to continue through November 2021. So that puts counselors access available, and you would see the flyers, and it's on Facebook. It's called a Community Resiliency Project. So they at least have a start of reaching practitioners, even though it's not a psychiatrist person.
Okay, excellent. Thank you for that. Commissioner Encarnacion, I wanted to ask you, I know that there are organizations in this community who have been awarded grants to address mental health issues in our community. What role does the Department of Health play in tracking, grant funding and tracking the services that were provided by persons who, won federal grants? Are things funneled through the Department of Health?
Well, one of the things that happens is that those individuals, those agencies actually write to me and someone like DC Steele, Dr. Sims, for letters of support. So in that way, that the information is channeled. So we provide letters of support. Frederick said Healthcare has done so. the village has done that. So so we know that the grants are there and what the grants support. So in essence, yes, we do.
Okay, but you don't get any feedback as to the effectiveness of the services that have been provided and the like. Once you do that initial support, letter of support, that's pretty much it as far as your involvement or interaction with the entity who was awarded a grant. Is that correct?
I have to tell you that I agree. That is correct, but I want to say that that's where our regulatory component comes in. And we have actually now have a director of regulatory. And so I have to tell you, senior health is my first priority in terms of data collection and ensuring the quality is there. But behavioral health data will be collected, and that's how it's going to be coming under our newly developed Office of Regulatory and Department of Health. So you're on point. It's not where it should be, sir.
Okay. Thank you very much, Commissioner. Thank you very much, Mr. Chair, for your time.
Thank you very much, Senator Potter, for your line of questions. Before we take a recess, I wanted to ask you, Commissioner, who else needs to be at the table? Obviously, we have quite a number of stakeholders here today. Who else needs to be at the table at this point?
Education actually needs to be at the table. They have a big component in the bill. And so, like I said, I did have a conversation with Commissioner Barry Benjamin as early as yesterday. But I think that having her at the table and her team, especially with the special needs focus.
UVI, perhaps UVI labor, you see them as being
yes.
Stakeholders as well?
Yes, especially the CERC program. Actually, the CERC program works with Department of Human Services and Department of Health on an ongoing basis, a grant for children in terms, and data collection was just, we just supported that grant. And so, yes, UVI for sure.
Commissioner, I want to give you a quick scenario, and if you could triangulate for me how these services interact between the VIPD, Department of Health, and others in regards to addressing this particular scenario. You get a call from an individual saying that in Burger King at Sunny Isles, we have a known mental patient, a 722, that's hanging around the drive-through there. Obviously disheveled, harassing the customers, everything, and created a problem and a nuisance. A call was made to 911. Obviously, the officers responded. Can you just talk the public through what is expected at that time in terms of that integration of agencies as they respond to that call?
You want to hear my vision, or you want to hear the reality?
Let's do the reality. I think today we want to have that honest discussion, and then next step will be what should be the vision and how we should really react to a situation like that. So let's talk a little bit about what is the honest reality of what occurred in a similar call like that.
Okay, we don't have the individuals that are trained with the CIT or the ability to de-escalate situations like that as much as we would want to have it. The collaboration between the entities, VIPD, hospital, human services, and BOC have begun, but the collaborative training is not there yet. And so right now it would be VIPD responding, it would be EMS responding if anyone was hurt. We do not have the outreach in Department of Health as we should. So that's really what we're looking for. When to get there, I have to tell you though, VIPD has been tremendous in getting in contact with Department of Health when behavioral health issues come about. So we try to assist as best as we can. If you look at the vision is actually, believe it or not, is actually in the act in which we actually come together. We develop the CIT, and where we're all trained, and we're trained on the same level, so we're all responding the way that we're supposed to respond. And so we're caring for these individuals. I have had many conversations where individuals who really should not be arrested are sometimes because of lack of knowledge. So it's not a fault, it's a lack of knowledge. So if the knowledge is provided, the training is there, and we work collaboratively, that is truly my vision. And that is one of the benefits of many that we have, but truly looking at what the act shows. We have a lot of cleaning up to do, yes, but the act shows us where we need to go.
Very well. Therein lies, I mean, certainly there are a lot of gaps that needs to be filled, and I think that that's what we will work towards, making sure that we fill those gaps. Because I will believe that the VIPD have a little bit of a different perspective, and what will happen under a call like that, Department of Health will equally have a, not Department of Health, but EMS, as well as the hospitals will have a different perspective of what transpired in terms of that reality. So I think it's critical that we do have that CIT and that complete integration to make sure that there is a smooth synergy that happens under that. But in the essence of time, I'd like to recognize Senator Fred for 3 minutes.
Thank you, Mr. Chair. Very quickly, Commissioner Encarnacion, there's a section in the bill, section 10002, that speaks to the Commissioner of Health being responsible for emergency beds. Is that something that should fall under your purview? And it's a two-part question. And are you and the hospitals collaborating on the rebuilding of the hospitals to ensure that there are sufficient beds to support mental health patients here in the territory?
Through the Office of Disaster Recovery, we've actually been at the table when the health expert came in looking at how the hospital should actually be built. Our Office of Procurement, our Chief Procurement Officer is actually at the table and providing health-related expert in reference to that as well. So she's there. I haven't been, but like I said, she's there, and I am on the board of the Territorial Board for Health and Hospital, and so I'm able to provide feedback as well in that entity.
So once we rebuild our hospitals, we should see the burden eased from the Bureau of Corrections. That's what I'm hoping to hear and see in the future.
If I may, it wouldn't be from the Bureau of Corrections per se. It would really be more, well, yes and no, but it would be more from the acute phase, and then hopefully the prevention portion of it, which is Department of Health, as well as other entities, would prevent that significant forensic cases that we're seeing.
Okay.
So yes.
All right, great. So I don't recall exactly which section is it, but there's a section in the bill that speaks to housing of persons with behavioral health, mental health, and developmental disorders. It appears to be under one umbrella. Do you believe that, and as facility, of course, do you believe that it is appropriate to have one facility that houses all of these? I see challenges with housing someone with developmental disorders there, but what is, from your professional perspective, is that appropriate?
Well, one of the things that we did is we edited that portion of it, and we also changed the term developmental disorders to neurodevelopmental disorders, focusing on not the physical disorder, but also the neurological disorder, emotional, and the definition is actually very clear with examples, and indicated that even if it's one, it doesn't have to be a building, but if a facilities within, we have 9 acres to work with. So they don't necessarily have to be within one building. They have to be separated, and we were very clear in our edits in the bill.
Okay, perfect. So it's separated. 1 billion, that's not really the issue, is ensuring the separation. Great. And then my final question goes back to the department. May I wrap up, Mr. Chair? Goes back to students, section 10002B. And perhaps you've already looked at that and realized that there's some challenges there. But it speaks to the educational services of students with disabilities. And of course, in fact, that is governed by IDEA, which is under the U.S. Department of Education. And that is currently funded. Significant funds come to the territory for supporting our students with disabilities. And again, that's where my concern comes in with the appearance of conflating individuals with disabilities in this particular legislation. So did you look at that component, section 10002B? If you haven't, that's fine, but I urge you to take a look at it. I think that needs to be rewritten, and the language needs to be clarified.
Yeah, we have, and we actually have an entire section that we've rewritten into that, and that is in our testimony as well. It is on page 5 of page 13 in our testimony, and it begins at line 14.
Okay, I will look at it again. Of course, like we said earlier, there's much work to be done on this legislation, and I have taken a lot of time on it, so I have a number of areas that I recognize where there are challenges. I would be happy to share them with the team, so y'all could use the information and determine whether or not the information is appropriate. Mr. Chair, thank you for the time, and again, everybody have a good afternoon, and we have a lot of work to do on this. Thank you.
Thank you very much.
Thank you.
Senator Fred Gregory, Madam President, for your line of questions. Before we still talking about going on a break, but on page 43, section 1025, protective custody, I wanted to know, I'm not sure if the Chief Public Defender, Joseph, is still on the line, but there was a discussion in regards to both from the Attorney General and the Public Defender in regards to probable cause. And I don't know, Assistant Commissioner Brooks, I don't know if you heard the testimony from both of those individuals where they were questioning where that either a magistrate or a judge should make the determination in terms of probable cause. But I see this being very problematic that officers are the first line of defense that respond to these calls for service. Again, when you have to take action in terms of determining whether to make an arrest, take this person into protective custody for his safety or the safety of his community, then you certainly have to make that decision in terms of developing the probable cause, the facts and circumstances to lead to take that person into custody. Any position that the Virgin Islands Police Department have contemplated in respect to the protective custody aspect of this legislation?
Again, thank you for that question, Mr. Chair. Relative to that protective custody, again, we arrest for crimes. Officers arriving on the scene will, of course, meet a certain level of or circumstances. They'll make a determination whether a crime has been committed, and then the determination will be made. That's what they're trained to do. Should there be a crime, then the officers will then proceed with the procedures accordingly, which would then, relative to an arrest, will be made, and then that person would be then taken over to a Bureau of Corrections. Now, if there's no crime, I think I had mentioned earlier in my testimony that we do have a list of persons. That individual can then be taken to the hospital as practice has been. For treatment and so forth, and then we'll proceed from there. But a crime would have to have been committed for that arrest to be effected.
Very well, but there's instances where an arrest may not be warranted, but rather, again, protective custody for the purpose, again, for the safety of the community or the safety of this individual. So technically, you will still have to take that person in custody for the purpose of either transporting or assisting in transporting to the hospital for 722 to be filled out and documented. Correct?
Correct.
Right. So
Correct.
it don't always amount to a situation where an arrest is made.
That is correct.
Very well. The committee will stand in recess for 2 minutes, and when we come back, we'll do a final 3-minute round. Committee stands in recess for 2 minutes. We're out of recess. At this time, we'll do a wrap-up round of 3 minutes. Colleagues, please try to stick to your 3 minutes. We have these individuals been here since 10 o'clock this morning, and I want to be fair to them and get them out. I know that's a very important issue. It's a comprehensive bill, but we'll have a second opportunity at this. So, Senator Francis Heiliger, you're recognized for your 3 minutes.
Point of personal privilege before testimony, please.
You're recognized.
Thank you. As a member of this institution for about 22 years, I have formed quite a bit of relationships and friendships over the years, and I would like to extend condolences to one of our employees, Ms. Turnbull Carty, on the passing of her father earlier this week. But I also want to take this time out to extend condolences to the family and friends of one of our former employees that have worked here for over 20 years, Ms. Angela Spencer, that passed away day before yesterday of cancer. For those of you that have known Ms. Spencer over the years and have known of her battle with cancer, I, as one of her very close and personal friends, have been a little bit somber for the last few days because as she knew her time was coming, she did attempt to return home to the territory day before yesterday, but on her way and at her attempt to get in the car, she could not make it. Unfortunately, she passed later that evening. And as I was on the phone with her children, awaiting the nurse to come to decide whether to check her vitals to make sure if this was her final passing, I paused because I was a little bit saddened because here was a Virgin Islander that had to leave her home to live away for several years just to get cancer treatment. And all she wanted to do was pass away at her home, and she couldn't do it. And I want to say condolences to her and her family, but I think even as a member of this specific committee, I hope that we could do something to help those with cancer in our territory, whether it's to make sure we have a facility running during this time we're deciding on what to do with the Charlotte Kimmerman Center or whatever the case is, to make sure some of these individuals can be at home because a lot of them don't want to leave their territory and they don't want to leave their friends and family. So I just wanted to express my condolences for that.
Thank you very much for that, Senator. We also have in the St. Croix district a former employee of the legislature, Lexter DJ Porter, that passed away as well yesterday. And the circumstances with that scenario where he may have suffered an asthma attack as well and was being rushed to the emergency room when this occurred also presents some challenges. So I know that healthcare continue to be in a crisis mode right here, but we're making every effort, and our oversight here in this committee will continue to be of such that we'll try to do everything possible to make sure that all of these issues are brought to the forefront and we work collectively as all branches of government and to really support the executive branch in addressing the healthcare situation that we find ourselves in. So it continued to be saddening as you hear of all of the individuals that's passing on under this COVID-19 time, but more importantly, again, here in the territory, it's burdensome, when you start to go down that road. So, I express my condolences to those individuals you spoke about, Ms. Carty's, as well as her father, as well as Alexa Porter, and all of those others that have passed on recently. So, as well as Fred Coman yesterday, I attended his funeral. Mr. Brown, I attended that funeral as well yesterday. So, there's some difficult time. You're recognized for your 3 minutes at this time, Senator Heiliger.
Francis Heiliger, thank you so much. I would like to quickly ask a question of VI Bar Association. Are they still here? Miss?
Yes, I'm still here.
Oh, okay. The question I wanted to ask, since receiving information about this act, has the Bar Association done any type of review in regards to maybe a relative act in a different jurisdiction or various jurisdictions to see if this act is somewhat on par as to what the modern or national trend is?
I do not know if the committee actually went and checked other locations and other jurisdictions. However, I know that they went through and did an extensive review. I can follow up with you on that, and we can do a nationwide search to determine whether or not this bill tracks language that is used in other locations. We often do that here on a number of matters, and in fact, our Supreme Court requires that if there's some new issues that does not have historical backgrounds here. So I can certainly follow up with you on that, and we can provide that information.
That. And this is also for you as well. I know in conversing here with the VIPD and them stressing that they don't have a policy specifically with dealing with people with mental issues, the question I want to ask you, has the Bar Association or do you guys have any recommendations for them as to how to deal with that? Because it's kind of interesting to hear if they commit a crime, we arrest them, or if it's not the case, we drop them off to the hospital. But at the end of the day, with somebody that has mental challenges, clearly there might be some type of extenuating interaction in even trying to arrest them. Are there any things that you guys might recommend to them to assist with this? Because clearly if this bill does not pass today or tomorrow or 6 months from now, they need to have some policy in place to deal with them.
I think that's a wonderful question. I have actually had some specific dealings with the police departments in Galveston, Texas, on a matter that I had represented some individuals in. And as I mentioned briefly in my testimony, that particular location has a very large homeless population, which, as we've all heard today, oftentimes is suffering from mental illness. That particular police department has I believe they called it the Mental Health Task Force. And those individuals were police officers who were at an investigator level and who had training, either undergraduate training or I forget exactly what their level of training was, but it often was either in psychology, psychiatry, and so forth. And so I can certainly have our group and I can personally reach out to that particular group and find out what training they offered to their police officers. I will tell you that in that scenario, as an attorney, having those mental health officers, mental health task force, was invaluable in the situation that we were dealing with, because those officers were able to tell the difference between someone who was acting in a way that was obviously provocative, that was in any other circumstance would have clearly be considered an aggressive behavior, but because they had that training, they were able to let a lot of the issues just sort of roll off of them, because they understood that the individual was coming from a place of mental illness as opposed to being aggressive toward the officer. And that would be a tough thing to do if you don't have that training. So I can reach out and circle back and at least find out what training that particular group does. At least I can tell you I've seen it and it worked.
Okay,
so
thank you.
That's as far as I
so
can
much
provide. Thank you.
And that was very important to me, because we've seen, and I've even witnessed some situations where, because officers don't have that training, some situations have escalated, and even nationally we've heard of individuals dying because someone with mental illness was approached or assumed it was a different situation other than someone. So the training is critical to dealing with them. Mr. Chair, could I just ask one more question and I should wrap up?
Yes, you may wrap up.
Thank you so much. This question has to do directly with the bill, and it's on page 48, 48, section 1030. And across from it on section 1030-49, it speaks to rehospitalization. And it speaks to if any patient needs to be rehospitalized, there are two different ways it could be done. And this has to do with people that are involuntarily committed. And for some reason, when their time is up, if the director of the behavioral health treatment facility or the commissioner, they can recommend to keep that person there. And it also goes on to speak to dealing with individuals that have been in there, but they have not voluntarily agreed to the stay. Now, if you approve that someone has to stay inside, how do you deal with it? Do you contact family? And how long is this process going to take? Is it until you guys feel that they're okay? Or does it step into a situation where you can contact family and see, do they have a say in the matter at some point? Because reading it here, it only speaks to the commissioner and the director of behavioral health.
This is Hussein Kanasoon, the Commissioner of Health. Yes. We actually spoke to that and we edited that portion of the bill. So right now, it is actually looked at as a 721, which is a voluntary committal, 722, and which is the involuntary committal, and then 723 is the extension of the 722. That's what we're looking at currently. The 1020, 1021 actually is truly mimics what we're doing right now with a little expansion and inclusion of some of the aspect of what we really need to be placed in the bill. And so it's not the Commissioner of Health that makes the decision, but it's actually a team of certified individuals who actually make the recommendation. Of course, the psychiatrist then takes that to court to extend the stay at that point in time, leading to a 1020 or as we do right now, a 723. Court actually also reviews that. That person is placed into custody if that need be. And then we have a monthly review of those cases, and we are continuing to do that. We meet with the judges on a continuous basis. So it's not something that's just laid to rest. It's something that's actually managed on a continuous basis.
Thank you very much, Senator Francis Heidegger. Thank you very much, Commissioner Encarnacion. Senator Blyden, you're recognized for your 3 minutes.
Thank you, Mr. Chair, and good afternoon again to all. Ms. Paxson, you spoke in your testimony about clearly defining and or identifying housing initiatives for persons with a mental illness, such as transitional housing, personal care homes, independent supported living facilities. And my question is to Commissioner Encarnacion, Ms. Paxson, and Assistant Commissioner Brooks, because right now we have many of those individuals occupying bus stops, living in abandoned private and public buildings, public parks, etc. Do you have any policy and or procedure as of how to deal with those individuals? And the second question is, how do we assist in terms of trying to help these individuals? Because I know many times, many individuals like myself have tried to assist those folks from the bus stops, especially when folks are trying to utilize those spaces also. They are not trespassing because it's a bus stop, but at the same time, what can be done or what have you been doing in that regard?
I can respond to that, but I actually prefer to shift that over to DC Steele, and also like to have Dr. Sims respond to that. But DC Steele, can you respond to the type of individuals we're looking at in behavioral health in general?
Yes, good afternoon. Yeah, so individuals, if they're out in the community, we go out and do an assessment on the scene. Often it's a collaboration with VIPD, Department of Human Services if needed. Administrator Sanas is very actively involved with our team. We have actually taken several individuals off the street and get them to the proper levels of care. Most recently, one well-known individual who, after assessment, does not actually have a behavioral issue. However, we still went ahead and placed him in housing, and he's so grateful to be in an apartment rather than on the streets. We are also in the process of re-engaging our encounter program, and that would kind of be an onset into hopefully one day having the full crisis intervention team. So it's a lot of joint effort, and we do currently work with those individuals the best we can, and we know there's many gaps in services as to where they can be placed. we have the same issue on the other end. We have several individuals coming back out of residential care. We're actively having intra-agency meetings right now and discussing where we can place them because they have successfully been treated, they're stabilized, and they're ready to come home.
Dr. Sims, can you add to that if you have the time? Senator Meshi, may I ask you to add, please?
Please.
Hi, good afternoon, everyone. So in addition to what DC Steele mentioned, that particular data set with the Encounter Project is something that the Department of Health has been tracking from inception. That couples with programs like the Clubhouse on St. Croix.
Please put on your
different
camera.
developmental programs.
Please put on your camera.
I'm sorry?
Can you put on your camera, please?
It's actually on. Let me reroute. I'm having a little issue here. Can you see me now?
Yes, we can now. Yes.
Yes, because I can see myself. Okay. So that program goes hand in hand with the Clubhouse on St. Croix, our outside partners like NAMI. What we try to do is once we get an assessment of those individuals, we go through levels of treatment because not everyone that is outside or considered homeless is a person that is on the severe end of the spectrum. And so it is our job to make sure that we assess and we provide proper treatment and implementation of those programs in order to get that person at the back on their feet or to a more critical type of care facility. And so those data sets will be compiled and submitted to the Senate. Thank you.
Thank you for your response. And in closing, Commissioner Gomez, I believe it was a couple of weeks ago, I was by Mandela Circus going back to the legislature, and it was raining pretty hard, and there was a young man there in a wheelchair. He's usually there in that corner, looking pretty bad, feet swollen, still have on his hospital tag. And I'm sitting there, the light is red, and I honestly could not move without actually addressing that situation because I could have my father, my brother, a family member, whatever. And I put on a sign when I talk to him. I say, sir, you know, it's raining, you're here in a wheelchair. Why are you here? Why do you have on this hospital tag? Have anyone approach you from Human Services, whatever? You know, he said, yes, someone from Human Services approached him like 2 weeks ago and said it was going to get back with him, and no one got back with him, and he needed help. You could have actually smelled his skin rotten. You know, so in those cases, with those type of individuals who really cannot help themselves and are depending on your agents, your department to assist them, how do you go about actually dealing with these type of individuals? Because I know I'm not the only one that have seen him there.
Oh, I'm not going to talk specifically regarding any clients we may or may not serve, Senator, but a great question. I think in the event that you see that, a direct call to me or my staff to address it on point would be appropriate, first of all. Second of all, sometimes we do go and look for clients, and they're either not home or at the location that they said they were going to be. So if he had just released to the hospital and we went to look for him over the last couple of weeks, we may not have known that he was in the hospital because many people do live alone. So it's a combined effort, and it depends on if they have family members, if they have a mental illness and or a behavioral health issue and a substance abuse issue, are they homeless? So I think each individual client that we have to take and assess their needs at the time. So it is a group effort. It is a team effort between health and human services and VIPD. And it just depends on what is happening in our private and nonprofit agencies. Also, we pull in a lot of the times too to see if they're able to do so. So it's a combined effort, and it's unfortunate. So, you know, in the event that you do see something like that, I appreciate a call or text so I can address it immediately.
Thank you so much for your response, and I will do such. Thank you, Mr. Chair, for the leniency. Thank you so much.
Thank you very much, Senator Blyden. Senator Soro, you recognize?
If I may,
Yes. I hear a couple of voices there.
Yeah.
Commissioner Encarnacion?
Eddie Callender has an update for you because he actually has been in contact. So that's where the collaboration between the two agencies come in. Eddie Callender, if he may, please.
Yes, good afternoon again. The Behavioral Health Division has had contact with this particular gentleman. Our outreach worker has gone out on more than one occasion and has done an initial assessment with him. And it doesn't appear that he has any current behavioral health issues. But the issue is, of course, finding him appropriate housing. So there has been collaboration and work with Catholic Charities to try to get him in there. And a spot was initially available for him. But at first, he refused it. And then there was follow-up with him, and the most recent update is that it seems as though he's now willing to go. So we have to basically have more communication with Catholic Charities, again, to see if that spot is still available and see if he is maintaining his willingness to be transferred there. So there has been contact with him, and there is collaboration happening behind the scenes, because we definitely have noticed his condition. So hopefully he does not change his mind at this point if we can, in fact, get him in there.
Thank you, Director Colliner. Senator Saru, you recognize for your 3 minutes.
Thank you, Mr. Chair. I just want to comment before I go into my 2 questions. We noticed, and I'm going to say we because some of us noticed in here, that the bill really does target psychiatrists and psychologists, and the other parts of the, I want to say, the mental health spectrum, like the counselors, the whole group, they're absent really from the legislation. Is Public Defender, Chief Attorney Joseph on the line? Or did he leave?
I am, Senator.
You're here, good. So most jurisdictions, and you defend those who, need, indigent people, right? Who need defending. So in other jurisdictions, there are mental health courts with a specific task of coming up with treatment plans for those who are mentally ill. What are your thoughts on the Virgin Islands moving in the direction or part of this bill, including the establishment of a mental health court?
I think that, Senator, I think that would be actually a great addition to all the services the bill already speaks to. I had the fortunate or the privilege to practice in Maryland at one point in time, and I practiced in Baltimore City, and they had a mental health court. That court was held, I think it was pretty much every other Wednesday. It operated in a standpoint sort of like a check and balance or probationary type feel, where the persons with mental health issues would check in with the court regularly, and the court was aware of what their status was, whether or not they were on their medication, whether or not they were staying within the realms of their treatment plans, whether or not they were being housed properly, so that they never got too far, I guess for lack of a better word, on the spectrum, to the point that they were constantly monitored. Unfortunately, here within a territory, we are faced with the same individuals being incarcerated. They spend literally the more time or the amount of time, maximum amount of time for the crime they committed. Generally simple misdemeanors. They're medicated, then they're released, and the cycle just keeps going on and on. With respect to what would be needed, I think of forensic services at the courthouse. I don't know how funding would go. That would also help deal with the issues, because oftentimes these people come to court, and while we know what the issues are in general, we can't pinpoint specifically where we need to be in terms of getting them the help and the services they need.
Okay, thank you for that. And the time, can I just have the bar representative, attorney, please forgive me.
Purcell.
Attorney Purcell. Perel, sorry. I apologize.
That's all right. No worries.
What are your thoughts on a mental health court?
I think I would actually welcome the idea. I think the public defender is correct in that if maybe not a separate mental health court, maybe it's something that we need to work through as far as the possibility of developing plans. While we were on the break, I was looking up in the Galveston area, which is the area I had mentioned to you before, information, trying to follow up on the other senators' requests. And they actually have a mental health court as well. And, my experience down there was that it was the kind of thing where they really do coordinate for oversight. because what often happens with folks is that compliance becomes a big problem. And, you know, it's easier said than done. We all have issues, but folks that are having mental challenges either don't appreciate the issue or they have a lot of difficulty following through with any kind of a treatment. So having sort of a quasi-court available to ensure that they're on track, so they, as the other attorney mentioned, so they don't get too far off track, I think would be a very productive idea, and maybe something we could fold in as opposed to a whole separate court, maybe just something that we could otherwise fold into the process now. I don't know if maybe it's something that could be folded into family court or not. I know family court does do a lot of that, certainly with the youth. I know that that's something that I've been involved in as well, and I know the judges are involved in that, coming up with plans, and I know we do that in conjunction with the Department of Health and Human Services, and they really do help us in that regard. So I would second it. Maybe the answer is simply fold it into something we already have existing so that we can actually get it moving quicker rather than later.
So thank you, Mr. Chair. Just brought that up to just jog the minds and brainstorm on the mental health court portion and how, you know, what Attorney Perel said, because oftentimes we only act in this territory through a consent decree, a court order, and the mental health court would be the level of oversight necessary to ensure that what's in the legislation in the future will be followed. Thank you, Mr. Chair.
Thank you, Senator Sorrow. We do have bill drafting for a mental health court. So I will love to work along with you and my other colleagues in respect to moving that forward. Senator Carrion, you're recognized for your 3 minutes.
Good afternoon once again. Let me ask you with regards to, I think this is Commissioner Encarnacion, on section 1039, this is if I understand this correctly, the section 1039 criminal law limitation, that's on page 58, it says here, the legislature of the Virgin Islands may not adopt or enforce local laws, ordinance, resolutions, or rules having the force of the law that excludes being mentally disturbed. And it continues to read. My question really is, this prohibits the legislature from making any changes to the law in regards to being mentally disturbed, drinking, being a common drunken. This section appears to be unconstitutional and violates the separation of powers. What's your opinion in regards to that, or can your attorney maybe respond, your legal counsel, I should say?
Yes, Attorney Henry can respond, and I'm sure Deputy Seal can also. But when you say separation of power, could you be a little bit more clear with your question on that?
Because if I'm reading correctly, it says the legislature of the Virgin Islands may not adopt or enforce local law. I know we're not called to enforce, but a section for adopt, so that's where I need some clarification maybe from legal counsel.
Okay, this is Attorney Henry, Department of Health. There are many instances where the legislature, whether it's federal or state legislature, has actually enacted legislation that imposes a restriction on themselves. Like, for instance, when you pass a law that says that you may appoint this commissioner, but limit to the 2 commissioners on a board, or every so many years. So I think there's legal precedence for that. That's my department's position. I would defer for an official government position to the Department of Justice, the Attorney General, who by statute has the authority to speak more with authority on that issue.
Yeah, and I believe the Attorney General she's not connected, right, Mr. Chair?
No, she's not.
Okay. Can we look into this? I just want to have some clarity, if I may, maybe through the chair.
Very well. We can have legal counsel actually issue an opinion on that matter.
Good. With regards also, we know that with COVID, we have been really impacted because of the pandemic. The emotional health of the Virgin Islanders has been impacted. I'm especially concerned about our children. And as well as our seniors. many who have spent the last year isolated in their homes. Have there been any studies or surveys in regards to the overall emotional, mental, and well-being of Virgin Islanders? And if so, has any funds been appropriated from the CARES Act to be able to address and attend the needs that we have within our community? Because we know that, nationally we've had, sorry, Mr. Chair, if I may, nationally we've had a high number of suicides. So I want to find out, what's the status locally? How are we dealing and attending that area?
Okay, I'm actually going to turn that question over to DC Steele, but just to let you know, we actually are, some of our listings right now in reference to case managers and counselors that we have out there, it would be supported under the CARES Act Fund Office of Interior grant, as well as one of our public assistance in relations to not just COVID, but COVID vaccine administration and hesitancy. So DC Steele, you want to talk about what we've been able to do over the last year and 3 months?
Yes, and I mentioned it briefly earlier, specifically the Community Resiliency Project that we developed. That grant that we received through partnership with FEMA and SAMHSA is specifically related to the COVID response that provided that community support and counseling out to any individual within the community to receive that. So we were fortunate to go ahead and apply for the second phase of that, which gives us the extension from this current month through November. So that is a specific program directly to serve those who are dealing with struggles or stressors related to this COVID pandemic.
Thank you very much for your response. Thank you very much, Senator Carrion, for your line of questions. At this time, Senator James, you're recognized for your 3 minutes.
Thank you, Mr. Chair. To Department of Health, as you know, we have a psychology program at UVI that is offered on St. Croix and St. Thomas. Do we currently have like an internship program with the Department of Health and UVI when it comes to mental health or behavioral health in the U.S.?
Social work, we actually went into a MOU with UVI and the select program for social, you have to turn yours, for social work. And as I can give you an update on that, I can't write offhand, but that is one of the initiatives that we've taken on. In terms of psychology itself, we do not have, we're always willing to accept internships, but that collaboration, I'll look into a little bit more. Excellent question.
Please, because I know for sure, I know one of the graduates from that program, I know she's doing big things on the U.S. mainland. She's now a doctor, Dr. Fredericks, and I know she's on the island, and we have many other individuals there who are intelligent, and we need to create an internship program because we are very serious about pushing mental health and behavioral health based on the legislation that was brought down from the governor. And I know the governor always talk about helping young people and putting them in jobs and what have you, so it would be good if we utilize UVI. So my question is, in regard to the legislation that is before us today, was there any input from the research team or any extension of UVI?
No, it was one of the questions that the chair actually asked, who should be at the table, and UVI was definitely one of the ones that he spoke of as well, besides education.
Okay. I just want to make sure that we don't overlook our young Virgin Islanders who are doing great things, and then they tend to go to the U.S. mainland and contribute to the success of somewhere else. So I know that you made mention in your testimony of children and behavioral health, but it was just one paragraph. And I know on page 106 of the bill, section 1122A, it speaks to some programs there that they will put in place once the bill becomes law. Can you speak to how much of that $5 million will go towards our youth based off of that section in the bill, section 1122?
It's hard to say. When you look at the case managers, some funding, of course, has to be leaned towards MCH and the 0 to 3 birth to toddler program. So we have several programs that would benefit from what we're looking at here in terms of where the bill is. So it's hard to say exactly how many funds, but I think all of the clinical aspects has to also be focused on not just children, but adolescents as well as adults.
And
It's hard to say how to break it down right now.
And through the chair, I know Commissioner Hussein Kanasiong made mention of the need for an extra $5 million to be able to execute this bill. If at a later time you can provide that breakdown of how you plan to utilize those funds if this bill becomes law, and if you can just end by saying this, answering this, when it comes to our senior population in the U.S. Virgin Islands who are suffering from mental illness, whether it's diagnosed or undiagnosed, how do you go about dealing with those individuals between Department of Health and Department of Human Services? If you can just answer that. Thank you, Mr. Chair, for the time.
Okay, I'll begin. Just to let you know that the breakdown of that budget was actually attached, so we'll make sure that you get a copy of that as well, but that was attached to the testimony. Steele, DCC, want to speak a little bit about the adult population and elderly population and behavioral health needs?
Yes. Currently, we've been providing some community outreach through our Let's Talk Forum specific for the elderly population. So we've been working with AARP and other community groups to provide and make sure we have a captive audience there. And then apart from that, we've been trying to engage some of the other community partners who specifically serve that population to just make them aware of the services we have and what we can offer to them at this time.
Thank you very much for your response. Thank you very much, Senator James, for your questions. Commissioner, in regards to nonprofit organizations that you believe, I heard the mention of Catholic Charities today, as well as 10,000 Helpers. Any other nonprofit that we believe could have a seat at the table as we continue to contemplate this comprehensive reform bill?
I would say the Village, St. Croix Mission Outreach. There's so many there. I would say we can actually lean onto the St. Croix Community Foundation, the VI Community Foundation, who a lot of our nonprofits are channeled through there, and see exactly who we can pull and what the benefits of having them at the table would be.
Yeah. Very well. And I come in. What about the, can you speak a little bit to the clubhouse? Where are we with the clubhouse?
Yes. Currently, the clubhouse have 14 active members that participate.
You got muted. I don't know what happened there.
Okay. Yes, we currently have 14 active members in the clubhouse. We refer to them as members instead of patients because they receive training, not only on social skills, but vocational training and being able to work with other individuals beyond themselves and being able to go back out into the community. So as members, we have 14 of them. Some of them participate virtually during this time because of COVID. However, we have active members coming into the clubhouse. We had added staff to that process. We have activities coordinator and educational coordinator, outreach staff placed there, as well as the Dr. Bratwitt oversees the daily operations and the whole clinical operations at the clubhouse.
Very well. And Commissioner, do we have cultural competency training available for our healthcare workers?
Excellent question. In terms of our onboarding at the Department of Health, I have to be honest.
You're breaking up. You're breaking up real bad, Commissioner.
That was painful.
Very well. Let's try that again.
Okay, let me just say, not particular for the Department of Health, to be honest with you, it's something that we're working on our onboarding process, but I know that the Department of Personnel does offer cultural competency, and they have a week-long orientation for new onboarding employees as well.
Okay, and you're also having a discussion with the Frederick Health Center. I know that they too provide some support to our behavioral health clients. You're having conversation with them how they could actually be a part of this comprehensive reform?
They're actually part of the committee that we continue to speak about. So and they're very consistent in their approach to working with us. We have not pulled them on the table with this act, and so you asked who should be at the table, and our federally qualified health centers definitely need to be added to that. So I'm glad you brought them up.
Very well, thank you. And Ms. Pogson for NAMI, can you just speak to some of the complaints, some of the requests that come in through your working sessions with some of the clients? Because I've attended meetings and I know that there's individuals there with real life scenarios and the level of frustration. Can you just speak to some of the discussion you were having with some of the clients in terms of needs as we contemplate this legislation?
Sure, yes. Thank you, Sherilyn Pogson. The major complaints have been around the 722 protocol, primarily from caregivers, as I mentioned in my testimony, because of the confusion that always seems to happen. Everyone has a different situation, so that's why we say confusion, because every story is different. So that's why we want to stress the need for consistency and an effective protocol that everyone understands, so that when someone is in crisis, that the family member, the caregiver, whoever their loved ones are supporting them, they understand what the process is, what will happen when that call is made, if they do have to go to the hospital, and what will happen after that. So that's why we want to make sure that we have a clear protocol in place so that everyone has a clear understanding of what will happen. The other main issue has really been around housing. Quite often, the family members that are even willing to support their loved ones, they are doing it because they love them, but they're also living in fear. And no one should have to live in fear in their own home. You want to be able to support your loved one. However, you want to feel safe as well. And so while we recognize that there is a need for that support system, there also for the person that is living with a mental illness, you need to make sure that you're supporting the caregiver as well. Because if they don't make sure that they practice self-care, then they're not going to be able to help them help themselves for their own well-being. But also too, it's with regards to the housing. Everyone should be able to live independently, have a purpose in life, and that's one of the things that we all want to experience. We have our own home, go about our own day-to-day activities. We want to feel like we're a part of something, like we're doing something with our lives. And if you don't make sure that you're giving individuals a home, safe home, resources, tools that they need so that they can feel like they're waking up every day with a sense of purpose, that's important as well. So I would say the main priorities during our meetings has been discussion about the 722 protocol and the need for housing, just to make sure to take care of not only the person that's living with a mental illness, but also the family members that are supporting them.
Thank you. Thank you very much for that. And Commissioner Kazi Gomez, in respect to caregivers, is there any benefits that's available to support those individuals that's actually providing for them? And equally, are there any consequences for those that's actually receiving financial support? In some instances, some of them may be military individuals earning or receiving Social Security checks, various checks for them, but that in no way, shape, or form really assisting to take care of some of these individuals. Any thoughts on how do we address that?
Well, I mean, that's part of that elder abuse aspect of things that we spoke of in one of the hearings as far as the legislation with that. So in the event of elder abuse specifically, that's also financial exploitation. So if that's happening, that's reported, and we work with Department of Justice in order to make sure that that is taken care of. As far as the family caregiver, we do have a program. It's small. And it's caring for those caregivers that are actually caring for either elderly and or sometimes their grandchildren too. So it's a variety of services. We have that support group. We've had to do it virtual since COVID. So we're trying to figure out how we can get everybody back safely. We had a little bit of CARES Act money that we reported on the 16th at the CARES Act hearing. Regarding virtual and being able to get them systematically put up IT-wise so that they're able to participate accordingly too. But caring for the caretaker and the family caregivers program is probably a really crucial role, especially right now. And then we also, even though we have our senior centers that have been on pause for a bit due to COVID, we do outreach with them. We have our Meals on Wheels program. So there's lots of outreach that we're continuously doing. And when we see that dual diagnosis, I think that's the other part of it. We have quite a few that have more than one factor, and we haven't really spoken about that today too much, but sometimes that dual diagnosis and or combined with homelessness, combined with basically exerting everything that you have, and no family wants to take you anymore because you've burnt all those bridges. And we have our elderly that are shut-ins, and they're lonely and isolated. So we need to make sure we keep an eye on them, and we've been doing that the best we can as far as our clients are concerned.
Very well. It's been a long day. You have an alibi question? Oh, you had a point of. You had a point of inquiry, Senator James. Then point of information, Senator James. Point of inquiry, Senator Carrion, and then we'll come to Senator Sorrow. Yes.
My point of information is very brief. I just want to say to the Department of Health to please reach out to Collective Collaborations Inc. on St. Croix. I think the lady who's running the program is Miss Dickinson. She's doing great things down there. I'm not sure of the collaboration between Department of Health and that group. But I know in an October 20, 2020 article, she says, I am a single individual with no government funding and no paid staff. We do this from the heart and to improve the lives of those who don't have a voice. She's doing great things. I'm please asking you guys to assist her and to collaborate when it comes to mental health and behavioral health in the U.S. Virgin Islands. Thank you.
Thank you very much, Senator James. Senator Carrion, you're recognized for your point of inquiry.
Thank you, Mr. Chair. I have a question. Were any counselors that is not, of course, psychologists, psychiatrists, or independent from the Department of the Government of the Virgin Islands consulted in writing out this bill? Such like my colleague mentioned earlier, counselors, behavior counselors or licensed professional counselors, because they seem not to be, they're underrepresented here as stakeholders and also not really mentioned in the language of the bill, as she mentioned.
Okay, I'd like to address that. We actually did in our edits from the Department of Health ensure that not just psychiatrists and psychologists are part of it. So our recommendation to add the full spectrum of clinical services under psychological care has now been added. In reference to who has been consulted, I will indeed admit that this is something that we started not too long ago in terms of forming this interagency collaboration to put this bill together. But we will continue and we'll pull these individuals in. The senator has noted several people who needs to be on it, nonprofits, private, and we'll pull them together and we'll continue.
Okay, well, I'm glad to hear that, Commissioner. And the last thing was also the Virgin Islands Behavioral Health and Alcoholism Drug Dependency Planning Council and their advisory board, were they also part of the process or consulted with?
That's actually comes out of the Department of Health. I am the lead of that. And so in its entirety, the ones who were not consulted are the individuals we just spoke about, the private agencies, and so we'll continue.
Thank you.
Thank you, Senator Carrion. Senator Sorrow.
Thank you, Mr. Chair. I know earlier the Bureau of Corrections listed the cost that they, what they expend on having to house off-island inmates. Department of Health, do you have a number for how much you spend? As well as Human Services?
We have that number, you have it right, not on hand, but we can provide that to you.
Through the chair.
Yeah, please submit it through the chair to circulate for the members. Also, the
course.
Department of Human Services.
May I get Chair, this is Commissioner Gomez, may I get a clarification? Is it specifically regarding provider contracts, behavioral health? Like what specifically? We have across a lot of programs, so I just want to make sure that we're clear on what is being asked financially.
I think the senator was referring to the the off-island payments, those that's institutionalized, I think is what she was making reference to.
I actually have that information for you regarding Department of Human Services, if you'd like for me to report that out now, or I can provide it and in respect of time, I'll be happy to provide it in writing.
Thank you. Providing we writing it will work for us. Thank you very much. It's been a long day. I think that there's a wealth of information that have circulated here today. We still got work to do. And I would just like to afford individuals 30 seconds to do a close off. And more importantly, we want to go out and be able to hear from, before we come back and finalize this measure, is to be able to hear from those impacted. And we haven't determined exactly what mechanism we'll use for that, either a virtual town hall or bring them in or set up something that they too could have a voice and discuss some of the issues or concerns in respect to this. And I'm talking about the family members and that's impacted and perhaps even some of the caregivers as well, yes. So that's something that we're working and making sure that we're getting a perspective on those before finalizing this. But I'm hoping that within short order, we have another committee meeting scheduled for the March 18th. And I'm hoping that we could get all the amendments and everything in place and try to move this along. The Committee of Health, Hospital, and Human Services has really prioritized this issue, and as well as the executive branch, and we want to support them in again, making sure that we move the legislation and then get into some actionable items to be able to address behavioral health and developmental disabilities here in the territory. At this time, we'll allow for closing. 30 seconds, and we could start exactly where we began this morning from the Commissioner of Health.
Thank you, Senator. First of all, my advertisement, I promised Senator James, I would like to ask that those interested in joining the Department of Health Division of Behavioral Health, Alcoholism, and Drug Dependency Services to please visit the DOP-USVI.org to apply, and to also visit our DOH.vi.gov website for opening. I think that we are building a strong team, and of course, the services are so well needed throughout the territory. Senator, we appreciate the input of all involved today. It truly takes all of us to work together to make this possible. Behavioral health touches all of our agencies and all of us personally. While we have the interest of all involved, let's all commit to making this a priority to continue the collaboration. Together, we can develop an effective system of care that focuses on a continuum of care regarding behavioral health services in the territory. And of course, I cannot leave without saying that we have a community vaccination center that's being set up in St. Croix and in St. Thomas beginning Monday, March 1st, 8 a.m. to 5 p.m. Monday through Friday. And I encourage you to call the Vitima hotline. And please, we need to reach herd immunity. Behavioral health is impacted in essence by COVID-19. We want to be able to feel normal again, or some form of normalcy. So I ask that you all, your friends, families, sign up, become inoculated, become vaccinated, and let's be able to be free again in terms of how we live. So thank you so much, Senator. I really appreciate the time and the collaboration seen here today.
Thank you very much, Commissioner Encarnacion, to you and your team. And again, thank you for answering our calls and our many discussions we have had leading up to this particular hearing. We certainly appreciate it and look forward to moving this legislation through. Commissioner Kazi Gomez.
Well, I think, thank you, Senator. So Commissioner Encarnacion almost took my tagline, human services, we are working together to make a difference, and that's what we do. And that's the only way we'll be able to make a difference is to do just that. Special thank you to my staff and our team, and of course, Department of Human Services, the health, the VIPD, all the players that are on today and the legislature. This is a joint effort to ensure that we are providing streamline of services, a continuum of care for those that are most special to us, because behavioral health does affect each and every one of us. So thank y'all so much and have a great weekend.
Thank you very much, Commissioner Ocasio-Gomez, to you and your team, again, for being present here today and all of the work that's being done, again, to meet from the cradle to the grave, and your work as you continue to take care of our elderlies and our youngsters in our community. We certainly appreciate it. The Attorney General had to sign off to attend another event, so as well as Judge Harold Willocks, we certainly appreciate him being on today. So next we'll go to Assistant Commissioner Brooks to give closing on behalf of the Virgin Islands Police Department.
Yes, good afternoon again, Mr. Chair. Thank you for your time. Today we discuss a significant gap in our society, and the VIPD supports and welcomes any type of additional training to aid us in providing and support better services to the members of our community, particularly those with behavioral health and the other life challenges. Alone, we cannot attain this goal of successful care for them. This effort can only be accomplished collectively. The Act in its current form gives us a running start. We must now finish the race. The VIPD is in full support. On behalf of Commissioner Trevor Villanor, the members of the Virgin Islands Police Department, I'd like to thank the Honorable Governor Bryan and his staff for putting forth this act. And to you, Mr. Chair, we thank you. And the other honorable members of this community for the opportunity to present here today on this so very important topic. Thank you again. Have a good day.
Very well. Thank you very much, Assistant Commissioner, to you and Deputy Commissioner Walwyn, Dr. Walwyn, as well as the Virgin Islands Police Department, and being here, providing the stats, and also for all that you do to address this particular issue. I know that you're on the front line. You refer to yourself as the flagship in law enforcement, and certainly we appreciate the work, and you continue to put yourself in harm's way to make it happen. We'll go next to the Director of the Bureau of Corrections, Director Testemark.
Thank you, Chairman. Thank you for this opportunity to testify before you today. This is an important bill that is urgently needed. The Bureau of Corrections stands prepared to work with each and every one in this community to craft the best possible legislation in this area. Thank you.
Thank you very much, Director Testemark, to you and your team. And again, you're the unfortunate recipient a lot of times that have to endure, these individuals not having the type of institution that they so deserve. And then we rely on the Bureau of Corrections then to provide some protective service for them. So we thank you and your team for what you do, as well as the rank and file officers over at the Bureau of Corrections. Chief Public Defender Samuel Joseph, you're recognized for your closing.
Thank you so much, Senator, for having the Office of the Territorial Public Defender here today. We look forward to the progress that will be made as a result of the discussions that we had here today. It was a great collaborative effort. This is an issue, as echoed by everyone else, that affects us all, and it's been a long time coming. So we, although we tend to fall on the other side of the fence sometimes, we still look forward to working with the entire group and making sure that we can make great strides that will impact those in our community who are impacted or affected by mental health issues.
Thank you very much, Chief Public Defender. You're on the right side of the fence, making sure that you're defending our indigent and making sure that they have a voice and that they're not taken advantage of in any way, shape, or form. So we appreciate the work that you and your team do, again, to provide that defense on their behalf as part of the system and the process. President of the Virgin Islands Bar Association, Attorney Perrell, you're recognized for your closing.
Good afternoon, everybody. Thank you so much for having us. We really appreciate the ability to actually weigh in on this. I know I have a to-do list, a 50-state survey, a mental health deputy review, which is what they do in Texas, and then also provide red line suggestions, and then also research into the issue of an actual special mental health court. So I'll be happy to coordinate and get all of that information to the chair so he can disseminate it to the group. We appreciate everyone's time, and we just really happy to assist and provide whatever we can to help move this along so that we can get a bill that works and that actually will function and do what needs to be done in the territory. Thanks again.
Thank you very much, Attorney Perel and the Virgin Islands Bar Association, your team that actually had the opportunity to review this 110 pages, comprehensive reform. And be careful what you ask for. You're the new kid on the block, and we will be sending a lot of legislation your way to get your input on these measures. So you asked for it, you got it. We look forward to
Bring it on.
We look forward to the collaboration moving forward. President of NAMI, Ms. Pogson, you're recognized for your closing.
Yes, thank you again, Senators, for the opportunity to allow NAMI St. Croix to provide testimony on this proposed bill. NAMI St. Croix stands ready to work with our community stakeholders and advocate for the priorities to help our loved ones as we all develop a comprehensive behavioral health care system. Thank you.
Thank you very much. And again, I want to thank you to NAMI and all the work that they do to continue to be a voice and advocate and your advocacy for the mental health and behavioral health issues. I've attended several of those meetings, and I know how diehard you folks are. You're very committed, and we certainly buy into your mission statement to provide that voice and an input. So we are very happy to have you here today, and the perspective that you brought to the discussion was extremely important. We appreciate it. Thank you very much for joining us. So we have come full circle. Again, I hope I didn't leave out anyone, but we really appreciate the discussion we've had here today. This is a very important measure for the executive branch as well as the legislative branch and the judicial branch. We have an opportunity, again, as all branches of government, to really work and providing a finished product that could benefit this community. So I look forward to really doing that and moving this legislation forward as the chair, as well as all of the committee members and my colleagues in really making this happen. So thank you for this discussion. We'll circle back as we continue to further this, and we're hoping that we could be able to move a comprehensive legislation forward with all the funding and everything else that it requires to be able to address this age-old issue that have confronted us. And I'm very passionate about it because we're all just a thin line away from it. These are our family members. These are people that have contributed to this community in some way, shape, or form. Our nurses, our teachers, our veterans. When we look at who's who, it's us, our family members. So I truly look forward to us being able to address this particular issue moving forward. So thank everyone. Have a safe weekend. At this time, we'll take a short 2-minute recess, and when we come back, we'll be moving towards Bill 34-0017. That is with the Wang Louis Hospital, so there's no need for you to stay on. Have a good weekend, and thank you for the long day. Committee stands in recess for 2 minutes.
Thank you, sir.
Thank you.
We're out of recess at this time. Madam Clerk, please call up the second and last item on today's agenda.
Bill number 34-0017, an act making appropriations from the balance of the funds appropriating an act number 7697, section 2, paragraph 1, and $400,000 from the Community Facilities Trust account to the Virgin Islands Government Hospital and Health Facilities Corporation for the acquisition of plot number 7, Estate Diamond Ruby, St. Croix, Virgin Islands, for reconstruction and expansion of the Governor Juan Francisco Luis Hospital and Medical Center.
Thank you very much. Who speaks to this bill? Senator.
Good afternoon.
Senator Gittins, you recognize for presentation of your bill, and then we'll go to the, well, let's recognize the testifiers. We have two testifiers from the Juan Luis Hospital. Let's do a mic check. Attorney Thomas?
Good afternoon. Yes, sir. Good afternoon. Testing 1, 2, 3.
Very well, good.
And good afternoon. Chanel Moorhead.
Try that again, CFO?
Hi, good afternoon.
Ms. Moorhead, go ahead and put your name on your record. Try that again, Ms. Moorhead. We see your mouth moving, but we don't hear any voice coming out of it.
Turn up sound. Good afternoon, Chanel Moorhead.
Very well. Thank you, Senator Gittins. You are recognized for presentation of the bill 34-0017.
Thank you, Mr. Chair, and good afternoon to all. I am proud to once again introduce this piece of legislation to purchase the land for the reconstruction and expansion of the Governor Juan Francisco Luis Hospital and Medical Center here on the island of St. Croix. I brought this measure forward last year, which was supported by the full body in the 33rd legislature, as well as the hospital governing board and the Brian Roach administration. However, Governor Bryan Jr. noted in his veto message to the legislature dated January 21st, 2021, that he vetoed the bill because the funding source in the original legislation had been depleted. However, we realized soon thereafter that the proposed legislation back then outlined the wrong section in Act 7697. The bill cited Section 1, Paragraph 3, when it should have stated Section 2, Paragraph 1. Also, the governor indicated in his message that he had authorized the Office of Management and Budget Director to expeditiously use the Community Facility Trust Fund to assist with the critical project, and the governor also reiterated his support for this land transfer in his State of the Territory address on or about January 25th. We have made the necessary adjustments to this legislation, and today's bill number 34-0017 allows the Board of Directors of the VA Government Hospitals and Health Facilities Corporation to make an offer to purchase plot number 7, Estate Diamond Ruby, St. Croix, for the purpose of reconstructing and expanding the Governor Juan Francisco Luis Hospital and Medical Center, utilizing funds already appropriated to the Governor Juan Francisco Luis Hospital under Act 7697 in the year 2014. For those listening and viewing today who are unfamiliar with the proposal, this land consists of more than some 3 acres directly adjacent to the hospital. Acquiring this land for construction of our new hospital could speed up the construction process by months or even years and save us a great deal of money, and we know that we need to save some money while helping to minimize disruptions to services, and the good Lord knows we cannot afford that. Purchasing this land allows us to move forward more quickly rather than waiting on total demolition of the current structure, and to expand and the expanded footprint of St. Croix Healthcare Facility also affords us the opportunity to expand the services available to residents and visitors alike. St. Croix needs quality health care, and the state-of-the-art hospital is critical. Building our facility adjacent to the current hospital will save us time and money and ensure continuity of care. Once construction is completed on the new hospital, we can hopefully repair and repurpose the current structure to further serve the needs of St. Croix. Colleagues, as I ask for your support, it is important that we act swiftly on the legislation to acquire this adjacent property so that the Governor Juan Francisco Luis Hospital architects have all the information necessary to complete their designs, including this new site. This is a matter of exigency for the people of the Virgin Islands and specifically those on St. Croix. Thank you in advance for your support as we continue to serve the needs of our community. Thank you, colleagues.
Thank you very much, Senator Gittens, for presentation on Bill 34-0017. At this time, we'll go to the testifiers to give their testimony. Attorney Thomas, you're recognized.
Thank you. Good afternoon, Honorable Senator Novell Francis, Chairman of the Committee on Health, Hospitals, and Human Services, Honorable HHS Committee members, other senators of the 34th Legislature of the U.S. Virgin Islands present, and the listening and viewing audience. My name is Attorney Siobhan Thomas, and I am here on behalf of Interim Chief Executive Officer Daima B. Williams of the Governor Juan F. Luis Hospital and Medical Center. We apologize that our CEO was not able to attend this hearing today. To assist with this presentation is Acting Chief Financial Officer Chanel Moorhead. It is a pleasure and honor to testify before you on Bill number 34-007, an act making appropriations from the balance of funds appropriated in Act number 7697, Section 2, Subsection 1, and $400,000 from the Community Facilities Trust account to the Virgin Islands Government Hospitals and Health Facilities Corporation for the acquisition of plot number 7, Estate Diamond Ruby, St. Croix, Virgin Islands, for reconstruction and expansion of the Governor Juan F. Luis Hospital and Medical Center. It is my hope that this testimony will provide this committee with a clear understanding of not just JFL's need, but the community's need for this land for healthcare. Plot number 7, Estate Diamond Ruby, is approximately 3.6552 acres and would become the southeast quadrant of JFL's boundary line. We have provided a slide that shows the exact location of this property. I don't know if media is able to project that, but I will continue.
Media.
A parcel map
1 second.
displayed on the screen.
1 second, Ms. Thomas.
Yes.
Let's make sure.
Okay.
Okay. Go ahead. Go right ahead. It's up.
Yes, thank you. A parcel map is displayed on the screen for your reference. Following my testimony, the committee should be equipped with the knowledge of the core benefits to JFL and the community as a whole in moving forward with this purchase. We also look forward to providing you with the immediate and future plans for the land and how this purchase will advance the provision of healthcare in the Virgin Islands. For ease of reference, I have organized my testimony into 2 key areas. 1, the funding source for the purchase, and 2, the purpose of this land purchase. So 1, we'll start with the funding source. We request the reappropriation of $1 million in funding previously allocated in 2014 through Act number 7967, Section 2, Subsection 1, to rebuild and restore the acute care inpatient psychiatric unit. As you may recall, and as a result of the 2017 hurricanes, FEMA deemed that JFL is eligible for a full rebuild to include a temporary structure built to house the hospital's functions while the new hospital is being built. This temporary structure, known as JFL North, includes a complete acute psychiatric unit. Next slide. Inclusive of 4 state-of-the-art rooms, one of which will be completely padded. The unit is a ligature-free zone and further includes 10-foot ceilings and tamper-resistant equipment and fixtures. All common areas of this unit are equipped with cameras, and the nurse's station includes a viewing glass, which allows clinician visibility of all 4 rooms on this unit. This marks the re-engagement of beds in JFL designed specifically for acute behavioral health on the island of St. Croix. To reiterate, there will be acute behavioral health beds in JFL North, and the new projected JFL Build project will include a state-of-the-art behavioral health unit. JFL received the release of funds for the $1 million from the Office of Management and Budget on April 21, 2015. From April 2015 to present, this funding remained untouched in JFL's restricted account. At this current juncture, the time and money spent on rebuilding the psychiatric unit in the current soon-to-be demolished JFL structure would be better spent on strategizing and finalizing the state-of-the-art behavioral health unit in the new JFL, which may be housed on this very plot of land if purchased. This reallocation of funding will provide enough to cover most of the purchase price. In addition, we are requesting for the reallocation of $400,000, and that is for monies that were allocated to JFL previously. Once we receive that entire funding, that will be enough to cover 100% of the negotiated purchase price for the land. Purpose of the land purchase. Our vision is that this land would allow for us to expedite the process of constructing the new permanent JFL hospital. There has been much knowledge gained in the building of JFL North. The first lesson we seek to apply is that every opportunity for JFL to be efficient and agile in constructing this facility must be taken. The land purchase provides JFL the opportunity to create a structure that would encompass the holistic healthcare needs of the community as a whole as soon as plausible. First, we start with the procurement process. If media could re-engage that slide that was on the screen. As you can see, the procurement process for a large-scale project is extensive. To provide an illustration of the timeline, we start by utilizing the procurement of the architectural and engineering firm for the permanent JFL hospital as an exemplar of some of the time that we anticipate that it will take to procure a construction company and commence the demolition and construction of the permanent JFL hospital. To date, the board has approved FLAD as the architectural and engineering design company for the permanent JFL hospital. This contract was just executed on February 10, 2021. Based on research and discussions with healthcare builders, including FLAD, the planning and design of the permanent JFL hospital will take 18 to 24 months. The demolition and the remediation of the current JFL hospital will also take about 18 months. On the slide, we have a timeline that would provide an idea of the timeline for the completion of the permanent JFL project. However, if we are able to utilize the land that we are discussing today, we will be able to begin building phase 1 of the new hospital project expeditiously. Next slide, please. Beyond the construction project, the additional land would provide JFL with the stability necessary to ensure that we have several patient care spaces that can accommodate the needs of patients if there is a compromise to the JFL building as a result of a natural disaster. For example, the landfall of 2 Category 5 hurricanes. Next slide, please. Particularly, the wind speed rating for JFL North is 175 miles per hour. Creating a space that can be utilized for patient care in the case of a hurricane rating that is close to or exceeds that amount would allow JFL to continue to serve the community in its capacity as the sole hospital on the island of St. Croix. Next slide, please. As we consider our diverse and aging population, the new hospital build project and the new medical campus would represent a vital investment that would serve as a viable economic engine for the island of St. Croix and further meet the existing and projected future demand for patient care. For JFL, that investment starts here and now with our legislature. In conclusion, the hospital facility that the people of St. Croix deserve must be able to accommodate advanced medical services, including but not limited to top-of-the-line imaging technology, telehealth, artificial intelligence, information technology, and specialties that were not previously available within the healthcare system in the territory. In this way, we can minimize transfers off island, minimize the risk of patient infection, which now includes COVID-19, enhance the comfort and healing of patients and the general welfare of our staff and our patients. Other wraparound services, such as a behavioral health specific emergency room, dialysis, outpatient diagnostic centers, and private physician offices will increase access to quality care and create an even greater positive economic impact to the community and the economy. I would like to thank Senator Gittens and Senator Violet for sponsoring this bill. I would also like to thank the members of this committee for taking the time to support the needs of JFL and the opportunity to provide this testimony today. I look forward to any questions that you may have. Thank you.
Thank you very much, Attorney Thomas, for your testimony. And at this time, we'll open up the floor for a 2-minute round. And we'll start with Alma Francis Heidegger. Senator Francis Heidegger, you're recognized for your 2 minutes.
Good afternoon again.
Good afternoon.
I hope everyone is doing well. As I was not a member of the 33rd, and this is the second time coming around, I have a couple of questions just for my understanding. I took the time out to pull up the two acts, 7012 and 7697, because I wanted to make sure exactly where the funding was coming from and to make sure it was not being taken for something it should be able to be utilized for. In speaking to the sponsor, they did share that as it relates to the $400,000, the funding will not be depleting the entire account, and there's funding still available for other things. And the $1 million is supposed to be reappropriated that we're attempting to do today does belong to this One Louis Hospital. But what I want to find out quickly is the 1.4 we're trying to appropriate the total cost of the property, inclusive of closing costs as well?
For the 1.4 million, that is inclusive of the cost of the property. My understanding is that there may be some additional closing costs that are not excessive, but that's essentially the cost of the property.
So you said deposit? So 1.4 is the deposit or the total cost minus or maybe some closing costs?
No, I said 1.4 million is the cost of the property.
Okay.
And it's not inclusive of closing costs.
Okay.
I hope that is clear.
So, well, see, the thing is, when you spoke just now, you cut out, so I couldn't fully hear the last part of what you said. Could you repeat it for me?
$1.4 million is the cost of the property.
And the second part in regards to closing is the part I didn't hear.
So that does not include some closing costs that will be borne by the hospital. For example, attorney's fees that would be utilized in attaining the property.
Okay, could you share with us how much those attorney's fees are?
I do not have the exact amount, but I would be happy to provide that to you. as soon as
would
I can get
appreciate
it from
it.
our board chair, Chairman Finch.
Thank you. Appreciate it. Quick question. Who are we purchasing this property from? And as it relates to the cost of the property, was there an assessment for comparables in the area to verify why this piece of property was valued at $1.4 million?
Absolutely. So there were actually a total of 4 appraisals that were done on the property. And there were comparables that were close to the property that were utilized to determine exactly what the value of the property is. One of those appraisals actually appraised the property at up to over $1.9 million at the highest.
Okay. Well, thank you. Before I close, I'm going to be in support of this. I have gotten the necessary information. You didn't respond as to who we're purchasing it from.
Yes, ma'am. My apologies. We're purchasing this from the Shabert and Schuster family.
Okay.
The person that is.
Okay. Thank you so much for the information.
Thank you very much, Senator Francis Heiliger. Senator Blyden, you recognize for your 2 minutes.
Thank you, Mr. Chair. I really don't need 2 minutes. I supported this legislation before, and I support it again. I understand the urgency, I understand the need, and definitely I do stand in support of this piece of legislation. I want to thank the sponsors for bringing it forward, and thank you so much for the time.
Thank you very much. Senator Blyden. Senator Saru, you recognize for your 2 minutes.
Thank you, Mr. Chair. I will vote in the affirmative at the appropriate time.
Thank you very much, Senator Saru. Senator Carrion, you recognize for your 2 minutes.
Thank you very much, Mr. Chair. Yeah, I just have a question. How many appraisals were conducted for the land in question?
Good afternoon. Thank you for your question. There was a total of 4 appraisals that were conducted for the land.
Thank you. That's it for now. I would likely also rise in support of this measure today, given the circumstances. However, I'm urging Virgin Islands Health Facility and Hospital Corporation to exercise due diligence prior to completing the purchase. And I'm in favor once it will help move forward the process. Thank you, Mr. Chair.
Thank you very much, Senator Carrion. I stand in support of this measure as well. It's obvious that we have outgrown the space currently at the Wang Lui Hospital. Anyone that goes there recently for any calls for service could tell that there's hardly any parking that's available there. The JFL North is a wonderful facility that we're looking forward to getting up and running in short order. Have taken up the parking for the Wang Lui employees, and certainly there's definitely a need for the land acquisition again for the rebuild of the JFL hospital. Funding is available, and certainly with that said, I will be supporting the reappropriation of the funding to be able to allow for this purchase. I believe that due diligence have already been done and will continue to be done, both by the appraisal, certainly by the staff of Wang Lui Hospital, as well as the board in terms of their oversight responsibility. So I'm satisfied that all of the due diligence have been done and will continue to be done. So thank you very much. I'll go back to the bill sponsor for his 2 minutes at this time. Senator Gittins, you recognize for your 2 minutes.
Thank you, Mr. Chair. Mr. Chair and colleagues, I just want to thank you for your support in this measure. I also want to thank the other sponsor, Senator Viale, who is unable to be here at this time but was excused. We did ask that the hospital get at least 3 appraisals, and as you've seen, they've done their due diligence and they got 4. After receiving all the appraisals, we're at this juncture, and again, it is exigent at this time because there's other people that's eyeing the property, just not the government. However, where this property is right adjacent to the existing hospital and is ideal. so we don't have to drive and go someplace else. Also, again, this will cut down the amount of change orders, etc., so that once the plans starts, they can do all their planning with the existing building into where the new hospital will be built. Once again, I want to thank all of you for supporting this and looking forward for the balance of the other senators to vote in support on session day. Thank you so much, colleagues.
Thank you very much, Senator Gittins. At this time, Attorney Thomas, I'll allow you to give your 30-second closing.
Good afternoon. First, we want to thank all of you for your overwhelming support of JFL and the future for healthcare in our community. The JFL team truly looks forward to these initiatives. We look forward to the completion of these new build projects as we continue to rebuild today for a healthier tomorrow. In the current JFL building, having the entire hospital under one roof has challenged the viability and stability of the organization in times of crisis. The ability for JFL to provide healthcare on the same medical campus but spread out allows the organization the ability to thrive when we are met with disasters, both natural and man-made. In addition to addressing the stability of JFL in times of crisis, we anticipate and we are working to project the growth of our healthcare industry, inclusive of new innovations and service modalities for the next 20 years and beyond. Thank you to you all for the opportunity to speak before you today, and happy Black History Month.
Thank you very much, Attorney Thomas. Happy Black History Month to you as well. I like your African gobs. At this time, Senator Gittins, you're recognized for your motion.
Thank you, Mr. Chairman. Mr. Chairman and colleagues, I move that Bill number 34-0017, an act making appropriations from the balance of funds appropriated in Act number 7697, Section 2, Paragraph 1, and $400,000 from the Community Facilities Trust account to the Virgin Islands Government Hospitals and Health Facilities Corporation for the acquisition of Plot number 7, Estate Diamond Ruby, St. Croix, Virgin Islands, for reconstruction and expansion of the Governor Juan Francisco Louis Hospital and Medical Center be voted upon favorably in this committee and be forwarded to the full body for further consideration. I so move.
Motion properly made by Senator Gittins, seconded by Senator Carrion, and Senator Searle, and by Senator Blyden. Roll call.
Senator Marvin A. Blyden. Senator Blyden, yea. Senator Samuel Carrion. Senator Carrion, yea. Senator Kenneth L. Gittins. Yes. Senator Gittins, yea. Senator Almus Francis Heiliger.
Yes.
Senator Francis Heiliger, yea. Senator Janelle K. Sarro. Senator Sarro, yea. Senator Kurt A. Vialet. Senator Vialet excused. Senator Norvell E. Francis Jr.
Yea.
Senator Francis Jr., yea. Mr. Chairman, 6 yeas, 1 excuse.
Thank you very much, Madam Clerk. Bill number 34-0017, an act making appropriations from the balance of the funds appropriated in Act number 7697, Section 2.1, and $400,000 from the Community Facilities Trust account to the Virgin Islands Government, Hospitals, and Health Facilities Corporation for the acquisition of Plot number 7, Estate Diamond Ruby, St. Croix, Virgin Islands, for the reconstruction and expansion of the Governor Juan F. Louis Hospital and Medical Center have been approved by this Committee of Health, Hospital, and Human Services that will be sent to the full body for further consideration. Thank you very much to the individuals, Attorney Thomas and CFO Moorhead, and colleagues. Thank you for today. Today was a good start to the discussion, and I appreciate the consideration in the amendments that will be considered as we move forward with the behavioral health. We have to create a system that serves our entire community This committee will convene on March 18 to continue vetting the amended bill and look forward to your continued input as we go forward. We also commend the bill sponsor and Bill 33-0017 that seeks to provide additional property and the build out for the Wong Louis Hospital in the acquisition of that land. I want to thank all of the testifiers and my colleagues for participation today. I want to thank the media, security, protocol, central staff, housekeeping, my staff, of course, testifiers, transportation, and everyone who made today's hearing a success. Have a great weekend. God bless. Take care. The Committee of Health, Hospital, and Human Services of February 26, 2021 is hereby adjourned.